Court officer.
Sir, one device off ಮಾಡ್ಬಿಡಿ sir. ಇಲ್ಲಿ ಬೇಡಪ್ಪ. ಮೇಡಮ್ ಇದೊಂದು ನಾನು ಲಾಸ್ಟ್ ವೀಕ್ ಮೂವ್ ಮಾಡಿದ್ದೆ ಬರ್ಲಿಲ್ಲ. ಮೇಡಮ್ ನಾಳೆಗೆ ಹೇಳಿದ್ದೆ.
5 ದಿವಸ ಮೇಲಾಗಿದೆ. 10ನೇ ತಾರೀಕಲ್ಲಿ ಬರ್ದಿದ್ದೀನಲ್ಲ ಅಲ್ಲಿ ನೋಡಿ, 10ನೇ ತಾರೀಕು ಹಾಕಿದ್ದೀನಿ, ಬರ್ದಿನಿ ಅದಕ್ಕೋಸ್ಕರ. ಹೌದು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ
ಸರ್ ಹೇಳಿ.
ನಾನು ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಸ್ಯಗಾರಲ್ಲಿ.
ಹೇಳಿ ಸರ್.
ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೇನೆ. ಮೊನ್ನೆ 13/4 ಇರೋದು 2 ಮ್ಯಾಟ್ರದಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದೇವೆ ಎಲ್ಲದ್ರಲ್ಲೂ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೆಟ್ ಅಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ನಂಬರು. ದಯವಿಟ್ಟು ನೋಟ್ ಮಾಡ್ಕೊಳ್ತೀರಾ
ಸರ್? ಯಾವತ್ತಿಂದದು?
13/4.
ಸರ್ 13/4 ಇನ್ನ ಟೈಪೇ ಆಗಿಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, ನೆಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ.
ನೆಟ್ ಅಲ್ಲಿ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗ್ಲಿಲ್ಲ, ಬರೀ ಜಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು ಮಾತ್ರ ಆಗಿದೆ. ಅದು ಡೇಟ್ ಕೊಡೋದು ಕೋರ್ಟ್ ಆಫೀಸರ್ಸ್. ಅವರು ಸಾಹೇಬ್ರು ಸೈನ್ ಆದ್ಮೇಲೆ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಸೈನ್ ಆಗುತ್ತೆ, ಅವಾಗ ನಿಮ್ಗೆ ಎಂಟ್ರಿ ಮಾಡಿರುತ್ತೆ. ಸಬ್ಮಿಷನ್ ಏನ್ ಮಾಡ್ಬೇಡಿ, ಹೇಳಿ ನಂಬರ್ ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ನಾ ಹೇಳ WP 16159 2021.
ಓಕೆ ಸರ್, ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಾದ್ರು ನೆನಪಿದ್ಯಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ನೆನಪಿದ್ಯಾ ಸರ್? ಅದು
ಸೀರಿಯಲ್ ನಂಬರ್
ಇರ್ಲಿ ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ನಂಬರ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು WP 1203 of 2022.
ಆಯ್ತು ಸರ್, ಎರಡರಲ್ಲೂ ನಾನು ಹೇಳ್ತೀನಿ. ಯೂಶುವಲ್ ಆಗಿ ಮಾಡ್ತಾರೆ, ಇನ್ನ ಟೈಪೇ ಆಗಿಲ್ಲ ಅದೆಲ್ಲ.
ನೆಟ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿದೆ, ಬರೇ ಪಾಸಿಟಿವ್ ಆರ್ಡರ್ನೇ ಮಾಡಿದ್ದಾರೆ. ಪಾಸಿಟಿವ್ ಟೈಮ್ ಲಿಸ್ಟ್ ಇಟ್ಟು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಲಿಲ್ಲ.
ಸರ್ ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ ಸರ್. ಅದು
ಹೌದಾ?
ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ, ಆಫ್ಟರ್ನೂನ್ ಹೇಳ್ತೀನಿ.
ದಯವಿಟ್ಟು ನಾನೀಗ ಸಬ್ಮಿಷನ್ ಮಾಡೋದು ಬೇಡವಾಗಿದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ,
ಹೇಳಿ ಸರ್. ಅದು
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 101 13/4.
ಮೊನ್ನೆ ಹೇಳಿದ್ದು 101. ಇನ್ನೊಂದು ಸರ್, ಇನ್ನೊಂದು ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರು?
ಅದು ಎಲ್ಲ ಅದು 3 ಮ್ಯಾಟ್ರ್ ಇತ್ತು. ಫಸ್ಟ್ ಮ್ಯಾಟ್ರದಲ್ಲಿ ಮಾತ್ರ ಎಂಟ್ರಿ ಮಾಡ್ರು ಇದ್ದಿಲ್ಲ ಮೊದಲು.
ಸರಿ ಸರ್.
ಈ 2 ಮ್ಯಾಟ್ರದಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಯಾವಾಗ್ಲೂ ಇದೆ.
ಸರಿ ಸರ್, ನಾನು ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ಲೋಡ್ ಆದ ಪ್ರಕಾರ ಹಾಕೇ ಇಲ್ಲ ಅದನ್ನ.
ನೋಡ್ತೀನಿ ಸರ್ ನಾನು.
ಪ್ಲೀಸ್ ನೋಡಿ. 16,159 up to 21 and 1203 of 22.
ಫೋಟೋ ಮೂವ್ ಮಾಡಿದೆ ಜಾಸ್ತಿ ಇದೆ.
ಮೆಮೊಸ್ ಇಸ್ಕೊಳ್ತೀರಾ ಟೆಸ್ಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಗುರುವಾರ ಕಂಪ್ಲೈ ಮಾಡ್ತೀನಿ.
Friday, court passed an order, on 12th, to pay the process fee by 13th. The order copy was uploaded on 15th. 15th immediately I paid the process. 1 day delay, I filed an application to condone the delay. File application. One matter, that violation matter, the last, the date today matter has not been posted. 144% violation. Report was called for.
Date ಕೊಟ್ಟಿದೆ
Date ಕೊಟ್ಟಿದ್ದೀರಿ ಇವತ್ತಿಗೆ ಇಲ್ಲ.
ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ಬರಲೇಬೇಕು.
The demand notice issued by the BBMP for fresh plan sanction.
There's no urgency there. It'll come up after.
As per BBMP are trying to evict us. Land was granted in the year 1960. And not following the due process and evicting us.
Case number 22, serial number 6758.
So on 16 matter, madam.
Some inconvenience
At the request of the council for the petitioner,
for respondent.
we list on 19 June.
Serial number 43, my lord. Serial number 43. 43, my lord. Serial number 43.
ಕರೆದಿಲ್ಲ.
Case number 23, serial number 69. Case number 24, serial number 7.
27 minutes.
Yes.
But this matter, probably the matter has become unnecessary. Weeks time may be given.
If it will become unnecessary, we will dismiss it today only.
I have
Yeah, Anajam.
responded to that matter.
Instructions because of reason we're not able to get in contact with the issue.
77 at the request of council for the petitioner released on 19 June.
28 Milad.
Yes.
28. Petitioner died. Necessary application.
Inform ಮಾಡಿದೀರಾ respondent. 78. That council for the petitioner submitted the petitioner. He seeks for 4 weeks time to bring the legal representative deceased petitioner on record. Released on 28th June.
Serial number 73, my lord. Shock.
79. Council for the petitioner. Have you informed the respondents? 79 at the request of council for the petitioner released on 28th. 73.
73, please, my lord.
Who are
Short
you?
accommodation, my lord. For the petitioner.
You inform the respondents?
I will be informing.
No.
I couldn't.
Please wait. Yes. Have you informed the respondents? Have you informed, yes or not? Little better. Please wait.
Number 88, Your Lordship, appearing on behalf
Cell number?
88,
88.
appearing on behalf of the respondent.
Yes.
Petition hasn't served the copy of the.
Have you,
I've informed I've called the petitioner and asked them to serve.
your petitioner is behind you.
Yes.
Copy coding.
I've informed.
88. B.S. Raghu Prasad has entered appeals for the petitioner, delete Y. Hari Prasad. Raghu Prasad undertakes to furnish copy of the petition along with annexures thereof by end of day tomorrow. Objections, if any, by 9th June, relist on 16th June.
Page number 27.
Serial number 94, madam.
Yes.
File ಮಾಡಿದೆ, respondent number 9 and 10 ಗೆ return ಆಗಿದೆ. Check ಮಾಡ್ತೀನಿ. ವಾಪಸ್ ಪರವಾಗಿಲ್ಲ ನಮಗೆ.
Have you,
Inform
is that a matter to be mentioned? ಅವ್ರು ಇದ್ದ ಹೋಗ್ತಾನೆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಮತ್ತೆ ನಂದು ವಕಾಲತ್ ರಿಟರ್ನ್ ಆಗಿದೆ.
ನೋಡೋಣ.
Serial number 91.
91.
Lawyer change ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಯಾರಪ್ಪ ಯಾರು ನೀವು?
Respondent.
Petitioner, respondent?
Respondent. Serial number 91.
ವೇಸ್ಟ್ ಮಾಡಿ ಅವ್ರು ಬರೋವರೆಗೂ.
Page number
Lawyer
20.
change ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಆಯ್ತು ವೇಟ್ ಮಾಡಿ, ಅದು ಕರೆಯೋವರೆಗೂ ವೇಟ್ ಮಾಡಿ.
Page number 27. Serial number 93 to 99. Page number 28. Serial number 100 to 106. Page number 23. 107 to 111. Page number 30. Serial number 112 to 18 to 120. Page number 32. Serial number 121 to 129.
28. 28.
Yes. 128 at the request of counsel for respond number 1 and 2, relist on 19th June. Interim order earlier granted is extended.
Your Lordship, serial number 126, I represent petitioner, Your Lordship. Other
For the
suggestion,
R2, my lord.
Carbon has not been occurred, pending postage after vacation.
I filed my wakalat, my lord, 15/4.
126 at the request of counsel for the petitioner, relist on 19/6.
Interim order can be.
Interim order.
Yes.
124. Have you informed the petitioner? Please don't mention
24,
1,
124,
122, 24. Yes, 124. New Year. New respondent. Wait for. You have informed. 124 at the request of counsel for respond number 1, relist on 19/6. ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರಲ್ಲ ಅವಾಗಲೇ ಅವ್ರ ಹತ್ರ ಕೇಳ್ಬೇಕು. ಕೇಳಿ.
Page number 33. Serial number 130 to 133.
My lord, one submission, my
Yes.
lord, serial number 41, my lord. I'm sorry, I missed this one.
You did not miss because it was not called out. Please wait.
Serial number 1. Mr. Dimber.
Your Lordship, I heard the petitioner in this matter. This matter is similar to serial number 2 and
That is why it's what.
property tax matter. On Thursday, I came to know of an amendment to the BBMP Act by way of which all educational institutions have been granted exemptions. I wish to place it on record.
What has happened, Mr. Pankam? All this have to go.
There is an amendment to the act.
The second matter.
Yes.
Along with several other matters. It was filed a memo before the court. Number will kindly received.
In which matter, Mr. Naik?
Point 16.
2.16. 16.
I'll give one more copy of that.
One copy.
More than the amendment, the memo sets out what is the prayer, what is the nature of release that seeking. Good.
Mohan, this is your memo.
39.2.4.
Mr. Naik is making a submission on his memo, not on your memo. Let us see his memo.
Prayers have been made in all these cases.
Then we'll have to clear the matter.
The next phase is not the amendment.
If you are saying that first prayer has got, is not required to be considered on account of the
The
amendment.
other prayers will not, because of the amendment,
Hmm.
will have to be allowed unless the other side says, no, it can't be granted.
Let's make a. Let's make one.
Mr. Prashant appears in our case. Let's the consequential prayer.
Whoever appears in whichever matter, the contention, the
The
submission
other
in the
prayers are
memo
consequential.
is since the amendment has happened to section 152, the first prayer of holding the section 152 to be discriminatory doesn't survive. It is no longer discriminatory. Consequently, to quash the circular issued by the BBMP notifying that private institutions do not have the benefit of exemption from payment of property tax and that the exemption is only extended to government institution. That also would not survive because your amendment says the education institution is established for the purpose of education recognized by the government or local authority. So if it is recognized by the government or local authority, they'll have to get the benefit. Therefore, consequently, last one of demand notice has to go. Clear?
One submission, my lord.
Naik?
My lord, 4565 is concerned, my lord. Copy has not served, my lord. Second matter is.
4565.
Please, my lord.
Serial number?
Serial number 2, my lord.
Serial number 2 point.
2 point, my lord. Point ಬರ್ತಾ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಬರ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಇಲ್ಲಿ ಬಹಳ ಇದಾವೆ ಹುಡುಕಕ್ಕಾಗಲ್ಲ.
It is our case, we undertake.
You will undertake to, why do you want to waste paper on it, Mr. Naik?
My lord, in respect of ಅದು ಗೊತ್ತೇ ಇಲ್ಲ ಏನಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಕೇಳಿದ್ ಸ್ವಾಮಿ.
All our education tax matters.
Please, my lord. In respect of my lord, local authorities concerned, my lord, the planning authorities.
One ನಿಮಿಷ. ಯಾರ್ ಲಿಸ್ಟ್ ನೀವೇ ಕೊಡೋದು ನಾವೇ ಆಡ್ ಮಾಡೋದು.
All our matters, lords, do not have any issues wrong.
Okay, let us go one by one then.
Yes.
There's a confusion.
Please, my lord.
Serial number 2, Mahesh AS. Ground rent. Ground rent either. Ground rent disconnect. Serial number 2.1. Vivekananda. Ground rent. 2.2. Education. 2.3, 2.4. 2.5. 6, 7. 8. 9. B. Pramod. 2.9 disconnect. 10. Ella BBMP ne. Ground rent education tax. 11.
Well, submission, my lord. On 6/3, there's a connected matter, my lord. On 8 August, this honorable court asked them to club all the matters. But 5 matters have been not clubbed, the same property.
Give the list, we'll list it again. 12, 13, 14, all your matters are encroachment.
Yes.
17,
Ground rent.
ground rent, disconnect.
In my matter, my lord, Sudhakir GV is the my lord petitioner advocate. My lord.
43. Sujay Naik. 43, connect and Adamel Baran, 43. 44,
Ground rent, my lord.
45,
Ground rent.
46,
Ground rent.
48,
Ground rent.
49,
Lord, one submission.
Allah, ground rent alla we are deleting from this. We'll
Because
list
my
it.
lord, ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ 18 ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. That has been pending before this honorable court, my lord. That is the reason, my lord.
Mr. Naik, we are only disposing all the education matters.
Please,
Ground rent, we'll have to take it up again.
please.
Exclusively ground rent or they plan sanction demand? They'll have to be considered. All interim orders is that. 50 ground rent, 51. Adananda,
Yogesh Naik.
Please, my lord.
idu ground rent answer Adananda. Narayan Swami PM, 52. 53. 54. Akash Kumar Gowda. Kumar tax. So this much. Okay, this one would be tax and
Education.
55 is ground rent. BBMP antide. 56 LB tax. That is education.
Education.
57, 58, 59.
Ground rent. 58 ground rent.
64 orgo ground rent answer ella BMP. And 65 to 71.
68 and 69 are ground rent.
Around 57, 53 ಹೇಳೋದಲ್ಲ 53, 55. 57 to 71. E-link. Ground rent ಯಾವತ್ತಿದೆ? ಈ list on 26.
My lord, in 50.1, a similar ground rent matter is there.
We'll see that when it comes. So these ground rents will all get listed on 26. Rest of the matters. 57 to 71. ಬಾಕಿ ಎಲ್ಲ ಏನಿದಾವೆ ಬಾಕಿಯಲ್ಲಿ single order, common order.
Petition number 1 may also be taxed.
Yes. 2.43. Registry is direct to correct the name of the council appearing to the petitioner as Suraj Naik, including in all the above matters. A declaration has been sought for. That section 152, 1(1)(b), small b, of the BBMP Act 2020, insofar as it excludes education purposes by private education institutions, is violative of Article 14 and is discriminatory. It is in that background that a circular which has been issued under section 152(1)(1)(b) by the BBMP notifying that private institutions do not have the benefit of exemption from payment of property fines has been challenged. Consequently, the demand notice issued by the BBMP calling upon the petitioners to make payment of property tax is also challenged. Correct. During the pendency of the above matter, the state government has amended section 152(1)(1)(b) on 10/3/2023 substituting section 152(1)(1)(b) with the following. The education institutions established for the purpose of education, recognized by the government or local authority. In view of the said, the alleged discrimination in view of the said amendment, the discrimination alleged by the petitioner of private educational institutions vis-a-vis government education institutions does not survive, inasmuch as all education institutions which have been recognized by government or local authority would be entitled for exemption. Thus, the declaration which has been sought for in the above matters in respect of section 152(1)(1)(b) as being violative of Article 15 does not survive for consideration. In view of the amendment, the circular which has been issued on 29/3/2021 notifying that private institutions do not have the benefit of exemption would be required to be quashed on account of section 152(1)(1)(b) and been amended by clarifying that any institution which is recognized by the government or local authority would be entitled for exemption. The consequential prayer seeking for quashing the demand notice dated 14/2/2022, which has been issued in further the circular dated 29/3/2021, would also.
The date which your lordship are mentioning. may vary.
Demand notice will vary from.
Yes.
Consequential demand notices issued
Based on the circular.
to the petitioners based on the circular dated 29/21 would also have to be quashed in view of the circular having been quashed. With the above observations, the above petitions stand disposed.
There were interim orders directing us to pay the.
No, 25%.
25% of.
Property tax we have paid.
Adjusted.
Will be adjusted to future.
Yes, that can be done.
In many of the above matters, interim orders have been granted directing the petitioners to make payment of an amount equivalent to 25% of the demand
The demand.
made, which has been so deposited by the petitioners. Wherever such deposit has been made, the deposited amount is directed to be adjusted to future tax payments due by the petitioner on the said properties.
If any.
It is
ಶ್ರೀನಿಧಿ ಅಂತ ಇದೆ, ಪವನ್ ಕುಮಾರ್ ಅಂತ ಮಾಡಿ.
ಈ ಶ್ರೀನಿಧಿ ಅಂತ ಎಲ್ಲೆಲ್ಲಿದೆಯಾ ಪವನ್ ಕುಮಾರ್ ಇಲ್ಲಿ ಪವನ್ ಕುಮಾರ್ ಎಕ್ಸೆಪ್ಟ್ ಎಲ್ಲ ಹೇಳ್ಬೇಕಾ ಎಲ್ಲ ಮ್ಯಾಟ್ರಲ್ಲಿ ಏನೇನೋ ಇದಾವೆ.
Some cases Prashant Singh.
ಈ ಶ್ರೀನಿಧಿ ಪವನ್ ಇಲ್ಲ ಯಾರ್ಯಾರು ಹಾಕಿದಾರಮ್ಮ. Ashwin Aladi is filed, Rakshita DJ is filed. Illi file madillo. Alli Pawan Kumar.
Copies should be directed to the petitioner to serve the copy.
Alli released on 2/6, copies to be furnished to the respective respondent.
Please, my lord, please.
Some of the cases, Srinidhi's name is shown.
That is why we are directing Pawan Kumar. In some of them, somebody has filed our Kalatnama. In some of them, the Srinidhi's name is still there, that Pawan Kumar.
Orders. Serial number 3, 33.
Ms. Joshi.
Full report by the NLS, directly NLS.
ನಿಮ್ಮ ಪ್ರಕಾರ ಇವಾಗ ಕವರ್ ಆಗತ್ತಾ?
Yes, comply, including every details have been.
As long as your officers know what is to be done.
Yes, yes. procedure to be followed at the time of storm. Prior to that, Maser, compliance of by the officer during the course of the proceedings, general guiding points, preparing the maps and rough sketch, investigation, permission. This time, in fact, I personally went and met.
This will avoid embarrassment for you when you appear. Him after ring ಮಾಡಿದ್ರೆ ಅಂತ ನಿಮ್ಗೆ
Nothing. We are much obliged because of the.
So now you will have refresher training courses once in
3 months, because all over state they have to come. Once in 3 months.
a refresher.
Refresher.
You 3 months ಗೆ ಒಬ್ಬ ಎಲ್ಲಾರ್ದು ಕವರ್ ಮಾಡ್ತೀರಾ. ಅದಾದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಟೈಮ್ ರಿಫ್ರೆಶರ್ ಯಾವಾಗ ಬರುತ್ತೆ?
Refresher every 3 months ಅಂತ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
ಎಲ್ಲರಿಗೂ every 3 months.
ಅಲ್ಲ, batch wise.
Correct.
Batch wise.
So ಇವಾಗ 10 ಜನ ಸಪೋಸ್ ಇವತ್ತಾಯ್ತು.
Yes.
ನೆಕ್ಸ್ಟ್ ರಿಫ್ರೆಶರ್ ಕೋರ್ಸ್ ಯಾವಾಗ ಆಗುತ್ತೆ?
So ಅವ್ರಿಗೆ ಮತ್ತೆ once again 6 months. Means ಇವತ್ತು ನನಗೆ ಆಯ್ತು ಅಂತಂದ್ರೆ ನನಗೆ 6 months.
6 months.
6 months. Because refreshing. ಅದನ್ನ ಮಾಡ್ತಾರೆ.
A memo has been filed by the council for
Respondents. Only one respondent.
By Shri Gururaj Joshi, council for respondent. Enclosing therewith a report prepared by the National Law School of Andhra University in association with Center for Environmental Law, Education, Research and Advocacy and the Pollution Control Board, Karnataka State Pollution Control Board, on inverted commas prosecution of offences relating to pollution control, inverted commas closed. The said report has been filed in compliance with the earlier order passed by this court on 2/9/2022.
2nd September 2022, man.
Earlier, another report had been filed on
Earlier, all earlier reports. This is the final report.
in part compliances, earlier reports had been filed. The respondent is directed to web host all these reports on its website, has also furnished soft copies of these reports to all.
Even the website, it has been uploaded in that.
ಹೀಗೆ ಬಿಡಕ್ಕಾಗಲ್ವೇ?
Yes. ಇಲ್ಲ ಅವ್ರು ಮರ್ತಿದ್ರು ಮತ್ತೆ ನಾವು ಹೇಳಿದೆ. It has to be uploaded in a website. It is to be available for each and every public.
Soft copies to be available to all the officers.
And for public.
Website al right public.
Public.
Soft copies to be
to all the officers.
Furnished to all the officers of the respondent. This court places its appreciation to the National Law School of India University, as also the Center for Environmental Law, Education, Research and Advocacy, having prepared such an exhaustive report. The submission of Shri Gururaj Joshi, Learned Counsel for Respondent, that refresher course will be held for all the officers at every 6 months. 6-month interval is placed on record. In view of the reports filed, no further compliance is required to be made. The proceedings are closed.
Much. Weeks time again to complete the office.
Each time under vacation. Counsel for the petitioner submit that the petitioner is in the process of compliance. Seeks to and is granted 3 weeks time to report further compliance. Released on 29th May at 2:30 p.m.
Number 5, Prakash.
R5. R5.
Respondent number 4.
5 service ತಗೊಂಡ್ಬೇಕು, or 3 legal aids.
File ಮಾಡ್ತೀವಿ. Week time.
5. And counsel for the petitioner seeks for and is granted 2 weeks time to do the needful released on 19th June.
With respect to R5, R1 and at 100% to give the residential address, my lord.
I could not,
R1 Vaishali Agri. Address of respond number 5. You're undertaking to furnish.
my lordship have directed BBMP to me to give the address. I could not get certain till and letters. Petition basis working in BBMP.
He was earlier working with the.
As per the cost title they have mentioned.
He's no longer working with you.
I could not ascertain because I have written letters, but I could not get any answer. Kindly have it the next week.
The Pawan Kumar submit that he has been unable to secure the address of respond number 5 and furnish it to the petitioner. He seeks for 2 weeks time to release on 26/5. R3.
Private party.
Petitioner ಬರ್ತಾ ಇದೆ. None appears for the council today. 4 weeks time is granted to do the needful released on 19/6.
Serial number 8. PM Narayan from
Yes.
So the 7th respondent.
File memo, man. It's a not person. A file memo, man. 13/4 to the. It's a not person. There was a compromise petition filed, my lord. I have filed my objections to the.
Oh, this is that matter.
So post my objections to the compromise petition, they are coming up with a memo for withdrawal of the writ petition. Like at second floor, 5 lakhs, man. I amount was withdrawn, this is not.
So you wanted to compromise behind their back. Now you are withdrawing. Why should we not impose costs on? Where have you deposited this money?
The registered general High Court of Karnataka, madam. In favor of 10 crores.
Counsel for the petitioner has filed a memo seeking for dismissal about the above writ petition is not pressed and for order of refund of the amount deposited with this court. On an earlier occasion, on the basis of a submission made that there was a compromise entered into and respond number 6A to C and 7 had no objection to the said compromise, they were deleted from the array of parties. Subsequently, respond number 6A to C and 7 objected to their deletion, saying that they had never consented to the compromise and that a wrong submission had been made before this court. It is in that background that the petitioner was asked to explain instead of explaining, a memo has been filed seeking for withdrawal of the above matter as not pressed and for refund of the deposit. I am of the considered opinion that the manner in which the proceedings have been conducted by the petitioner is a gross abuse of the process of this court, and therefore costs would have to be imposed. As such, I pass the following order. Accepting the memo, the petition is dismissed. The amount in deposit is directed to be refunded to the petitioner.
My lord's humble submission. My lord's, what has been suppressed. In fact, my lords, I filed my no objection wakalat also, which is yet to be put up. That apart, my lords, I have filed an application for recall of order dated 1/3/2023. Since even I have been deleted, my lords, I have for respond number 6A to C.
Anyway, the petition itself is going.
No, I understand, my lords. Here, there is also another suit, my lords, which has been pending, which is also suppressed, my lords. Wherein
That is why we are imposing costs.
much obliged, my lords. Much obliged.
Taking into account the nature of the thing. Cost of rupees 1 lakh to be paid to the Karnataka State Legal Service Authority. It is made clear that only after the costs are paid, the amount in deposit would be refunded to the petitioner. The cost to be paid within a period of 3 weeks from today, and the refund to be made within a period of 3 weeks thereafter.
Council for R6A2C filed memo for return. Number 9.
Therefore, the petitioner made the application, some small correction is there. Respondent number 6, instead of
Copy not so.
I made the application.
Copy kottidira?
La copy, sir.
Registry has raised the objection on IA 1 of 23 that the copy has not been served on the council for respondent. Sikidya?
Amendment copy.
Four filed, sir.
AGA and Ms. Soumya ji. Soumya ji, one copy. Copies have been furnished today, hence office objection does not survive consideration. The council IA 1 of 23 has been filed to correct the designation of respondent number 6. Council for the petition submit that the designation as mentioned was due to inadvertence. Accepting the said submission, since the amendment does not change the nature of the proceedings or alter the cause of action, the said amendment is allowed. Council to carry out necessary amendment and file amended fast action within a period of 15 days from today. This was to be allowed, very reason in that it was so we are allowing it because that allow madakagilla. We'll allow it. So what is the manual? Main. The petitioner is before this court seeking for the following reason. The petitioner submit that the petitioner is the own property or in that Janjar number 136, I think it's number 149. Where is property situated, Mr. Agarsh? Very Janjar assessment number kottidira. Property details kottilla. Ellide ee property?
Property is in Unsur Taluk. It's stated in petition.
Ellide?
Actually,
Next,
Ellu
child deed is there. After child deeds. Annexure C is the sketch. D is the
Unsur Taluk.
input. Jobs gere Unsur Taluk.
The grievance of the petitioner is that while issuing form number 9, 11A Kata, the extent of the land was reduced. Appeal has been filed
Before the Taluk concern.
to respond number 5 to rectify the defect. Same was not considered. It is at this juncture that Respond number 6 issued a eviction notice. The grievance of the petitioner is that without considering the appeal, the petitioner is sought to be evicted. In that order, I pass the following order.
Appeal, execute officer appeal ಇಲ್ಲ.
Appeal ilva?
ನೋಡಿ ಅದು ಏನೋ ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ appeal ಅಲ್ಲ.
Appeal file ಆಗಿಲ್ವಾ?
ಇಲ್ಲ appeal ಫೈಲ್ ಮಾಡಿಲ್ಲ.
Only a representation.
ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
Next to read, page 38.
The appeal and
ಇಲ್ಲ ಅವ್ರು ಹೇಳೋದಷ್ಟೇ.
made the submission appeal to appeal to the
ಅಲ್ಲ, ಕೋರಿ
authorities.
ಅರ್ಜಿ representation ಅಂತ.
appeal file ಮಾಡ್ಬೇಕಲ್ಲ Mr. Andrew?
Appeal ಅಂತ ಅವರು layman ಅವರು made the application, it is to be
ನೀವು
considered.
ಇದ್ದವಾಗ ಲೇಮನ್ ಅಂತ ಹೆಂಗ್ ಹೇಳೋದು?
ನಾವು ಅಲ್ಲಿ ತಾಲೂಕಪ್ಪ
ನೀವು ಇದ್ದವಾಗ ಲೇಮನ್ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ನಾವಿಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತೀವಿ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅಡ್ವೈಸ್ ಮಾಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
ಬಂದಿಲ್ಲ, ಮೊದಲು ಕೊಟ್ಟಿದ್ದಾರೆ ರೆಪ್ರೆಸೆಂಟೇಷನ್, ರೆಡ್ಯೂಸ್ ಇಟ್.
ಅದನ್ನ ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ಇವರು
ಅಪೀಲ್ ಇಲ್ಲ, ಪ್ರಾವಿಷನ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ರೆಡ್ಯೂಸ್ ಅದಕ್ಕೆ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು
ಅಪೀಲ್ ಇಲ್ವಾ?
ಅಪೀಲ್ ಇಲ್ಲ.
ವಾಟ್ ಇಸ್ ದ ರೆಮಿಡಿ?
ಎಪ್ಪಿ ಮೇಲೆ ಎನಿ ಡಿಫೆಕ್ಟ್ ಇಸ್ ಈ ಕ್ಯಾನ್ ಅಪ್ರೋಚ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ರೆಕ್ಟಿಫೈ ಡಿಫೆಕ್ಟ್. ಅವ್ರು ಬೇಕಾದ್ರೆ ರೆಕ್ಟಿಫೈ ಮಾಡ್ತಾರೆ. ಅದು ಮಾತ್ರ ಇವ್ರದ್ದು ಬೇರೆ ಗ್ರೀವೆನ್ಸ್. ಫಸ್ಟ್ ಟೈಮ್ ಗ್ರೀವೆನ್ಸ್ ಆ ಎಪಿಲ್ ಬಗ್ಗೆ ಅಲ್ಲ, ಇವ್ರ ಗ್ರೀವೆನ್ಸ್
ಎಕ್ಸ್ಟೆಂಟ್ ರೆಡ್ಯೂಸ್ ಆಗಿದೆ.
ಎಕ್ಸ್ಟೆಂಟ್
ಅಲ್ಲ, ಅದು ರೆಡ್ಯೂಸ್ ಆಗಿ ಅಲ್ಲ, ದಿಸ್ ಗ್ರೀವೆನ್ಸ್
that is why my 15/11/2000
first player may kindly look at it.
What is the remedy now for it?
ಅವ್ರದೆಲ್ಲ ಹೊಡೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವ್ರ ಎಲ್ಲೂ ಎಲ್ಲ ಎವಿಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ನಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಏನೇನೋ ಇದೆ, ಎಲ್ಲ ಪ್ರೇಯರ್ಗಳು ಇದೆ. ಅದು ದಟ್ ಇಸ್ ವೈ ಇಟ್ ವಿಲ್ ಟೇಕ್ ಮನ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
The area is reduced.
According to him, it is reduced. No, it depends a lot. It depends upon
It
this.
may be a right claim, it may be a wrong claim. Somebody has to decide it. Who will have to decide it?
He has to approve the Gram Panchayat itself. If there is mistake is there in issue, it is rectified. Then he can file an appeal if any order is filed. Resolution. Because in any appeal, any appeal can be filed only against the resolution of Gram Panchayat.
taking the assistance of Tahsildar and all that. You have made the BDO also the representation.
Experience ಅವರೆಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಎವಿಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರು, ನಮ್ದು ರಿಮೂವ್ ಮಾಡ್ಬಿಟ್ರು.
ಹೌದು,
ಎಲ್ಲ ಹಂತದಲ್ಲಿ we can't go into.
Photographs ಎಲ್ಲ ಹಾಕಿದ್ವಿ, but without illegally they have.
If there is a reduction in the area and they have given a representation, they have given a representation, PDO ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ, ತಹಸೀಲ್ದಾರ್ಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
And thereafterwards he was.
ಹೇಳ್ತಾರೆ ಪಂಚಾಯತ್ has to.
Our allegations against the executive officer itself, ಅವರೆಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಡಿಮಾಲಿಷ್ ಮಾಡಿದ್ದಾರೆ ಕರ್ಕೊಂಡು
Allegation ಇದೆ, representation ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ, ಕನ್ಸಿಡರ್ ಮಾಡದೆ ಯು ಎಂಟರ್ಡ್ ದ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಅವ್ರ ಅಲಿಗೇಷನ್. ಕನ್ಸಿಡರ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
ಇಲ್ಲ, now the question is, who has to consider? He has given representation deputy commissioner. He has given.
No, not only deputy commissioner.
First claim again.
Somyaji, who has to consider who will have the power?
It depends upon. It depends upon his prayer.
His prayer is to rectify the extent.
Yes.
Who is to consider?
Then he has to approach the Gram Panchayat itself.
Gram Panchayat, he has given a representation. He has given a representation to deputy commissioner. He has given a representation to the Tahsildar.
Deputy commissioner in ಬೇರೆ ಕಡೆ ಅವರೆಲ್ಲ ಬಂದು ಹೊಡೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ನಮ್ ತೆಗೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದು ಗ್ರೀವೆನ್ಸ್ ಅವ್ರು, ಅವ್ರು ಇದಲ್ಲ, ಅಲ್ಲಿಯ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಬೇರೆ. That representation kind of different.
That is why 15/11/2022 order may kindly look at whether Karnataka AGA submits that no such information is highly available. She would seek instruction to this matter and make submission on next date of hearing. Till today, they have not secured the information from competent authority. Why they have removed? And what is the extent of the government?
ಆರ್ಮಿಯಿಂದ ಕಳಿಸ್ಬಿಟ್ಟು ಇವರೆಲ್ಲ
Army, he is working in army.
Okay, it is not.
And he is
Yes, we can take an application. You file on it.
CPC provides for it. CPC provides for service to him through his commanding officer and representation to his commanding officer.
ಅವರ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಹೊಡೆದಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅದು that cannot be gone into. Extent I can understand different.
That is why we are saying when he is not even there and he is serving in the army.
ಹೌದು ಹೌದು, ಎಲಿಗೇಷನ್ against the ಇವ್ರ ಮೇಲೆ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಮೇಲೆ
So ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು?
ಅದು ಓನ್ಲಿ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕನ್ಸಿಡರ್.
ನೀವು ಒಂದ್ಸತಿ PDO ಅಂತೀರಾ ಒಂದ್ಸತಿ
ಅದಕ್ಕಲ್ಲ
extent-
it depends
what is-
upon the prayer, man. That is what I said.
What is the
Only extent ಗಾದ್ರೆ he has to approve ಗ್ರಾಮ ಪಂಚಾಯತ್.
Gram Panchayat?
But his allegation is ನಾವು ಇಲ್ಲದಾಗೆಲ್ಲ ಹೊಡೆದಾಕ್ಬಿಟ್ರು ಎಲ್ಲ ಇದ್ ಮಾಡಿದ್ರು ರಿಮೂವ್ ಮಾಡಿದ್ರು
ಅಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು?
ಅದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
ಡೆಪ್ಟಿ ಕಮಿಷನರ್
ಹೌದು.
ಎಕ್ಸ್ಟೆಂಟ್.
If there is
ಅಲ್ಲ ಎಕ್ಸ್ಟೆಂಟ್ ಅಲ್ಲ ಇದು
encroachment of the government property, we will
ಹೌದು.
look into it. The extent in the respect to sale deed, that has to be considered with the Gram Panchayat.
His allegation is what has been granted to him. The extent which has been shown in the Khata is contrary to the grant.
Grant purchase.
Purchase.
Sale deed.
that is his only grievance ಮೇಲೆ the ಗ್ರಾಮ ಪಂಚಾಯತ್
ನೋಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ತಾನೇ ಆಕ್ಷನ್ ತಗೊಳ್ಬೇಕು.
ಅಲ್ಲ ಅದಕ್ಕೆ ಬಟ್ ಇನ್ನು ಇದು ಎಲಿಗೇಷನ್ ನಮ್ ಜಾಗ ಎಲ್ಲ ಹೊಡೆದಾಕ್ಬಿಟ್ರು ತೆಂಗಿನ ಮರ ತೆಗೆದು ಮಿಲಿಟರಿನೆಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಎಲ್ಲ ಅನ್ಯಾಯ ಮಾಡಿದ್ರು.
ನೀವು ಲಾಸ್ಟ್ ಸ್ಟೇಜ್ ಹೋಗ್ತಾ ಇದೀರಾ. ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ನಾನು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೆ ಕರೆಕ್ಷನ್ಗೆ ವಿತೌಟ್ ಕನ್ಸಿಡರಿಂಗ್ ಇಟ್ ಬಂದ್ಬಿಟ್ಟು ಹೊಡೆದಾಕಿದ್ದಾರೆ ಅಂತ.
ಇಲ್ಲ ಅದಲ್ಲ, ದಟ್ ಇಸ್ ನಾಟ್ ಇಸ್ ಗ್ರೀವೆನ್ಸ್. ಅದಕ್ಕೆ ದಟ್ ಇಸ್ ವಿ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್. ವಿ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್.
We will file a report.
We file a report, will to maintain status quo.
Please.
HP and resource. So, are granted 3 weeks time to file their respective statement of objection and report as regards the extent of the property. In the meanwhile, the respondents are restrained from interfering with the possession of the property of the petitioner. Relist on 5th June.
Please.
Status quo as on today.
Disposal. Then allowed.
Status quo as on today.
Status quo as on. Who has entered appearance for respond number 2, accepts notice for respond number 3 also. Not so. None appears for the petitioner nor as a copy of the petition along with annexure being served on Shri Puttegowda. If none were to appear for the petitioner on next date of hearing, the petition would be dismissed for non-prosecution. Relist on 6th June.
Number 11. Copy not
Town Panchayat Tumkuru ನೀವು appear ಆಗ್ತೀರಾ ಮಿಸ್ ಮಂಜುನಾಥ್? Town Panchayat.
Town Panchayat.
Appear ಆಗ್ತೀರಾ?
ಇವರು ನಾಗರಾಜಪ್ಪ ಇರ್ತಾರೆ. Town Panchayat.
A. Nagarajappa is there to take notice for respond number 3. Counsel for respond number 2 has served copy of IA 1 of 2022. Counsel for the petitioner.
ತುರುವೇಕೆರೆ not ತುಮಕೂರು.
Turuvaikere, Tumkuru. Taluk to Tumkuru district. Relist on 1st June. Interim order list. Yes.
Serial number 12, I am for the respondent number 4, Lordship, including applicant. I have to comply office objection pertains to IA number 1 of 21, Lordship.
In office of copy ಬಂದಿದೆಯಾ?
Any ಬಂದಿದೆ.
Counsel for proposed response seeks and is granted 2 weeks time to comply with relist 16/6.
Much obliged.
15 minute I appear for the petitioner.
Yes.
We have filed an application for additional grounds. The office objection was about service. I'm told service has been made on the other side.
So respondent number 3, I have not received copies of this application.
You one more.
Sinchana MR has entered appearance for respond 1 and 2. Delete V. Srinavi as that appearing for respond 1 and 2. You have not received what?
I have not received copies of some application that they have filed now. my lords.
Additional grounds.
Email is.
I'm told it's been sent on mail. We can give another copy if they want.
You are appearing in 13.
Yes, my lord. I appear in 13 for the petitioner. It's my application for additional grounds. I want to raise 2 or 3 grounds. That's all there is.
Now copy is not there.
I'm told it's sent by email, but we'll give another copy, my lord. I don't want to stand on a formality.
The counsel for Counsel for
I'll check one more section.
Counsel for the petitioner undertakes to furnish copy of IA 1 of 23 to the counsels for the respondents. Relist on 9/6.
Legible copy of annexes.
Some of the comply ಮಾಡಿ.
Great.
Please.
Figure number 14. Says Sudhindra.
Yogeshwari has entered up. Not filed wakalat. Entered appearance for petitioner. Delete Siddharth, Sudhindra S.A. and Ramanya V. as that appearing for the petitioner. What is? Who is appearing now? Sudhindra. S.A. has entered appearance. Delete Ramanya V. and Yogeshwari. Yeah, 1 of 22 and rectification.
For that copy has not been served, Your Honor. Despite there is a service direction from this honorable court, they are not served the copy, madam.
14. Counsel for the petitioner undertakes to furnish copy of IA 1 of 22 and the counsel for respond number 4 by end of day tomorrow. Relist on 5th June.
Figure number 16. Hello,
Appearing for article. Appearing for us.
Yes.
Into the law.
Counsel for respond number 2 has filed a memo along with certain documents. His name is taken on record. Counsel for the petitioner seeks for and is granted 2 weeks time to go through the same and make a submission. Relist on 12/6.
Figure number 16.
R4, your lordship has directed notice to. But I was also granted liberty to serve by hand. Not able to serve physically and file an affidavit.
What is 16.1?
Not that, the petitioner in 16.1 had filed an IA in this petition seeking to come on record as a petition. He will do that with liberty to file a writ petition.
The notice has not been served on.
I don't know.
16.1. N.R. Jagdishwara accepts notice for respond number 1 to 3. 16. Issue notice to respond number 4 to 7, returnable by 12/6.
One submission.
Discuss the
The lordships may not by an earlier order.
In 16, is it?
Yes, Lord, 16.
16.
Dispatched on 5th April. Yes. 5th April.
15. Yes.
Dated 16, sorry, I'm sorry. Dated 29/10. 22. And directed a general inspection of this entire apartment complex to be carried out and a report to be filed. Now they have carried out, right, an affidavit recently. I'll file my reply to that formally. But in the meantime, they are issuing notices unilaterally. And already let them just go and write action. Not saying action, I will just point out.
Because my lord, it made a submission. Insofar the other 2 blocks is concerned, there is a deviation, there is another concern. And this court are directed to file a report. And after noticing the deviation, my lordship, we are intended to take actions. As again, in respect of other 2 portions as concerned. There are 3 blocks in the particular property, my lordship.
See, the subsequent construction.
What happened to the interim order in the civil court?
That has been, the plate has been rejected. After it was pointed out.
Yes, interim order was accepted.
Finally, in some matter.
Yes. Now we have to take action against the deviator. So issuing PO notice.
To reply to that notice. And 248 notice is it?
Yes.
But if the petitioner only, we have taken action because he made a for this court, there are other deviations as per other 2 blocks is concerned. Therefore, this is for directed me to take action.
So entire complex.
Entire block, B and C.
Petitioner 1
a very limited clearance, which in 2022, your lordships directed that action be taken for the illegal construction, which is investment for which already done. Then generally, for the remaining area of the complex also, an inspection was directed to be done. Now they filed an affidavit saying the entire C block, which petitioner number 2 is constructing, is unauthorized. Their own annexure R2 says that a modified plan is issued thanks to C block. It is still under construction.
You reply to them.
I am only
Reply to them. Until you reply, they can't take any action. You can reply, they can pass an order, you are 256, then you have KAT, everything is there.
I didn't want this order to be passed.
17, Ajit Kalyar.
Serial number 17 appear for respond number 2, my lord.
Yes.
The office objections have been complained, my lord. The only objection might be with regarding the typed copy of the
Serial number 17 appear for respond number 2. I not received prior remarks, my lord. I have to file objections.
Yes.
has been served on 3/11/2022.
3/11?
22, given an acknowledgement.
From when are you waiting for your paravise comment, Mr. Counsel?
I will receive. I have to receive from
When were you served?
for 4 weeks, maybe. Because election time.
Election time, in November 22 service agide namge. Are you waiting for paravise comments for last 4 months?
Yes, my lord. Yes, my lord. I can file within 4 weeks, my lord.
Please keep your officer present on the next date.
No, no need, my lord. I can file. No problem.
Nimag no need, namag need ide.
Less ಯಾಕಂದ್ರೆ ನನಗೆ ಮಾರ್ಟಿನ ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ ಇವತ್ತು ರಿಮೈಂಡ್ ಮಾಡ್ತೀನಿ ಒಂದು 15 ದಿನದಲ್ಲಿ ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸರ್.
Delete the name of government as that are paying for respond number 3. Counsel for respond number 2 submits that he is still awaiting paravise comments and therefore he seeks for accommodation to file his objection. The Ajit Kalyan submit that service of the petition was effected on
3/11/2020.
3/11/2022. It's rather shocking that paravise comments have not been received by a council of the BBMP for last nearly 5 months. That is not a ground for an adjournment. However, in the interest of justice, BBMP. KHB. No. ಅದು ಕೊಡೋದೇ ಇಲ್ಲ. ಒಂದರಲ್ಲೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ KHB. Later justice, 3 weeks time is granted to file objection. If objections are not filed by 25th, the legal officer of respond number 2 shall be personally present before this court on 30th May 2026.
This case personally already must to the respondent number 3 to 12 malad, except respondent number 3 malad. All others should be sanctioned.
What total file?
Process fee ಕೊಟ್ಟಿದ್ದೀರಾ?
Process ಕೊಟ್ಟಿದ್ದೀವಿ personal ಆಗಿ
ಚೆನ್ನಾಗಿದೆ process.
What total ಗೆ?
filing work.
You are filing okay.
What total?
2 ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? See, Allah, officers in individual name. Actually,
because making allegation against each of them, malad. ಅವರು ಕೆಲಸ ಮಾಡಿರೋದೇ ದುರುಪಯೋಗ ಆಗಿರೋದು. Therefore, malad, all of them jointly.
Shri MS Devraj, who has entered appearance for respond number 2, also undertakes to file Vakaratnama for respond number 3 to 12. What about 13? Ombudsman required. Not required.
13 ombudsman.
Notice to respond number 13 is dispensed.
What is not 13?
Expense. 13. You'll enter up.
ಏನಂದ್ರೆ ಯಾಕೆ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ
Notice not on.
ಫೈಲ್ ಮಾಡಲ್ಲ.
The BJ Somaji undertakes to appear for respond number 13. Registry is direct to print his name as such.
Number 3 is concerned.
Respond number 3 concerned Melody is refused to receive the.
ಅವ್ರಿಗೆ ಸರ್ವಾಗಿಲ್ಲ.
ಅಲ್ಲ, ಅವರು is refused to receive the summons.
ನೀವು appear ಆಗಿ ಎಲ್ಲಾರ್ಗು. ನಿಮ್ಮ officers. We list on 5-6.
Malads, in serial number 19, Malads, I beg to appear for the respondent number 4, Malads.
The BV Muralidhar has entered appearance for 1, 2, 3. Delete name of Shri K.N. Pegowda. Does that appearing for 1, 2, 3? Who appears for respondent number 4?
Please, Malads, I appear for respondent number 4.
Ajay Katkul undertakes to appear for respondent number 4. Registry direct print his name as such. Non-compliance in
order by the report on 15/9/2022.
You're not complied with the office objection still.
One, so far as a plan is concerned, I will look into it.
With my lord's leave, may I make one submission, Malads?
Yes.
Malads, this is a third.
When will you look at 15-9 order?
Yes, Your Lordship. There is only one small correction so far as
How long will you
plan
take?
is concerned, Your
How
Lordship.
long will you take to do it?
It is not necessary, it is not relevant so far as that.
It's not for you to decide.
Your Lordship, a week's time, no, 1 week's time.
Not for you to decide.
2 days.
Yes, Mr. Katkul.
Malads, this is the third round of litigation, my lords, in relation to the same subject matter, my lords. I'll just, my lords, assist your lordships on the facts of the case in just 2 sentences, my lords.
You want to file any objection or you want to address argument now?
My lords, if your lordships may permit, my lords, I'll address my arguments, my lords. My lords, what?
Yes, Your Lordship.
Let the petitioner start.
Please, my lords.
So far as the case is concerned, I challenge Annexure A, Your Lordship. Annexure A is a notice initiated under Section 150 of BBMP Act, Your Lordship, by the Joint Commissioner South. Now, what is relevant is whether the Joint Commissioner under Section 150 of BBMP Act has the jurisdiction to issue this notice and pass orders. It is with regards to jurisdiction. I will draw your Lordship's attention to the relevant provision of Section 150, Your Lordship, of BBMP Act. It may kindly be shown.
Yes.
A review by the Chief Commissioner, where the Chief Commissioner either suo moto or otherwise, after such such inquiry as he considers necessary, satisfy that any transfer of title under Section 149 got recorded in the corporation register by fraud, misrepresentation, or suppression of facts, or by furnishing false, incorrect, or incomplete material, he may, within a period of 3 years from the date of such recording of transfer of title, reopen the case and pass such order with respect thereto as he thinks fit, provided that no such orders shall be made except after giving the person likely to be affected thereby a reasonable opportunity of being heard.
Yes.
The provision is very clear, Your Lordship. The powers vested under 150 of the BBMP Act is only with the Chief Commissioner. Here is so far as Annexure A is concerned, this is an action initiated by the Joint Commissioner South.
Is there any delegation powers?
Section 66 of BBMP Act.
Includes 150? And who have you delegated it to?
Joint Commissioner, that is respondent number 2. Earlier, my lord, he had filed another petition, my lord. The matter was remanded to Joint Commissioner only.
Is this one is only that now? Earlier he had.
Yes, that is annexure. Lordship may kindly.
Your Lordship, that is under 114A. That is under 114 KMC Act.
Continuation
Third round of litigation, my lords.
You want to file a petition in each of the provisions of the
No, Your Lordship. So far as the jurisdiction is concerned, I raised this point on the very first day. I raised this point before the Joint Commissioner, and in my absence, this order came to be passed. And
Joint Commissioner has the powers.
Your Lordship, there is
Delegate.
Your Lordship, so far as the BBMP Act doesn't talk about the Joint Commissioner.
BBMP also has 66, read section 66.
So far as
You can't read one provision, the entire act.
Yes, Lordship, so far as jurisdictions, they can be kept open, and there is one more ground.
Kept open, we are dismissing your petition.
Your Lordship, one more ground here, Lordship.
What is the other ground?
The second ground is so far as interpretation of the order passed by this honorable court in WP. In WP, which is at 105, you know.
105.
102, you know. 102. What's happened?
How many petitions have you filed?
Lordship, it is with regards to, there were earlier orders.
The third round of litigation, Lord.
Your Lordship, so far as
102 is the Joint Commissioner.
it's an order passed by this honorable court. The relevant portion
102 is not by this court, Mr. Counsel. Annexure M 102.
Annexure N, you know.
Annexure?
N 102 in page. 102.
You have the wrong page number.
108.
108 in our petition.
108, you know.
Yes.
108. The relevant portion is para 9, you know. Para 9. I'll just read. In so far as it relates to amalgamation of Kata number 22 set aside, however, the petitioner shall not put up any construction on the area which is identified by the respondent number 2 as a road. Now, this order is being misinterpreted by the Joint Commissioner in Annexure A. What is stated herein is that the Honorable High Court has stayed the entire proceedings. It is not the impute order.
Where read that?
It is third paragraph, third line.
Third paragraph of
fourth line.
Of Annexure A.
ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಖಾತಾ ಹಾಗೂ ನಕ್ಷೆ ಮಂಜೂರಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಲು ಆದೇಶಿಸಿರುವುದರಿಂದ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಹಣೆ ಅಭಿಯಂತರು ರವರ ಕಟ್ಟಡದ ಕಾಮಗಾರಿಕೆಯನ್ನು ಮುಂದುವರಿಸಲಂತೆ ಕಟ್ಟುನಿಟ್ಟಾಗಿ this is the order.
Notice ಜಾರಿ ಮಾಡಿ ಕಾಮಗಾರಿಯನ್ನು ನಿಗದಿ.
So this order has been misinterpreted, Your Honor. So far as Your Lordship,
firstly, you haven't even read that order to say that you are missing.
Your Lordship, it may kindly be posted on Thursday. Thursday.
What the Joint Commissioner has only said is that the court has directed that no construction is to happen.
Your Lordship,
that is the right
interpreted is basically the court has passed an order wherein my khata and the sanction plan is being stayed. That has been misinterpreted. This is with regards to an interim order passed by the Joint Commissioner, which came to be challenged under this WP, Your Lordship. And the impugned order is so far as the interim order under the and that has been misinterpreted, contending that the Honorable High Court has passed an order wherein our sanction plan and the khata has been stayed. Whereas order is only so far as the interim order.
ಕಾಮಗಾರಿಯನ್ನು not sanction plan.
The khata.
Kalamagari is construction.
And the khata.
The khata is being set aside by this court.
No, Your Lordship, that is wrong.
You see 100 and...
Yes, Your. I will draw Your Lordship's attention to
insofar as
ninth paragraph.
Amalgamation of khata.
Yes, it is an impugned order. I will draw Your Lordship's attention to what is the impugned order. Impugned orders so far as the interim order passed by the Joint Commissioner.
Mr. Purushothaman.
Yes,
at page 115.
115.
Impugned order insofar as amalgamation of khata is set aside and not to put up any construction on the area.
Your Lordship, that is incorrect, Your Lordship. So far as I will draw Your Lordship's attention to 110, Your Lordship. 110.
The operative portion of the order reads
yes. It is so far as the impugned order is concerned, so far as an interim order passed by the Joint Commissioner.
You are trying to misinterpret the orders of this court.
No, Your Lordship. No, Your Lordship. I may kindly impugned order. I will draw Your Lordship's attention so far as 110 is concerned. This writ petition
coming in the way of disposal of the proceeding because this court has directed it to be disposed in 3 months.
Your Lordship, so far
you don't want to dispose.
Your Lordship, one thing. I will just read the impugned order.
As regards the construction portion, my lord, subsequent date, Joint Commissioner has clarified it, my lord, on 25/8/2022 itself. This portion on the road has been to be maintained as status quo. Other portion, my lord, is free to construct.
He is constructing on the
That has been clarified on subsequent date.
My lords, leave me assist.
On 25/8, my lord, I have got a copy of the order sheet of the Joint Commissioner here.
Yes, Mr. Kadkol.
My lords, permit me to assist your lordships on the facts of the matter, my lords, and thereafter, my lords, I am grateful to my friend. My lords, I'll just permit me to just narrate the facts in just 2 sentences, my lords.
Yes.
My lords, the petitioner before your lordships, my lords, and the respondent number 4, my lords, are the owners of the property, my lords, which came to be partitioned, my lords, about 20 to 30 years back. My lords, in the said partition, my lords, a road, my lords, a common area measuring, my lords, 24 feet into 106 feet was kept, my lords, as a common passage. My lords, this common passage came to be notified as a public road, my lords, by the city corporation. My lords, much later, my lords, what the petitioners before your lordships would do, my lords, file a petition for amalgamation of the khata, my lords, of their properties to the inclusion, my lords, of this public road. My lords, I being aggrieved, my lords, by the khata, my lords, amalgamated khata, which included, my lords, this public road, approached this honorable court, my lords, and the order which your lordships will find at page number 95, my lords, of their petition. My writ petition, my lords, was numbered as 33968 of 2019.
Yes.
My lords, may I request my lords to kindly, my lords, peruse paragraph number 6, my lords, which your lordships will get at page number 99, my lords. Internal page number 6. Learned counsel for the respondent submits that the passage referred to by the petitioner in fact exists. It is also submitted that though there was an observation in WP number so and so that an extent of 24 feet into 106 feet that runs to the property bearing survey number so and so was a private access and BBMP did not have any right. The said submission was made by its counsel before the division bench and is contrary to the records and applicable framework. It is submitted that the passage referred to by the petitioner has been vested with the BBMP by operation of law and that the said passage is a public street. Taking note that the order at annex.
We're not deciding that, Mr. Katkul. This court is already.
Well, subsequently, what happened?
The matter to the Joint Commissioner.
Please, my lords, the
Joint Commissioner decide that.
Please, my lords. My lords, the Joint Commissioner, my lords, would pass an interim order.
Yes.
My lords, that interim order, your lordships will find at page number 103. My lords, that interim order also came to be challenged by the petitioner before your lordship before this honorable court. My lords, that interim order, my lords, was set aside only to the extent, my lords, that the petitioner should be heard by the Joint Commissioners.
Yes.
My lords, however, my lords, the observation that was made in the impugned order that the construction in the public road measuring 24 feet into 106 feet, the status quo ought to be maintained. My lords, pursuant to, my lords, the order that came to be passed by this honorable court in the second writ petition, which your lordships will find at page number 103 of the petition, my lords, the impugned notice was issued. In fact, my lords, the impugned notice, my lords, which the petitioners have challenged before your lordships, would also encapsulate that, my lords, the notice that is issued, my lords, under section 105 is in parameteria, my lords, of section 114A of the Karnataka Municipal Corporation Act. So, my most respectful submission, my lords, only to, my lords, frustrate, my lords, the orders that are passed by this honorable court, my lords, a frivolous writ petition is again preferred by the petition. Your lordships may consider this and dismiss the petition.
If I may, if also so far as the orders passed at WP 10627 and order 108, I will draw your lordship's attention so far as why this WP came to be filed. This WP came to be filed so far as challenging the interim order of the Joint Commissioner. There was an interim order passed during.
Your contention now, as regards the impugned order.
Yes, your lordship.
Is one that the Joint Commissioner does not have jurisdiction.
Yes, your lordship.
And two, that the plan sanction, the order reads as if the plan sanction has been stayed. Those are the only two contentions. Kata has been stayed.
Yes, your lordship. So far as the order is concerned, it is misinterpreted, your lordship.
We'll deal with that. And you may also need to pay costs.
Your lordship, please let me just complete this, your lordship. I will just read the judgment so that or it may kindly be posted on first.
No, please argue now.
Yes, your lordship.
They have put you on notice that you are going to pay costs.
Your lordship, I will please.
How much cost you will pay is.
Your lordship, I may just draw your lordship's attention so far as the judgment is concerned.
Yes.
At 108, I will just read the 110 why the writ petition came to be filed, your lordship. The writ petition is filed under 226 and 227 of trying to quash the impugned order dated 28/4/2021 passed by the respondent number 1, wide annexure A, and grant an interim order to staying the impugned order dated 23/4/2021 passed by R1, wide annexure A, and all other further proceedings pursuant to the impugned order. The WP is filed so far as the interim order of joint commissioners concerned. During
Want to interpret the order of this court?
no, your lordship, and and so far as last paragraph is concerned, it is so far as the impugned.
Yeah, aggrieved by this order, your remedy is elsewhere. You can't interpret that here.
Your lordship, the order is concerned, the same came to be misinterpreted. Your lordship may kindly be post this matter on Thursday, your lordship. Thursday, your lordship. Thursday.
We have heard you enough and wasted time, Mr. Counsel.
Your lordship, so far as the orders are concerned, your lordship may kindly grant 1 minute. 1 minute. Your
Yes.
Your lordship may kindly peruse page 8 of the judgment. Your lordship. 8. Right.
Yes.
In that view, the matter, the writ petition is allowed in part. The impugned order, in so far as it relates to amalgamation of Kata number 52, is set aside. However, the petitioner shall not put up any construction on the area which is identified by the respondent number 2 as the road. This is the order and subsequent paragraph, your lordship. The respondent number 1 shall decide the case expeditiously and dispose of the proceedings at the earliest, which shall not be later than. This is the order. Now, so far as why I've challenged this WP, I filed this WPs, the order has been misinterpreted by the Joint Commissioner.
What misinterpretation, Mr. Counsel?
It
That
has
be
been-
5 times.
Your lordship, annexure A talks about.
You're just saying misinterpreted. What is misinterpreted?
Your lordship, the last 2 lines of annexure A, your lordship. Last 3 lines wherein annexure A, it may kindly be perused. Last 3 lines wherein they
ಹಾಗೂ ದಿನಾಂಕ 25 ಜಯನಗರ 2. That's all.
The order states that the Honorable High Court has stayed the Kata and the plan sanction. Hence, we are not supposed to put up.
It doesn't say plan sanction.
Your lordship, so far as
it does not say.
Madi.
The construction has been stated. Please don't misinterpret. You are the one who is misinterpreting.
Fourth line, your lordship. 4th line.
Yes, Mr. Counsel. Now let us dictate.
ನ್ಯಾಯಾಲಯವು ಖಾತೆ ಹಾಗೂ ನಕ್ಷೆ ಮಂಜೂರಾತಿ ರದ್ದುಪಡಿಸಲು.
For this court seeking for the following relief.
ಖಾತೆ
Contention of the petitioner. First respondent joint, second respondent joint commissioner does not have powers under section 150 of the BBMP Act. And as such, the notice which has been issued at annexure A is not sustainable and is required to be quashed. The second contention of the petitioner is that by way of said notice at annexure A, the order passed by this court in WP number 10626 of 2021 dated 15 July 2022 has been misinterpreted, inasmuch as the Joint Commissioner has contended as if that the plan sanction has been stayed, which is not being so stayed by this court. Ajay Katkol, the counsel for respondent number 4 would submit that the third round of litigation, inasmuch as the earlier notices which had been issued to the petitioner by the BBMP had been challenged, and this court having come to a conclusion that the matter requires consideration, had remanded the matter to the Joint Commissioner, point number 1 by way of the applicable order, and in the meanwhile, take the amalgamation of Kata, set aside the amalgamation of Kata number 52 and directed the petitioner not to put up any construction on the area identified by respondent number 2 therein, who is respondent number 4 herein as a road. In that background, we submit that there is no misinterpretation of the order which is being done by the Joint Commissioner. The above petition is a frivolous and vexatious one, is an abuse of the process court and the above petition is required to be dismissed. Shri B.V. Muralidhar, learned counsel for the BBMP, would submit that in terms of section 66 of the BBMP Act, the powers vested with the Chief Commissioner can be delegated by the Chief Commissioner to an officer subordinate to him. And exercising such power, the said authority has been delegated to the Joint Commissioner who has exercised the powers in a proper manner. Third point, produced papers. The dispute between the parties is as regards a 24 feet passage situate in between the property of the petitioner and respondent number 4, which was partitioned between themselves. The allegation made by respondent number 4 is that the said passage has been encroached upon by petitioner and the same has been sought to be amalgamated into the property allotted to the share of the petitioner, thereby depriving respondent number 4 of access to his property. And it is in that background that objections were raised by respondent number 4, resulting in various litigations.
May I just add one point?
These,
This passage, has been declared as a public road,
if the further contention is that the said passage has been declared as a public road by the BBM. Be that as it may, this dispute is required to be decided by the Joint Commissioner in view of the orders passed by this court in WP 10626 of 2021, date 15 July 2022. The contention of the petitioner is that the Joint Commissioner does not have the power to decide these issues, and the matter would have to be decided by the Chief Commissioner in terms of Section 150 of the BBMP Act. Section 150 reads as under, Section 66 reads as under. A reading of Section 150 in conjunction with Section 66 would indicate that the powers of the Chief Commissioner may be delegated to any officer of the corporation subordinate to him. It is in furtherance thereof that the powers under Section 150 has been delegated to the Joint Commissioner. Apart therefrom, a perusal of the order in WP number 10626 of 2021 indicates that the respondent number 1 was directed to decide the case expeditiously. Respondent number 1 in the said writ petition is the Joint Commissioner South BBMP. Thus, it is now not open for both the above said reasons for the petitioner to contend that the Joint Commissioner does not have jurisdiction. Insofar as the contention of the petitioner that there is a misinterpretation of the order dated 15/7/2022 is concerned, by the notice dated 18/8/2022, what the Joint Commissioner is directed is that what the Joint Commissioner has observed is that the amalgamation of the kata has been set aside by this court in WP number 1 by this court, WP number by this court, and as also the construction has been restrained. Para 9 of the order of this court is reproduced here under for easy reference. A perusal of the above would indicate that this court has indeed set aside the amalgamation of kata number 52 and restrained the petitioner from putting up any construction in the area identified by respondent number 2 as a road. Thus, the notice does not suffer from any misinterpretation as alleged by the petitioner. It is, in my considered opinion, it is the petitioner who is seeking to misinterpret both the orders of this court as also the notice issued by the Joint Commissioner. As such, costs would have to be imposed. The more so on account of the fact that the petitioner is seeking to delay the proceedings before the Joint Commissioner, which were required to be completed within a period of 3 months from the date of the order, that is 13 July 2022. Now, today we are in the month of April 2023 and the matter has not been disturbed on account of the frivolous disputes raised by the petitioner by filing this frivolous petition on 9 September 2022. As such, cost of rupees 50,000 is imposed on the petitioner. The petitioner is directed to make payment of the same to the Karnataka State Legal Service Authority within a period of 2 weeks from today. The petition, being devoid of any merits, stands dismissed. The second respondent is directed to proceed forthwith with the matter and dispose of the same within a period of 60 days from today.
3 months, man. 3 months.
ಮತ್ತೆ 3 months.
Matter was immediately stayed by this honorable further proceeding. Election ಇರೋದ್ರಿಂದ.
Within a period of 90 days from the date of receipt of copy of this order.
I'm deeply obliged.
What ಹಾಕಿದ್ದೀರಾ? Report.
I apologize, my lord. In fact, it was me, my lord, who pointed out that the petitioner is also staying in the glass house, wherein he is thrown will.
Now what to do if they are in the glass house? Glass house will be demolished.
My submission is, my lord, if we have violated, my lord, as per the order of this court, we are ready to demolish the deviated portion, Your Honor.
Petitioner also violation
Even
of
the
black mail.
petitioner also has violated the bylaw and he has.
Is a black mailer Swami. ಹೌದು petition file ಮಾಡಾದ ನಂತರದಲ್ಲಿ 20 lakhs claimed on Swami ಆತ petitioner. Report is awaited.
ನೀವ್ ಯಾರಿಗೆ?
Respondent to 405.
ಇಬ್ರು ಒಬ್ಬರಿಗೆ ತಾನೆ ಒಬ್ಬರೇ ಮಾಡಿ ಇಬ್ರು ಬೇಡ.
My lord, I'll file it on the next day.
Take action on you.
I'll take it.
If you don't maintain good relation with neighbors, this is what happens.
In fact, it was me, my lord, who pointed out that the petition is also, my lord, that's the sanction.
Interim order may be vacated, my lord, because I obtained the loan from the financial company, my lord. Since it stays in operation that they are about to cancel the loan, my lord.
Now they're going to issue a notice, you have to comply with all that, then only the question of construction will arise. Until then, you can't do anything.
Yes.
Let him file a report.
I'll file.
He'll let us know what both of you have to demolish. Both of you demolish, not construct. Have a good relationship with your neighbors.
That is the concern of the petitioner, but while I was making the construction, he's demanded for the illegal ransom.
Have a good relationship with your neighbor, here and there, they won't. But if you have a problem with the neighbors, then it counsel for respond number 1 to 3 seeks for and is granted 3 weeks time. The file is report released on Ella date released on 9th June. New Year ge
Respondent number 11.
respond number 11 BT Prasanna Kumar.
Yes.
Makaran withdraw madakagalla. You can't say not. To seek for discharge.
Return ಆಗಿದೆ ಅದು.
ಏನ್ ರಿಟರ್ನ್ ಆಗಿದೆ?
Reason ಗೊತ್ತಿಲ್ಲ.
ಕೊಡಿ ಏನಂತ ಆಗ್ತದೆ? Tell us return with office objection. ಏನ್ office objection?
NOC not okay.
Yeah, that. You'll have to file a memo for retirement. You say withdraw the wakala. The counsel for respond number 11 seeks permission to withdraw the wakala. The same cannot be permitted. She seeks for 3 weeks time to file a memo of retirement. What is IA 1 of 23?
IA 1 of 23 is for disobedience. The file, the petition is the nature of mandamus.
You find what are the objections on that?
With respect to the BBMP.
IA 1 of 23 you file madidira. Yeah, file. You file. So you have served it on everybody.
Please, I have that one.
The respective counsels for the respondents submit that they have received IA 1 of 23. Hence, the office objection raised on the said application has been complied.
But so far as the amendment of the cost title is concerned, it has been filed this morning.
Appeal not served on the.
Counsel for the petitioner submit that the amended cost title has been filed today. Registry is directed to verify. On filing of compliance report dated. Yeah, who has to file this compliance report of 10-4?
On the last date of hearing, I had complaints.
Is it-
And your lordship on the last date, please direct me to update this court. So what is happening in the lower court?
By virtue of the Supreme Court order, the present petition not survive, it has to be tried before the trial court. Your Lord. The same contention has also taken by me in the disobedience application objection. Your suit is not maintainable, Mr. Counsel.
My lord,
Your suit is an overreach of the court. This is the court. When there is a notice issued, you go and file a suit. No, Your Lordship, that has been disposed of. The earlier petition has been disposed of with a direction. We'll consider that. What is the status now?
my lord, permit me to make one
We'll
submission.
come to you just.
My lord, as far as the lower court is concerned, my lord, the lower court, my lord, the trial judge has stated that the interim order has to be vacated within a period of 1 month, during which period, my lord, liberty has been granted to the petitioner, which the
356.
please. My lord, 253.
256.
53 and 20.
BBMP. 253. And counsel for respondent number 125 filed a memo enclosing the status proceeding number 26373 of 2020. He submits that the trial court has granted a period of 1 month to the plaintiff to file an appeal challenging the orders passed by the BBMP under section 248(1) and 3 of the BBMP Act. Observing that after a period of 1 month, the temporary order of temporary injunction will automatically come to an end. The said memo is taken on record. Registrar General complaints.
First page.
The registrar, the system administrator has submitted a report stating that the application submitted by the Chief Commissioner BBMP Bangalore has been processed and login credentials of online digital case diary has been informed to the Chief Commissioner via email dated 11/4/2023. The BBMP and its law officers can now tag all their cases to the online digital case diary. The system administrator is also directed to auto tag as many cases as possible relating to the BBMP, which are pending before this court. The report of the system administrator is accepted. What about secretary e-governance?
But copy is not been served on 8 minutes. They have not served a copy, my lords. They have implemented R22 on last date acquisition.
A copy ಬೇಕಾಗಿಲ್ಲ, e-copy ಅಷ್ಟೇ ಬೇಕಾಗಿರೋದು. Why do you need the petition?
It is not uploaded, my lords. Check even
Upload ಆಗಿಲ್ಲ.
even in the morning I checked, my lords. Order was not been uploaded.
Upload ಆಗಿಲ್ಲ ಅಂತ ಬರ್ತಾ ಇದೆ. Statement ಅಲ್ಲಿ ಏನು pending ಇಲ್ಲ. And SCGB submit that since the order copy had not been uploaded, he could not keep informed the Secretary Department of E-Governance of the above order. ಇವಾಗ ಆಗಿದೆಯಾ? 10-4 ನೋಡಿ.
10-4 ಆಗಿದೆ. Not it. Right, approve.
ಆಗಿದೆಯಾ ಆಗಿಲ್ಲ?
Agil.
ಆಗಿಲ್ಲ, check ಮಾಡಿ. He submit that once the order is uploaded, he'll keep the secretary governance informed for doing an full and file the recompliance given 4 weeks time. He list on 12th June.
But meanwhile, the interim order passed with the honorable court, they have no value, the construction is going on.
No, your lordship, with respect to the construction is concerned, your lordship, it has been constructed way back, your lordship, before preparing the present petition before this honorable court, and as well as before obtaining interim order. The photographs furnished by the other side petitioner is completely, it is not into actual, your lordship. I have filed the detailed objections to the disobedience application.
The counsel for the petitioner submit that despite the orders passed by this court,
That's what, 23.
the construction is still proceeding.
Construction,
This is submission. Counsel for respond number 125 is directed to cause an inspection of the property in question and ascertain if any construction is going on and from when. And if such construction is going on, to take necessary steps to stop such construction. And submit a report in that regard.
I submit. But your lordship, construction is already duly completed. Your
Then check and let us know. ಅವ್ರು ಆಗ್ತಾ ಇದೆ ಅಂತ ನೀವು ಇಲ್ಲ ಅಂತೀರಾ, ನೀವು ಇಬ್ಬರನ್ನು ನಂಬಕ್ಕಾಗಲ್ಲ, ಅವ್ರು ನಂಬ್ತೀವಿ.
The date for the report.
ಮಾಡಿದ್ದಾರೆ. From when ಅನ್ನೋದು it may be a bit difficult because they may have obtained.
You see, let us see what the report is.
Thank you for the petitioner. Find a memo of withdrawal, my lord, seeking for liberty to file fresh petition in the same, my lord. Petitioner had applied for the site in science scheme, my lord, that has been struck down by the division bench. Now we have to submit certain records, my lord.
So for the petitioner filed on 6/4/2023, signed by the petitioner and the counsel for the petitioner, seeking permission to withdraw the above petition. What is the liberty you are seeking for?
To file fresh petition in case if it is necessary, in the same cause of action.
Set aside, it will be a new cause of action.
Yes, ma'am.
Accepting the said submission, petition stands dismissed as withdrawn. Six.
Paying for the petition.
Copy I not issued one.
Copy is equal.
The third response description is. Not the copy of.
Third description.
Primary.
Primary development.
Correct. Counsel for the petitioner is directed to furnish copy of the petition along with annexures on Shri B.J. Somyaji. Process fee.
Process fee, week's time. Ma'am.
Petitioner seeks for, petition seeks for and is granted a week's time to make payment of the process. Needful is done, registry is directed to issue notice to respond number 4 to 6, returnable by 23/6.
Description change. Third response.
ಅದೇ ಹೇಳಿ. 24.
Placing my report. Placing my report. It appears may not be inspected in pursuance of the orders passed by this court. The entire construction appears to be important. Consequent to which.
Without plan sanction.
And consequent to that, may not be issued POC and also demolition order. Petition may not survive.
How are your officers permitting construction without plan sanction? Don't you?
No, it is at the nascent stage. It is at the stage. You'll see the photographs. Page 6.
Deshpande, if you look at this construction, lakhs and lakhs of rupees have been spent, if not crores.
What has happened is that, my lord, I did inquire. Initially, they gave only a, my lord, affidavit have stated in the measure also I pointed out. Annexure R1, my lord, page 3 of my statement of the report. My lord, we have been writing to them since 3 to 4 months. Please give the documents. Please give the documents. They don't come and
So why don't you stop the construction at that stage?
yes, my lord, immediately, my lord, Suchana Patra, your lordship. We have pointed it out to him. Please produce the documents for. He doesn't appear. And here also, my lord, they are not coming before this court.
If they don't give you papers, should you not stop it?
Yes. Page 6, my lord. Page 3, my lord.
4 floors are constructed.
Entire, my lord, I go down. I go down.
Must have taken at least a year plus.
Since
what your office is doing.
Yes, my lord, my lord, we have been communicating, we have been corresponding to them, my lord. They are.
ಮಾಡ್ತಾ ಇರ್ರಿ. They'll occupy it.
Like, my lord, we have issued demolition also. At page, demolition notice is also issued at page, my lord, annexure R8, page 133. Demolition notice is also issued, confirmation order, 248 subsection 3, dated 10/3/2020. That is why last time we took time that we wanted to place this on record. Demolition order is also issued.
KVIT file ಮಾಡಿದೀರಾ? Have you filed KVITs?
No, yes, my lord, I will instruct them. The morning they gave it across the barcode.
The moment that notice is issued and 248(1) and KVIT has to be filed. Both in the High Court and the trial.
My statement will be.
Otherwise, they'll go and.
No, my lord, we'll ensure that, my lord. In view of this demolition order being passed, but their grievance stands.
If they apply for plan sanction even now, if it is in terms of plan sanction, it could be granted, it could be regularized by issuing a plan sanction.
As regards, my lord, regularization, it's only point.
Not regularized. The plan sanction is sought for, and if it is in accordance with the plan, that's that.
No application is ಕೊಟ್ಟಿಲ್ಲ.
Plan saying there's 6 inches gap. I think that greedy. Counsel for respond number 2 has filed an affidavit of the assistant executive engineer, Uttarahalli subdivision, ward number 184 of BBMP, stating that pursuant to the order of this court dated 3/3/2023, the respondent had called upon respondent number 1 to furnish copies of the plan sanction, if any. Despite the said notice, no plan sanction was submitted. And as such, notices have been issued on 13/2/23. How can it be 13/2? This was prior to the order.
ಅವ್ರು ಮೊದಲು ಕರೆಸ್ಪಾಂಡೆನ್ಸ್ ಮಾಡಿದ್ರು, ಅವಾಗಿಂದಾನೇ ಕೊಡ್ತಾ ಇದೀವಿ, ಅವ್ರು ಬರ್ತಾನೆ ಇರಲಿಲ್ಲ.
And your affidavit is not correct.
Yes.
Your para 4 should have been first.
Yes, ma'am. There is chronology.
We submit that on as far back as on 7/11/2022, notice under section 313 of the BBMP Act had issued, calling upon the first respondent to produce the plan sanction. When the same is not produced, the BBMP has on 13/2/2023 issued notices under section 248(1) and 2 of the BBMP Act, which is also not replied to. As such, a confirmation order under 2248(3) has been passed on 10/3/2023, calling upon the first respondent to demolish the construction. We submit that if the first respondent were not to demolish the construction, necessary steps would be taken by the BBMP to demolish the same at the cost of the BBMP. Insofar as said notices are concerned, we submit that KVIT petitions are being in the trial court as also before this court. A perusal of the report and the photographs which have been produced indicates that nearly 4 floors which have been put up along with the terrace, that construction could not have been put up overnight. It's only after this court, it was for the office of the respondent, more particularly the ward officers, to ward engineers to have verified any construction taking place in the said ward and ascertain if the plan sanction has been obtained in relation thereto. More so when all the plans are now electronically processed and the details thereof are available with the BBMP. It would be the duty of the ward engineer to stop any construction if there is no plan sanction which has been obtained in relation thereto. The Chief Commissioner is directed to look into this matter and issue necessary instructions to all ward engineers to comply with the above directions. Released on 19/6.
As regards, David will be filed under no ಮಾಡಿಲ್ಲ ಈಗ.
Is being filed on
I'm sorry.
at 6. Awaiting service of notice on respondent 6, released on 15th March. Released on 9/6.
26. Meeting.
You are wanted to file the additional affidavit for the action.
Even follow ಮಾಡಬೇಕು.
This one. Some efforts are being
That counsel for respondent number 1 to 4 has filed an affidavit of the
Joint
Commissioner of BBMP. The same is taken on record. In the said affidavit, the process relating to conduct of litigation against the BBMP has been laid down in terms of the guidelines formulated by the BBMP. It is open belief that the said guidelines will be followed by the BBMP. Released on 12/6.
Copy to me also, for respondent 5 to 13, they have not got this copy even on the last.
I shall.
Counsel for respondent number 5 to 13 submit that he has not received the report filed by the BBMP. Counsel for the BBMP is directed to furnish a copy thereof on the said counsel.
Suit has been filed before the court below. The present petitioner has also implicated himself and is contesting the matter.
That suit is not maintainable. That they have to take that they will take adequate action.
7 to 11 application is also.
ಹಾಕಿದೆ. ನಿಮ್ಗೆ 30 days time ಕೊಡ್ತಾರೆ appeal ಹಾಕಕ್ಕೆ appeal ಹಾಕಿ. Follow the statutory remedy.
What has happened in this case, your lordship, the petitioner before this honorable court has claimed that it is right opposite the landowner to the scheduled property under question. It is not so, our lordship, he said.
Have you violated the plan sanction or not?
No, absolutely not.
That's
violation.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಇವ್ರು ನಿಮ್ ಇಬ್ಬರದು ಬೇಡ. The duty of the petitioner was to bring it to the notice, that's all.
But 2 additional floors without any sanction plan license.
Let them serve the copy.
I shall.
Last occasion, I don't know for that.
Interim order earlier granted is extended.
That's the 30th March.
Awaiting service notice on respondent number 4. Counsel for the petitioner seeks for and is granted a week's time to make payment of necessary process fee in respect to respondent number 5. Registry is directed to issue notice to respond number 5, returnable by 23-1, 23-6.
28.
Lord, my name is shown to Lord represent respond number 1, Lord. Learned counsel appear for the petitioner appears to have not taken note of that. I have not received copy of the petition papers.
Counsel for the petition undertakes to furnish copy of the petition along with annexure and counsel for respond number 2 by end of day tomorrow.
Lord, I appear for respond number 1, Lord.
Respond number 1 by end of day tomorrow. He also undertakes to make payment of necessary process fee in respect to respond and furnish copies in respect to respond number 2 within a week's time. Needful is done, registry that issue notice to respond number 2, written by 23-6.
Last occasion, BBMP inspection.
What Millards, now I'm awaited for the reports, Millards concerned. Weeks accommodation, Millards, I'll file it. And also they have.
Week accommodation vacation.
248 clause 1, clause 3 also has been issued, Millards.
There is violation.
Yes, Millards, there is a violation. They have not taken the sanction plan, 100%.
Not taken the.
Yes, without sanction plan, they have constructed, Millards, 100%, there is a violation. Wait for a week's accommodation.
May kindly have it on 20th,
We
Millards.
do people construct without plan.
20th.
Anyway, 248(1) and 2 they have issued. Let the process happen. We'll have it immediately after that. And counsel for respond number 1 to 4 submits that respond number 5.
5 is a private.
5 is put up construction without obtaining plan sanction.
Yes.
As such, notices under section 248(1) and 248(2) have already been issued.
3 also has been issued. Confirmation order.
Issued. No reply.
No, not at.
No reply has been received. The confirmatory order under section 248(3)
Yes.
has also
Issued.
been passed.
Issued.
The BBMP is in the process of taking further action and related thereto. Her submission is placed on record. Relist on 2-6.
Obliged.
Regard to process, Millards. I have taken out for both address, residential address as well as construction.
Paper publication.
But their notice has been served. Court notice has not been served.
RPAD hogi.
RPAD, through RPAD.
And summons forward.
Akbar.
Counsel for the petitioner is permitted to take out hand summons on respond number 5. Showing the next date of hearing as 2/6/2020.
Then the construction
Has been stopped.
still going. Still going, and after issuance of first notice,
Instruction, Millards, yesterday they have stopped the construction. We have instructed them to.
Counsel for the petitioner submit that despite the orders passed and notices issued, construction is still going on. Respond number 1 to 4 are directed to inspect the property once again and restrain any construction happening. This 248(3) confirmatory order has already been passed.
Obliged.
okay.
Serial number 30. Dilapidated.
So for the petitioner seeks for 1 week's time to make payment of necessary process fee and furnish copy. Needful is done, issue notice to respond. Unserved response by 23/6.
31. Sarvana, yes.
Process fee and the second copy of furnished.
Counsel for the petitioner submit that process fee and copies have been furnished. Needful registry is that verified. Issue notice written by 23/6.
32. Telecast.
I would like to withdraw the representation.
Yes.
Withdraw the.
Counsel for the filed a memo dated 17/2023, signed by the counsel for the petitions, to give permission to withdraw the above matter, accepting the statement.
33.
Same order.
34. Sarvar Ballard.
34.
On this one number 3, the planning council representative, Sharanjit Shetty, and we have served a copy.
Sharanjit. The office objection is still not complied.
We have filed an application for dispensation.
Okay. I will the other 3 of them. Counsel for the petition seeks one is granted 2 weeks time to comply with office objection. Relist on. Relist on 2/6. Yes, sir, you got the copies? File your objections before that day.
35.
I'm sorry for a writ of mandamus directing the respondent to issue building.
Amendment, Master President. Amendment.
Subsequent to filing of this restriction, they have issued an endorsement saying that it can't be done because the road width varies between 17 to 19 meters. In fact, along with the amendment application, I have produced the document to indicate that the BBMP himself has issued a letter saying that the road width is 18.4 meters.
Counsel for the petitioner has filed an application in IA. Office objection.
Legible.
Registry has raised an objection as regards IA 1 of 2023, but connection H is not legible. A peril of the same indicates that it is sufficiently legible. However, 2 weeks time is granted to the petitioner to file a typed copy of the same. IA 1 of 2023 has been filed, seeking for amendment of the petition to incorporate subsequent details by which the petitioner's request has been refused and as such the endorsement has been challenged. The said subsequent events and the release which have been sought for being necessary for effective and proper disposal of the above matter to avoid multiplicity of proceedings. The amendment sought for is allowed. Petitioner to carry out necessary amendment and file amended petition within a period of.
Tomorrow I file. There is an urgency. I request your lordship to kindly take it up on Wednesday or
in a period of 2 days, as sought for by the petitioner. Relist on 20th April.
Please.
Respond number 3 in this petition.
Plan idea?
My lord, I'm respond number 3 in this case.
Yes.
The Atibele Municipal Act, Municipal Authority is not a competent authority. This comes under STRA, Satellite Town Ring Road Planning Authority. It comes under.
So you have taken a
Town and Planning Act.
You got a plan.
My lord.
You got a plan sanction on STRA?
No, my lord, because here one thing is the petitioner has suppressed the fact they already filed an alternative suit against us.
That is a different thing.
No, same for same issues. No,
We are not concerned with the petition.
much of it.
Petitioner's duty was only to bring it to a notice, that's all.
Much of it.
Have you obtained a plan sanction?
No, my lord. This revenue land. One more thing. Because it comes under SSL law.
STRR ಆಯ್ತು ಎಲ್ಲಿಂದ
My lord, they have given a note because they are challenged for the notice endorsement based on Atibele Municipal Corporation Act under section 187. They have to give a application before STRR.
They are asking you, Mr. Counsel, if you haven't got a plan sanction, how can you construct?
One more thing is, I'll check it out with my client for that aspect.
You are saying this authority, that
One more.
some authority have you taken plan sanction, that's all.
Because this authority have no power.
ನಿಮ್ಮ jurisdiction ಬರುತ್ತಾ?
The planning authority comes under the jurisdiction of municipal. There is no planning, there is no building like. Yes, planning authority is STA. I'll check it out. I'll come back. While I in detail objection.
Are you,
Just record.
are you forming a layout there for the planning?
Nothing, Mark. Because petitioner is basically a landlord. Basically landlord.
You are only constructing a house for which you have to take a plan sanction.
No, they are not adjacent property of the petitioner itself.
Forget about them. Have you taken a plan sanction?
Just I will check it out with my client because I have not received a.
You just said you have not taken any plan sanction. So they have they have jurisdiction.
No, one more thing is the jurisdiction part of that issues, they are not a competent authority.
It comes within their jurisdiction, Mr. Counsel.
STRR. Yes. Sorry, I'm.
STRR is the planning authority.
Yes, my lord. Planning and building.
Building sanctioning authority is the BBMP. Municipality. Municipality other plan.
I'll check it out with the test. I will file in detail objection.
They haven't taken initial action.
We have issued already 2 notices, but they have not stopped the construction.
Why haven't you stopped the construction?
First notice issued on 17.
Construction stop ಮಾಡಿದೀರಾ?
Then notice ಕೊಟ್ಟಿದ್ದೀರಿ. Reply ಮಾಡಿಲ್ಲ.
Construction stop ಮಾಡಿದೀರಾ?
Stop ಮಾಡೋದು ಹೇಳಿಲ್ಲ.
ಯಾಕೆ? First notice ಕೊಟ್ಟಾಗಲೇ ಹೇಳ್ಬೇಕು.
Notice ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
Check it out.
But you haven't implemented your own notice. Very powerful person.
Sorry. Allah, they are powerful person.
You issue notice and they continue construction, you don't do anything. Counsel for respond number 2. Submit that the inspection has been carried out and there being no plan sanction which have been obtained. Say notices have been issued. Counsel for respond number 3 submit that respond number 2 is not a planning authority. Therefore, it has been issued. The said condition may be true insofar as planning authority is concerned, but insofar as obtaining sanction of building plans and building license, respond number 2 being the concerned authority, it was for respond number 3 to obtain the 3 plan sanction and building license from respond number 2. The same not having been done, the respond number 3 is retained from putting up any construction. Respond number 2 is directed to implement the orders of this court.
I file mine.
As also take such action as may be necessary in respect of the violation committed by respond number 3. Alleged violation committed by respond. Relist on 12/6.
Direction to take action. Copy to read. I have not made government as a party.
BBMP.
BBMP.
Copy to GA. R3 is police inspector.
BMPF
state. Pawan Kumar accept notice for respond number 1 to 4. What is the relief you are seeking?
BMPF is BMPF statement.
BMPF ನೀವು
I saw that.
1, 2 and 4. The learned AG accept notice for respond number 3. 248.3 has happened, Mr. Pawan Kumar. 248.3 has happened, no action taken.
Construction is going on. Once the 248 issue, some people are filing appeal before the chief commissioner. I will ascertain whether they are.
When you issue 248.1 and 2, you should stop the construction. Prima facie, there's a violation.
No, can give complaints, police complaints, they can take assistance of police and they can ask BWSSP and DISCOM not to give power connection. There is no direct provision which says that we can stop the construction. But we can definitely we can take the assistance of police. I will
Just ascertain whether they have filed any appeal or there is.
What happens is you issue that notice, they continue construction. Then it becomes difficult for the court also to order demolition of the entire.
I'm just ascertain whether they have filed any appeal.
No, there is no appeal filed.
There is no appeal there. Further action should not have taken.
Please, issue notice to respond number 5, returnable by 19 June. Since there's already a section 248(3) notice which has been issued to respond number 5. Respond number 5 is restrained from putting up any construction. Respond number 3 and 4 are directed to implement the orders of this court. In report in bed, you already relist on so. Process fee and copies to be published by end of day tomorrow, in which the interim order will stand automatically.
38. Routine ticket, additional allowance. What is there's a small submission.
Court fee.
But we pay the court fee allowed by tomorrow maximum allowed. There's a small submission. There's a property allowed that's owned by us.
First pay the court fee, madam. You paid, we'll pass it for review.
That
You'll pay it by after
tomorrow allowed.
100 rupees you can't pay now. Pass over. This was so much.
This matter was the petitioner had challenged the other part by the district court minutes whereby the limitation applied for condoning the delay direction petition.
Respondent none appears.
Lord, my name is shown as for respondent number 3, my lord. Is an election officer, Taluk Panchayat. Lord, I am not appearing. So far, copies are all not served on me, my lord. I am not a standing counsel for election officer, Taluk Panchayat. R3, my lord.
The election petition itself has become infructuous. But the election petition itself has become infructuous. Because in the year 2016, the election
So this can go.
This as well as the original election petition.
Adu nammunde illa. We can only say about this. Shri Sudhakar Pai, learned counsel, submit that he does not appear for respond number 3. You are respond number 4 ga appear agtira. District election officer.
Illa, now yavarige illa. State.
His submission is placed on record. Registry is direct delete his name as that appearing for respond number 3.
Grateful.
Counsel for the petitioner submit that the above petition has been rendered infructuous.
The election petition has to go. Duration has expired.
And I'll know bit submit murder. We can pass on. If you do it there, we'll dispose this. There's no need to keep this. Since the term has expired. Accepting the said submission, petition stands dismissed.
What? How much are you?
Therefore, consider the representation of the next. Right with the members of the mission was held on 10/11.
What is annexure B? What have you sought for?
Representation is of annex. Page number 15.
Copy of the proceedings has not been submitted.
Copy proceeding is not been provided allowed to the councillors. Issuance of the councillors of respondent number 3 got municipality.
The petitioner is before this court seeking for the following release. The grievance of the petitioner is that the petitioner has not been furnished a copy of the minutes of the meeting. It is 10/11/2022, despite a request having been made on 12/1/2023. And it is in that background that the opposite reliefs have been sought. The petitioners being elected councillors of respond number 3 corporation the elected representatives would be entitled for copy of the minutes of the meeting of the councillors. Hence, I pass the following order. Writ petitions allowed, respond number 3 is directed. The mandamus is issued, respond number 3 is directed to consider the representation of the petitioner dated 12/1/2023 and issue copy of the minutes of meeting. Said councillors, if required, by collecting necessary photocopying expenses within a period of 4 weeks from the date of receipt of a copy of this order.
My lord, I appear for the petitioners in this matter, my lord. Serial number 41.
Yes.
I appeal for 1 to 3.
My lord, in this we have received wakalas. Previous direction was to file fresh wakalats. We will file that in the course of the day, my lord. Maybe matter may be taken up day after, my lord.
It take 2 months to file wakalat.
No, my lord. The clients are living in another state, my lord. The authorized party.
We'll have it after vacation. There's no urgency.
My lord, only for recalling I will take chance, my lord. Kindly, my lord. Because this is an electricity matter, it will go before the regular bench. This is for recall. Kindly, it may be posted on day after, my lord.
What is the recall?
My lord,
First of February.
Your file wakalatam or yet to file?
My lord, previously I am on record, my lord. Your lordships directed me to file the fresh wakalats. I have received the fresh wakalats today morning. I will file in the course of the day. If may be taken up.
No, we'll pass it over. You file it and come back in the afternoon.
My lord, it may be posted for day after, my lord. Kindly, my lord.
File it today, Mr. Dureraj. We won't be listing. Otherwise, we'll go after vacation.
Oh, no problem, my lord. After vacation.
My lord, may kindly hear me, my lord. 1st of February, there's an order dismissing the petition insofar as petitioner 1 and 3 is concerned. On the last occasion, your lordship had given my learned friend 10 days to file wakalat. It's still not filed. The cause list also indicates it. So your lordship may kindly reject his recall application, my lord.
He's got the wakalat nama now.
My lord, I am the possessor of the
file
wakalat. I kindly request for 2 days time, my lord.
Not on that technicalities. Counsel for the petitioner submit that the wakalat nama would be filed in another 2 days. Relist on 2nd June.
Your lordship, I appear for the respondent number 6 in the matter. Appearance might kindly be recorded.
No need to record.
Indeed, your lordship.
Accepting the reason stated in support of IA 1 of 2020, the production certified copy of annexure D, E, F, G, G1 and H are dispensed with.
My lord, in that matter, there are interim orders, my lord, 41, my lord.
This is only ground rent or?
Ground rent and along with other action.
So all these stays. So this will have to go to 2nd June. Connect the matter, so relist on 2nd June. The Pawan Kumar is directed to accept respond number 4 and 5. Registry is directed to delete the name of the BC India.
43.
Appearing for the respondent, seek accommodation.
What does this matter vacate?
This is the matter of traffic police booths that we have constructed, my lords, for the BBMP on the condition that we would be permitted to advertise on them. They have, my lord, surreptitiously in the
Here the counsel for response and is granted 3 weeks time to get ready and address his argument. Released on 5th June. Interim order earlier granted is extended. 44. Jagdish. 1 or 23 is allowed. Final hearing on 20.
I'm for the petition. For the respondent number 1. For
who appears for Town Municipal Council, Kunigal? TMC Kunigal. ಲಿಸ್ಟ್ ಇಲ್ವಾ? ಮತ್ತೆ
ಬ್ಲಾಂಕ್ ಇದೆಯಾ?
ವಕಾಲತ್ ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ನಮ್ಮದು ವಕಾಲತ್ತಲ್ಲಿ ದಟ್ ಆಫೀಸರ್ ರೇಸ್ ಅಬ್ಜೆಕ್ಷನ್. 1 week time.
ಬರೀರಿ ಇವಾಗ್ಲೇ. ಮೊಬೈಲ್ ನಂಬರ್, ಇಮೇಲ್ ID ನಂಗೆ ಬರೆಯಕ್ಕೆ ಎಷ್ಟೊತ್ತು ಬೇಕು? ಬರೀರಿ ಇವಾಗ. Counsel for the respond number 1 has added his mobile number and email ID to the Vakalatama. Hence, office objection on his Vakalatama does not survive for consideration. TMC Kunigal ಗೊತ್ತಾಯ್ತಾ? ಆಗಿಲ್ವಾ? Released on 5th June.
Interim order may fail.
Interim order earlier granted is extended.
Not for the respondent number 4, madam. This is my application for getting paid.
AUWSDB. HS Suhas is directed to accept notice for respond number 3. Counsel for the petitioner to serve a copy of the petition along with annexures on the said copy.
Emergency. For this reason, my lord, the respond number 4, that is myself, my lord, I pay for it. He has been by way of interim order, my lord, he has been restrained from releasing the funds. You will also kindly see the kind of interim order, my lord, that is passed by the honorable court. Of course, my lord, it is a ex parte order according to me, my lord. Page 2. Until next date of hearing, respond number 4 is directed not to release any compensation in favor of response 1 and 2 in respect to the property bearing number 67/2 of Parkurgund village. My submission is that, my lord, the petitioners, my lord, they are not the owners, my lord, of that property. Secondly, they have approached the civil court, my lord, for the purpose of adjudication of their rights. And at the same time, my lord, they have sought for an order of injunction as against response 1 and 2, my lord, who are parties to the petition. Secondly, my lord, we as an authority, my lord, we are constructing a STP plant, my lord, in the property in question. The question of compensation would not arise in this case, my lord, for the reason that we are purchasing the property from response 1 and 2. Response 1 and 2, my lord, as against whom, my learned friend, that is petition himself has initiated suit, my lord. That copy of the plaint is also produced as page 41.
Suit for?
Suit for madam.
Case
Injection
regarding the identity of the property.
ಅದು ಇಂಜೆಕ್ಷನ್ ಅಷ್ಟೇ ಇದೆ. ಪೇಜ್ 43 ಮೆಕಾನಿಲ್ ವಿಷಯ ಪ್ರತಿವಾದಿ ಯಾರಾಗಲಿ ಅಥವಾ ಅವರ ಕಡೆಯವರಾಗಲಿ ವಾದಿಯವರ ಹಕ್ಕು ಮಾಲೀಕತ್ವ ಮತ್ತು ಶಾಂತಿಯುತ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿರುವ ದಾವಾ ಆಸ್ತಿಗೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ವಾದಿಯವರ ಶಾಂತಿಯುತ ಸ್ವಾಧೀನಕ್ಕೆ ಅಡ್ಡಿಯುಂಟು ಮಾಡಿ ದಾವಾ ಸ್ವತ್ತುಗಳನ್ನು ವಾದಿಯವರು ಬೇರೆ ಬೆಳೆದಿರುವ ಬೆಳೆಗಳನ್ನು ನಾಶ ಮಾಡುವುದಂತೆ ಹಾಗೂ ದಾವಾ ಸೋಣಿಸು. Now there is an application for injunction also. Now, my lord, thereafter an order is also passed. Page 57, my lord. 51, my lord.
Scheduled property 67, 40 ಆಗಿದೆ 67.
40 ಅಲ್ಲಲ್ಲ
2 ರಲ್ಲಿ 2 ಎಕರೆ 34 ಗುಂಟೆ ಪೈಕಿ 1 ಎಕರೆ 10 ಗುಂಟೆ.
Yes.
1 ಎಕರೆ 10 ಗುಂಟೆ 2 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಅಲ್ಲ 67/1 and 67/2. We are concerned with, my lord, 67/1.
ಇಲ್ಲಿ ಸ್ಕೆಡ್ಯೂಲ್ 67/40 ಆಗಿರೋದು
67/1/2 ಎರಡು ಸೇರಿಸಿದ್ದಾರೆ ಪ್ಲೇಟ್ ನಲ್ಲಿ.
1 ಎಕರೆ 10 ಗುಂಟೆ ಯಾವ
1 ಎಕರೆ 10 ಗುಂಟೆ ಬಂದು 67/1 ಅಲ್ಲಿ. That you will also find, my lord, in
67/2 is not part of that suit.
67 ಅದೇ, that's what 67/1 and 2 they say, but it's only for injunction.
ನೀವು ಯಾವುದು purchase?
Now that you will also find annexure M, which the document of which they have challenged, page 39.
67/2.
Page
39, my lord, of the writ petition.
39.
They have challenged, my lord, which is nothing but a communication from the chief officer to the executive engineer. It is the nature of a communication. ಅರಕಲಗೂಡು ಪಟ್ಟಣ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಒಳಗಂಡೆ ಚರಂಡಿ ವ್ಯವಸ್ಥೆ ಆಗುತ್ತಿರುವ ಖಾಸಗಿ ಜಮೀನಿಗೆ ಅಪ್ರೋಚ್ ರಸ್ತೆಯನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿ ಕೊಡುವ ಬಗ್ಗೆ
ಅಲ್ಲಿ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ 60 ಗ್ರಾಂ ವ್ಯಾಪ್ತಿಯ ವ್ಯವಸ್ಥೆಗೆ ಆಗುತ್ತಿರುವ ಜಮೀನನ್ನು ಕ್ರಯಕ್ಕೆ ಪಡೆಯಲು ಅವಶ್ಯವಿರುವ ಮೊತ್ತವನ್ನು ಬಿಡುಗಡೆಗೊಳಿಸಿಕೊಡಬೇಕಾಗಿ ಕೋರಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಮಾನ್ಯ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಭೂ ದಾಖಲೆಗಳ ಅರ್ಕುಲ್ಗೋಡು ಬರೆಯಲಾಗಿ ಉಲ್ಲೇಖವನ್ನು ಸದರಿ ಒಳಚಂಡಿ ವ್ಯವಸ್ಥೆ ಅಗತ್ಯವಿರುವ ಅಪ್ರೋಚ್ ರಸ್ತೆಯನ್ನು ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಖಾಸಗಿ ಜಮೀನು ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ನೀಡಿದ್ದು, ಸದರಿ ಸಂಪರ್ಕ ರಸ್ತೆಯ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆಗೆ ತಗಲುವ ಮೊತ್ತವನ್ನು ಈ ಕೆಳಗೆ ದಾಖಲೆಗಳನ್ನು ಅನುಸರಿಸಿ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿದ್ದು ರೂಪಾಯಿ 1,48,811 ಮೊತ್ತವನ್ನು ತುರ್ತಾಗಿ ಪಟ್ಟಣ ಪಂಚಾಯತ್ ಬಿಡುಗಡೆಗೊಳಿಸಬೇಕಾಗಿ ಈ ಮೂಲಕ ಕೋರಿದೆ. ಸಂಬಂಧಪಟ್ಟ ಸಚಿವ ಅದು 67/2 ಇದೆ. And this amount has been released to us.
Girish, your contention is that they are in possession of 67/1 and you are in possession of 67/2 and the 40 durasti which has been carried out.
Conducted properly.
So
We have in possession of 67/2 instead of 67/1.
have you challenged the 40 durasti?
Yes, my lordship. That's why I
Where have you
challenged
challenged?
got the ADLR in actual my lordship, page number 59. I sought for injunction. Injunction is also granted by the court, page number 59.
Have you challenged the durasti?
Yes, my lordship, in page number 59. That is pending for adjudication. Annexure G, R and S, annexure
29/7/21 in the pending adjudication.
then proceedings ಏನಾಗಿದೆ ಅಂತ ನೋಡಬೇಕು. Now if they have released the amount, they have acquired my land.
My submission is
Position.
the amount has been released to us. We are required to purchase that property.
Then they have acquired my
One second. Now, my lord, if you are to purchase that property, my lord, the person who is owner as on date, my lord, we will have to purchase from him.
Mr. Kole, if you pay to respond number 1 and 2,
Yes.
and tomorrow in these proceedings, they are.
Let them give an undertaking. They should be giving an undertaking, my lord.
If
Since
they
they
are-
are already facing civil proceedings and the appeal before this thing, we are only concerned with.
Please understand this.
Yes.
If they are declared, the 40 is set aside and 67/2 over one, you would have bought it from a person who had no title, number 1. Number 2, you are buying it as a sale, not as an acquisition. So if you are sale, it depends on whether they consent to it or not.
That's true, my lord.
Either ways, you can't say I'll pay the money.
I understand, my lord, if you had filed a suit for declaration, it's only an injunction.
Injunction on the basis that there is a Kodi Durasti mistake which has happened, for which there is already an application which has been submitted. Declaration in Bharat. It's only a Kodi Durasti mistake agirad. What has happened to these proceedings?
They are requested.
Why are you in such a hurry? We are not understanding because why do you want to pay it to somebody who may?
STP project, your lordship kindly see, my lord, what I have said in my application.
Acquisition proceeding alle, your owner illa, our owner illa, get this document, get that document, we won't pay antira. Why are you in such a hurry in this proceeding?
They are in a hurry, my lord, not to pay money, but to complete the project, STP project, it has been pending from last almost 2 years now, my lord.
Mr. Girish, will you, even if the correction has happened and you become the owner of 67/2, or kottira 1,48 lakhs here.
I will verify and I will.
You make that submission. We'll ask them to deposit the money in the court.
Yes.
Depending on the outcome of that proceedings.
Deposit amount, my land was accused for the project, my lord. That is the thing. I'm in possession of the 27/2, which was acquired by the
67
project.
acquired ಆಗಿಲ್ಲಪ್ಪ ಇಲ್ಲಿ. There's no.
Sale ಆಗ್ತಿದೆ, ಅದು ನಾನು ಪೊಸಿಷನ್ ಇದ್ದೀನಿ. Tenth of the.
Yes. Now 67/2, assuming you are in possession.
Yes.
Because there is a 40 durasti error, you are 67/1 owner. Now would you be willing to sell the property to the third respondent?
Verify, my lord.
1,48 lakhs you will get.
Verify and I will make my.
They want to sell you. If you are also willing to sell, depending on that outcome, we'll direct who is to be paid. We'll ask them to deposit it because it's a public interest project.
Requested, my lord, in completing the project.
The contention free Girish B. Baldare, Laurent counsel for the petitioner, is that the petitioner is the owner of land in survey number 67/2. There being error in the jurisdiction proceedings, he is being shown of survey number 67/1. An application has been submitted to the ADLR for rectification of the error. On inquiry as to, it is on that basis he submits that the purchase now being sought to be made by respond number 3. Respond number 4. Survey number 67/2 from respond number 1 and 2 is in fact the property of the petitioner and not that of respond number 1 and 2. On inquiry as to whether the petitioner is also willing to sell his land, whether the petitioner would also be willing to sell the land in survey number 67/2 if the rectification of the Kodi Durasti is carried out. He seeks for and is granted 2 days time to obtain instruction, make a submission. Released on 20th April.
Where for the petition in this case, my lord, IA is filed for vacating the stay. We are filing rejoinder. The lordship has taken up after vacation. My lord.
Kindly see the interim order. Actually, the main reading to grant.
Objection. Application for vacating the interim order is filed. We are filing rejoinder.
You can't ask. You can't ask for free of cost.
Annexary of free 80% of free of cost. 80% that too.
Section 17.
Out of 8 of quintas.
Just a moment, please.
Very sir.
Yes.
Now the deputy commissioner granted conversion. One of the conditions is that the person who has obtained the conversion order should not sell or bifurcate the property without the prior approval of the planning authority. Now, admittedly, the property is situated within the planning authority's limits.
Yes.
As per the master plan relating to this particular planning authority area. Now, section 17(2) of the Karnataka Town and Country Planning Act provides that the area relating to the road, etc., has to be surrendered free of cost without any compulsion. That is what we have asked in the endorsement that has been issued. I have produced connection R1 and R2. This property is situated at the intersection of 2 main roads. At the intersection of 2 main roads, this property is situated. Without surrendering this area, particular area.
You are asking for surrender for the proposed road.
Road is already in the coming up.
You are asking for a proposed road, not for a layout within his property.
No. They are asking for approval of the layout of the property which is in the intersection of 2 main roads.
Yes.
Please see the documents at section R1 and R2. I have produced
plan.
Along with the application for vacating stay, I have produced.
Where is the plan? Where is the plan that you are supposed to sanction? You produce model plan.
That I have produced at annexure R1 and R2 along with the application.
R1 is. You can't make out anything in R1. It's all photocopy. You can't make out anything.
Next document.
Yes. R2.
This
property
red mark nalli ide 133, 134, 135 anta bartidala aa area.
133,
134 and
135 ಇದೆ.
ಇಲ್ಲಿ ಬರ್.
ನಿಮ್ಮ ಹತ್ರ ಕಲರ್ ಇಟ್ಕೊಂಡು ನಮ್ಗೆ ಬ್ಲಾಕ್ ಅಂಡ್ ವೈಟ್ ಕೊಡ್ತೀರಾ?
ಸಾರಿ.
ನಮಗೂ ಕಲರೇ ಕೊಡ್ಬೇಕು. 133,
134, and 135 Bharata, that is the property where the property of the petition is situated.
133, serial number.
133.
Yes.
Now they are asking for approval of the layout. It is
In 133.
Of two roads.
In 130.
In 133.
133.
Yes.
A portion of the property.
Yes.
As per the order of conversion issued by the Deputy Commissioner, without the approval of the BMRDA.
So this proposed 45-meter road is formed by them or by you?
By the government and the National Highway Authority.
You want that to be given free to you?
Yes.
Innenaru beka free?
80%.
ಅಲ್ಲಿ approval ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Layout approval ಮಾಡ್ಲಿಕ್ಕೆ chance ಇದೆ. There is absolutely no chance of approval of the layout.
And you say that, how do you ask for a free land?
Please see section 17 of the Karnataka Town and Country Planning Act. Subsection 2.
Yes.
A. If the authority decides to sanction the layout plans under subsection 2, it shall sanction provisional layout plan in accordance with such rules as prescribed for demarcation and development purposes, showing the site, streets, alignment, park and playground, and civic community area and any other infrastructure facility, including the arrangement to be made for leveling, paving, metaling, flagging, channeling, sewering, drainage, street lighting, water supply to the satisfaction of planning authority and local authority. One copy of such plan shall be marked to the jurisdiction local authority. The owner shall relinquish the roads, parks, and playgrounds to the local authority and civil community sites to the planning authority through register relinquishment deed free of cost without claiming any compensation.
So this road is formed in the layout.
Yes.
In terms of the zonal regulations. This is not formed by the government, it's formed by them if there is a layout approved. You have not even approved the layout.
We are only asking.
You are asking for
to surrender this.
Surrender. You are asking
80%.
for land which is being earmarked for a proposed 45-meter road in a development plan.
Yes.
Or a master plan. Do you seriously want to press this submission?
No, without surrendering of this land, it is not possible to form the layout at all. That is number one. Number two, it is in the intersection of two main roads.
Yes. Yes.
Therefore, it is not possible to the planning authority to approve the layout.
Yes.
Virtually, interim order has been granted, and I have filed the application seeking for vacating the interim order.
We'll dispose of the matter. Petitioner is before this court seeking for the following reliefs. The petitioner is absolute owner of 8.5 quintals of land in survey number 133 of Dandupalya village, Hoskote Taluk, Bangalore Rural District, and said land has been converted for non-agricultural purposes by way of a order passed by the Deputy Commissioner on 28/4/2005. That's also by another order. The petitioner and others made a request for issuance of plan for residential purposes. One, Srimati Venkama, being the owner of
Annexure JUB conversion order.
Annexure A, my lord. Converted on 28/4/2005.
So all three survey numbers. Yes, sir. The said land along with certain other lands, totally measuring 11 acres, 37.5 quintas, including lands in survey number 134 measuring 26 quintas, survey number 133 measuring 33 quintas, were converted for non-agricultural purposes by order of the Deputy Commissioner dated 28/4/2005. The petitioner had purchased the aforesaid 8.5 hectares of land on 30/7/2013 under a deed of sale registered with the sub-register of Scotland.
Eight and 1/4.
8 and 1/4.
It's at page 30.
The petitioner submitted a plan for approval to respond number 1. Number number 2 in the respond number 1 with respect to the opposite line. The respond number 1 was letter dated 27/1/2022 contending that 80% of the said land had been earmarked for the formation of 45 meters earmarked for widening of National Highway 35 to 45 meters, called upon the petitioner to hand over the land so earmarked free of charge in order, and it is only thereafter that respondent number 1 would approve the plan. It is agreed by the same that the petitioner is before this court. The contention of the counsel for the petitioner is that the petitioner is only seeking for a plan sanction in respect of his own land. A condition as such cannot be imposed on the petitioner to relinquish or surrender free of cost the land which is proposed to be used for widening of a 45-meter road. The A.V. Gangadharappa learned counsel appearing for the respondent would submit that this said demand has been made in terms of section 17(2) capital A of the Karnataka Town and Country Planning Act 1961, bracket KTCP Act, in furtherance of which the planning authority, while sanctioning the layout plan, can impose a condition for relinquishing the roads, parks, playground to the local authority and civic community areas to the planning authority under a registered relinquishment deed. And as such, the demand made by the respondent number 1 to surrender the area earmarked for the proposed 45-meter road is proper and correct. And
Existing road will have to be widened.
Has to be surrendered free of cost. Third, so and so produced the documents. The contention of Sri A.V. Gangadharappa, learned counsel for respondent number 1 is that there is an existing national highway which is proposed to be widened to 45 meters. The property of the petitioner coming within the area sought to be widened. The same is required to be surrendered by the petitioner free of cost. In that regard, reliance is placed on section 17B of the KTCP Act. That section 17B is reproduced here under perusal. A perusal of section 17B indicates that it is when a plan sanction is granted and roads are earmarked in such a plan sanction, the said roads would have to be surrendered free of cost. If civic communities are earmarked, the said civic communities would have to be surrendered free of cost. The essential ingredient being that the said road and civic communities are required to be part of the plan sanctioned by the planning authority. And the extent of roads and civic communities are calculated in terms of the zonal regulations applicable there. In the present case, what is sought for by respondent number 1 is surrender of land of the petitioner for the proposed widening of a national highway to 45 meters. In that view of the matter, the demand made by the petitioner by respondent number 1 to say the least would be a claim made by respondent number 1 in extortion by using the legal remedies. If respondent number 1 intends to form any road on land belonging to a private citizen, it would be required for such authority to acquire the land and make payment of due compensation with such private citizen, merely because the land has been designated for widening of an existing road or designated for a formation of a road. The same cannot be demanded by a planning authority like respondent number 1 to be surrendered by the owner of the land free of cost. Section 17B, the interpretation now sought to be given to Section 17B of the KTCP Act is completely misplaced, inasmuch as the said provision relates only to roads formed within the layout and civic amenities formed within the layout. Admittedly, the proposed widening of the 45-meter road has nothing to do with the layout, but is something which is being planned by the authorities concerned, keeping in view the requirement of widening the existing national highway.
This is as per the master plan approved by the government.
And the same has been approved by the state government by approving the master plan. The said contention is, as already observed, being a claim by the respondent number 1 authority amounting to extortion, the private citizen, cannot be sustained. As such, I pass the following order. Writ petition is allowed, certiorari is issued. The endorsement dated 27/1/2022 bearing number so and so at Annexure E is hereby quashed. Respondent number 1 is directed to consider and approve the plan submitted for approval by petitioner without insisting for such surrender free of cost. Liberty is however reserved to respondent number 1 to acquire land by making payment of due amounts as and when required. Item number 1 of 2023 does not survive for consideration.
Okay, the petition.
Yes.
Matter petition of court to take action for the unauthorized construction in violation of the sanction plan. And this honorable court had also directed second and third respondent.
Both of you are in glass houses.
Please, madam. And last time you lords.
You said.
Two submissions, my lord. One is that, my lord, we have never violated any plan. The sanction is given to us, license is obtained by us. Like, they have only taken a broad contention that we have violated the sanction plan. And they themselves have filed a suit before the lower court seeking for injunction. And even that injunction is also vacated by the lower court, making an observation that I have prima facie not violated anything. That order is also produced.
Is that court to pass that order? They are not the authority.
And even authority has not inspected.
Why do you go to civil court? Civil court is not the authority for this. The corporation is the authority. In this case, corporation, TMC is the authority. They can determine whether the plan is sanctioned properly or not.
And they have made a false submission before this court in the inspection report. That is prima facie wrong.
48.1.
Now, our petition annexure F, my lord, page 46.
So-called notice has been issued in your petition.
And annexure, my lord, annexure G.
In your matter, Mr. Sunil, only representation has to be considered.
Considered, and an inspection report which is filed before this honorable court. Prima facie shows every floor there is violation, third floor license will. May I take my lordship's consideration for a moment to the
Yes.
inspection report, please. 30/11/2022. ವರದಿ ಅಂತಿದೆ.
Yes.
ನೋಡಿ, it says, serial number 3 ಮೇಲೆ ಪಡೆಯಲಾದ ಪರವಾನಗಿ ಮತ್ತು ನಿರ್ಮಾಣ ಮಾಡಿದ ಕಟ್ಟಡದ ಮಾಹಿತಿ ಕೆಳಕಂಡಂತಿದೆ. ಇಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಪಡೆಯಲಾದ ಪರವಾನಗಿ ನೆಲ ಅಂತಸ್ತು 97.75 meters. ಹಾಲಿ ನಿರ್ಮಾಣವಾಗಿರುವುದು ರೈಟ್ ಸೈಡ್ 137.25. Each floor there is one. And second page also. This third.
Indirect benefit.
ಅದ್ರಲ್ಲಿ ಒಂದು ರಾಂಗ್ ಸಬ್ಮಿಷನ್ which they make is license plan ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. In my objections have detailedly filed plan, license. 2012 I have considered, not now. And
demolition ಮಾಡಿ.
Kindly see my statement of objection for it. I'll not take more than 2 minutes.
So your contention is that the photograph at Annexure J
Please.
is a building which was constructed in 2012?
In their petition,
Their petition?
please. Yes, my lord. 2012. What I have done is rolling shutter ಹಳೇದಾಗಿತ್ತು. I have only changed the door and rolling shutter ಅಷ್ಟೇ. The license building was constructed in 12, not now.
And this is in accordance with the plan section.
Please, my lord, kindly take my statement of objection for a moment.
There is no setback only.
ಇಲ್ಲ, setback ನಾವು ಬಿಟ್ಟಿದ್ದೀವಿ.
ಎಲ್ಲಿದೆಯಪ್ಪ?
They have showed only one side, one photo ಹಾಕಿದ್ದಾರೆ.
ಒಂದು ಇಂಚು ಇಲ್ಲ setback on the right side. Left side ಅಲ್ಲಿ ಒಂದು 6 inch ಇರಬಹುದು.
Not clear in my thing because ಏನು ಕಾಣಿಸ್ತಿಲ್ಲ ಇದು.
Page 51.
Please, my lord, nothing is clear because please.
So, we should issue direction that every copy should have color. You can't give photocopies of black and white.
Sorry.
ಅಂದ್ರೆ ಏನು? ಎಲ್ಲಿ ಸೆಟ್ ಬ್ಯಾಕ್ ಇದೆ ತೋರಿಸಿ.
Yes, my lordship is right. Left and right there is no setback.
ಫ್ರಂಟ್ ಇಲ್ಲ, ಬ್ಯಾಕ್ ಗೊತ್ತಿಲ್ಲ, ಬ್ಯಾಕ್ ಕಾಣಿಸಲ್ಲ ಅಲ್ಲಿ. ಫ್ರಂಟ್ ಇಲ್ಲ, ಲೆಫ್ಟ್ ಟು ರೈಟ್.
Left and right, yes, my lord. It has attached to the
like this. Can't do that. Understand, land is very expensive and there has to be limits to the greed. So,
and the only issue is since it was a lodge which was constructed nearby, that was the contentious issue. Ella residential area ಇದೆ, and in the two shops, my lord, one shop is held by him because he seat or the stitch ಮಾಡ್ತಾರೆ. Only one shop is given for a cutting shop. ಅದು ಬಿಟ್ರೆ that is running from 2012. License, ಉದ್ದಿಮೆ ಪರವಾನಗಿ ಎಲ್ಲಾನು ಕೊಟ್ಟಿದ್ದಾರೆ. Everything is given. But only thing is with regard to the validity. Sorry.
it will be difficult for us to say anything in this. 48. Petitioner is before this court seeking for the following reliefs. The contention of the petitioner is that respondent number 2 and 3 having carried out unauthorized construction beyond the permissible limits under the plan sanction, the same is required to be done. The petitioner in 48.1 is before this court seeking for the following reliefs. The contention of the petitioner is despite a show cause notice and an issued to the respondent on 18/10/2022 as per Annexure F in respect of the construction carried out by respondent number 4 and 5. No action has been taken by the authorities concerned. In WP 19010 of 2022, this court had directed the authorities to inspect the property and submit a report. A report has been submitted on 1/3/2023. A memo has been filed on 1/3/2023 enclosing the report dated 30/11/2022, wherein it is clear that there is a excess construction which has been put up. By respondent number 4 to an extent of at least 54.75 square meter. Insofar as WP number 8101 of 2023 is concerned, a perusal of the photograph produced at Annexure J indicates that there are no setbacks which have been provided for the left and right side of the building as also in the front of the building. In that view of the matter, both the petitions would be required to be allowed. The statutory respondents and authorities are directed to consider the representations submitted by the respective petitioners and take necessary action thereon within a period of
4 weeks.
8 weeks from the date of receipt of a copy of this order. Both the reports.
Please. We may be permitted to file our reply, my lord.
In what? They'll take action by issuing necessary show cause notice.
Highly obliged.
For petitioner, my lord, in this case, I have filed an amendment application wherein, by virtue of typographical error, the name of the petitioner was wrongly mentioned only in the petition, my lord. Instead of Ayub, it was mentioned as Ayaz, my lord.
In this, I am appearing for Mysore City Corporation. They have shown our name in cause title, in cause list, in the party's name, I can see Mysore City Corporation. They have not served the copy to us.
We'll get them to serve after amendment will be. IA1 of 2023 has been filed to carry out correction of the inadvertent typographical error in the name of the petitioner. Accepting the reasons stated in support of the said application, the application is allowed. Counsel for the petitioner to carry out necessary amendment and file amended cost title within a period of 2 weeks. Copy of the petition along with annexures to be served on the counsel for respondent. Objections, if any, by 31st, relist on 6th June.
Highly obliged, my lord.
Is any mentioning?
PD number 26, posted at 26. 50 is also
5026 connect to so and so.
My lord, serial number 53, my lords, is also matter relating to ground rent.
53.
Yes.
Connect to so and so and relist on 26. 56.
Just matter.
56. Interim order beka.
My lord, 53, there is a request for an interim order, my lords.
And then please wait, Mr. Gilbert.
I'm sorry, I'll wait.
Please wait. 50, interim order idea beka.
Absolutely.
50 connect to so and so and relist on 26. Rest of them, yes, any other mention?
114.
Please wait. Any adjournments, sir?
Serial number 82.
82. You are for the petition.
Respondent.
Respond number?
3, my lord.
Yaar idhar hai respond number 3? Subramanian, na?
Yes, my lord.
82. Shri Subramanian has entered appeals for respond number. Delete M. Jayaprakash Reddy is that appearing for respond number 3. At the request of counsel for respond number 3, delist on 19th June.
Serial number 97, my lord.
97.
Number 5, my lord.
Inform ಮಾಡಿದಿರಾ ಎಲ್ಲರಿಗೂ?
ಈಗ
ಮಾಡ್ತೀವಲ್ಲ ಮಾಡಿದಿರಾ?
I mean, serial number 103, my lord. Krishna.
Yes.
India after the vacation, my lord.
Have you informed the others? Don't mention it like that.
Observe ಅದು next is 51 ಅಲ್ವಾ?
230 meter continue madam. 230 ಆದ್ಮೇಲೆ ಇದು ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ತಾ
Madam, 72 ಮತ್ತೆ 74. 74.
76.
25 ಏನಿದೆ? ನಾನು ಬರೋಷ್ಟು ಕಾಲೌಟ್ 82 ಅಡ್ಜಸ್ಟ್ 25. ನಾವು ಬರೋಷ್ಟು 26 ಆಗುತ್ತೆ. 25 96 ಏನಾದ್ರು ಏನು ಇಲ್ಲ. ಅದು ವೇಟಿಂಗ್ ಇರ್ತಲ್ಲ, ವೇಟಿಂಗ್ ಅಂತ ಹೇಳಿ 96 ಅನ್ನು 96.
54.
ಮೇಡಮ್ 87 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದ್ಯಾ?
98 ಎಷ್ಟಿದೆ? ಇನ್ನೊಂದು 70.
ಮೇಡಮ್ 87 ಅರ್ಜೆಂಟ್ ಆಗಿದ್ಯಾ?
87 ಇದೆ.
ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು.
ಇದೆಯಾ ಮೇಡಮ್? 84.
ಚಿನ್ನದ ಬೆಳೆ.
ಸರಣ್ಣ
ಯಾರು ಸಿಕ್ಕಿದ್ರು ಮಾತಾಡ್ತಾ ಇರ್ಲಿಲ್ಲ. ಯಾರು ಇಲ್ಲ ಫೋನ್ ತಗೊಳ್ಳಿ, ವೆರಿ ಈಸಿ.
ಅರ್ಜೆಂಟ್ ತಗೊಂಡಿದಾರ ಅಂತ 67 ಅಷ್ಟೊಂದು 230 ಮಾಡ್ತಿದ್ದೀರಾ ಸರ್? ಅದ 67 ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ.
ಆ ಕಡೆ CH, ಈ ಕಡೆ LB. ನಮಸ್ತೆ. ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಹೌದು, ಇಬ್ರು ಇದೀವಿ. ಅಲ್ಲ, ಕರೆಕ್ಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಬೇಕು. 95 ಏನಾಯ್ತು? ಕಡೆಗೆ ಹೇಳ್ತೀನಿ ನಾನು.
ಇನ್ನೊಂದು ಲಿಸ್ಟ್ ಇದೆಯಾ?
95. ಎರಡು
74.
230 ಅಂತ
ಅದರ್ ಸೈಡ್ ಟೈಮ್ ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಅದೇ ಅವರಿಗೆ ಕರಣ್ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಈಗ 45 ಆಗಿದೆ, 50 ವರೆಗೆ.
ಇದೊಂದು ಶ್ವೇತ.
72 ಏನೋ ರೀಚ್ ಆಗುತ್ತೆ ನಮ್ಮ.
ಎಲ್ಲ ರೀಚ್ ಆಗುತ್ತೆ ಸರ್, 5 days. ಅಲ್ಲಿ ಅಲ್ಲೇ ಇದ್ದು 230.
ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಡೇಟ್ ಕೊಟ್ಬಿಡೋಣ. ಇಲ್ಲ ಎಲ್ಲಿ ಕಾಯಿಲಿ, ನಾನು 4 ಗಂಟೆವರೆಗೆ ಹೋಗ್ಬಿಡ್ತೀನಿ ಮನೆಗೆ.
ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ
ನೋ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ವಲ್ಲ? ಓಕೆ, ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
ಸಾಯಂಕಾಲ ಬಿಟ್ಕೊಡ್ಬೇಡ. 50 ಆಗಿದೆ. ಇವತ್ತು ಕಮ್ಮಿನೇ ಇದೆ. ಅದು
ನಾನು ಬೆಳಿಗ್ಗೆ ಹೋಗಿ ಅಷ್ಟೊಂದು
ಕಳಿಸ್ಬೇಕು ತಾನೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಬಂದಿದೆ ಅಂತ ಕಳಿಸ್ಬೇಕು.
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಬರಲಿಲ್ಲ. ಏನು ಗೊತ್ತ, ನಾ ಟೈಮ್ ನೋಡ್ದೆ ಬರ್ಲೇ ನಾನು
ಬೇಗ ಬರ್ತಾರೆ. ಬೋರ್ಡ್ ಅಂತಾನೆ
ಒಂದೆರಡು ಬ್ಯಾಚ್ ಅಲ್ಲ ಗೊತ್ತಾಗಲಿ. ಮತ್ತೆ ಅನೇಕ ಎಲ್ಲ ಕೂಡ ಅವತ್ತೆ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಕಳಿಸ್ಬೋದು.
ಅಲ್ಲ, ನನ್ನ ಸೈಡ್ ಬಂದಿಲ್ಲ ಅಂತ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ನಾನು ಹೇಳ್ತೀನಿ
So, that is the
Yes.
ಅಲ್ಲ ಹೇಳ್ಬಿಡಿ ಸರ್ ಫಾರ್ಮ್ ತಂದ್ರೆ ಹರಿಯಾಣ ಧಾರವಾಡದವ್ರು ಯಾರಿದ್ದಾರೆ? ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ. ಅಲ್ಲ 2:30 ಸ್ವಲ್ಪ ಲೇಟ್ ಆಗಿ ಬರುತ್ತೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಕ್ಲಬ್ ಅಲ್ಲ ಸಪ್ರೇಟ್ ಆಗಿ ಬಟ್ ಆರ್ಡರ್ ಯಾಕಂದ್ರೆ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಹೋಗಲ್ಲ.
ನಡೆಸೋಣ 83
ಧಾರವಾಡ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಬಗ್ಗೆ ಮಾತಾಡ್ತೀನಿ. ಅದರಲ್ಲಿ
ಯಾವ ಹೇಳಿ
petitioner ಯಾರು ನೋಡಿದ ಇಲ್ಲ ಎಲ್ಲ ಆಗೋಗ್ಬಿಟ್ಟು ಆ ಕಡೆ ಒಳ್ಳೇದು ಈ ಬೇಸಿಗೆನಲ್ಲಿ ಮ್ಯಾಟ್ ಮೆರಿತಿದ್ರೆ ಅದು ಹಿಂಗೆ ಅಂತ ಹೇಳೋದು
But I think 82 is mentioned.
82.
Yes, ma'am. 82 is mentioned by the council appearing for respondent number 3 minutes, seeking an adjournment. The report needs to post it on 9.
It has been adjourned.
Please, minutes, but we were not informed. I've also informed them. Can it be taken up anytime this week, madam?
Not been informed.
My lords, I had informed the council on record. It appears that Mr. Aditya Bhatt appears. I had informed the council on record that is Mr. G.S. Patel, lordship.
Minutes, we've not received any text message. Be that as it may, my lords.
My lord, I have
But it's also
informed
not-
over text as well as have contacted the advocate. Since he was not reachable over the phone, I have dropped a message as well, Your Lordship.
My lords, anytime this week, my lords. My lords, small issue, my lords.
Everything is small, but time is also small.
That is.
What is the issue about?
My lords, we have an e-Khata, my lords. We have a manual Khata, my lords. E-Khata is not being given to us. Our endorsement was rejected by way of an endorsement stating that the planning authority has not given me a sanction for the layout plan. But my contention is, my lords, that I already have a sanctioned layout plan. This is from the year 1990.
Asking for a site or for the layout?
My lords, it's a layout. So we have.
E-Khata can only be for the site. Then.
No, my lords. Yes, my lords. Individual sites that are there. So in respect of those sites, my lords.
You have the plan sanctioned from the authority.
Please, sir.
Take a chance on 20th. 20th, madam.
Indeed, my lords.
82.
Very great.
Number 69. 69.
69.
I informed someone sir also. My letter is appearing for.
Yes.
After it.
69 at the request of counsel for respond number 4. Relist on 16/6.
Imprimatur is there, madam.
No, imprimatur is absolute, man.
Someone sir.
It's absolute imprimatur.
He informed my lord.
Absolute and
Please, madam. Then, madam, 95. I have to file my objections. Recently, I filed one.
Have you informed the petitioner?
Madam, I informed ಅಲ್ಲ ಈಗ ನಾನು ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡದೆ
ಮಾಡ್ತೀನಿ. ಐ ಅಂಡರ್ಟೇಕ್.
ಮಾಡಿದ ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ, ಅದವರೆಗೂ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ.
ಪ್ಲೀಸ್
ವೇಟ್.
Serial number 97. I will inform the other side.
97.
Yes, madam.
Here for respond number? Fifth respond. 97 at the request of respond number 5, released on 19/6.
Serial number 1, my lords.
Yes, Mr. Gurudev.
Lords, today, my lords, there is some difficulty, my lords. My name is not shown in the cross title, my lords, cross list, my lords.
You are appearing for whom?
My lords, I am appearing for, my lords, the respond number 1, my lords. Therefore, my lords, sometime my kindly be granted, my lords. I shall prepare myself, my lords, next time. The review petition, my lords, the order was passed by this honorable court, my lords, granting permission.
So 2 and 3 are represented. Only 1 was to be represented. Shri Gurudev Dachinmat, learned counsel submit that you will be appearing for respond number 1.
Yes, my lords.
For 2 weeks time to file his wakalatnama and make his submissions. Relist on 29/5 at 2:30 p.m.
Grateful, grateful.
Respondents, my lordship. In fact, my lordship, I filed objections on main petition, my lordship. So far as update is concerned, the orders was not uploaded. That was the reason I did not prepare the update. Weak account will be granted, my lordship, so that I applied. In the meantime, the corporation.
Rain.
Quite.
Again, back him.
1 week accommodation kotre update haktane. In the meantime, we are also approaching the petitioner as well as this district magistrate under Disaster Management Act to pay the compensation and get it done, the work completed. And we'll pay the compensation, whatever the compensation, because both are statutory bodies.
Why don't you both of you sit together?
Well, in fact, we met the.
You want to show your strength and power.
What was transformed, my lordship? It is not the intention of the corporation, my lordship. By anticipating the approval, I have placed records before my lord regarding permission. By anticipating that, we completed the work. What was transferred on the last date, my lordship, when the court commission was appointed?
You can't have a post facto permission. You can't have a post.
I do agree, my lord.
Whoever has done this. will
I'm not
have to-
disputing, my lord. Under the Disaster Management Act, we are supposed to take action. We'll pay the compensation. We have already approached the petition, my lordship.
We have asked you to answer the queries that have been posed. Either it is for you to answer or not to answer.
I'll file update, my lordship.
If you don't answer, the adverse inference would have.
No, I'm sorry, my lord, I filed update because my lordship, the orders was not updated. I could not be able to file update. I'm sorry, I'm apologizing for this court, my lordship. I filed objection statement so far main petition concerned yesterday.
So we'll have it on Thursday. By the time you give the explanation as to
My
how.
lordship, immediate application, my lordship, in the meantime, we'll try to dissolve the entire, the problem as such because
You have the audacity to make a submission now.
no, I'm
On
sorry.
construction,
I'm
you
sorry,
and
I'm
then-
sorry, my lord. I'm sorry. I apologize.
Say you approach the disaster management with.
No, not that, my lordship. The intention of the corporation, my lordship, to see this matter will be resolved amicably. That is not the intention, my lordship.
Getting an order and disaster management with, by suppressing facts again.
ಮಾಡ್ತೀವಿ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅವ್ರ ಜೊತೆ ಅಪ್ರೋಚ್
Payment ಮಾಡಿದ್ರೆ ಆಗಲ್ರಿ ಎಲ್ಲ ನಾವು ಏನಾದ್ರು ಮಾಡ್ತೀವಿ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಅಂದ್ಬಿಟ್ರೆ.
ಅಲ್ಲ ನಾಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಸಬ್ಮಿಟ್ my lordship.
It is not everything.
We'll resolve the issue by approaching the petition, my lordship.
You have to follow the process, Mr. Jagdish. And if corporation statutory authority does not follow corporation, then that will result to what? Unlawfulness. It is rule of law, not rule by law. You have to follow rules.
Yes, sir.
There. You cannot get into their property and you say that there's nothing, and when the photograph, commissioner produces photographs, everything is constructed. Did that happen overnight?
Actually, my lordship, I made a sub in the last occasion.
Your officer was here who says that I've instructed the contractor has done it by himself. Is that the attitude of the corporation?
Immediate application.
If you are going to do it to a government company, we shudder to think what you can do to a private citizen.
I apologize, my lordship. I apologize before this court. And in the meantime,
We are not going to do
we'll try to resolve the entire issue, my lordship, immediately after vacation.
Resolve ಮಾಡದ್ ನಮ್ಗೆ ಏನ್ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. You are now going on filing an application in disaster management.
ಇಲ್ಲ.
You file your affidavit first on Thursday.
Immediate application, sir. We'll resolve the issue because entire
That
officers are.
person, we'll ask that person to be here. We'll ask your chief commissioner only to be.
ಸಾಲ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ.
Zonal commissioner ಯಾರು ಹೇಳಿ, ಈ zone ಯಾರು zonal commissioner? We'll ask zonal commissioner. This is not the way to do it. Or Papa, probably your chief commissioner and zonal commissioner don't even know what your officers are doing.
Yes. I bow down my head.
Knowledge they are doing all these things.
I bow down my head, Lord, because there is an error on the part of the corporation, of course. I am not disputing it. We will try to resolve the entire issue, my lordship. Not because of any other reason.
File your affidavit. You can't escape. You have sought for 3 adjournments now.
Last time ಆಗಿತ್ತು ಅಪ್ಡೇಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್. Objections on main.
File ಮಾಡ್ತೀನಿ ಅಂತ ಇವತ್ತು ಆಗ್ತಿಲ್ಲ.
Under
Otherwise it was supposed to be on last Thursday. ಇನ್ನೊಂದ್ 2 ದಿನ ಎಕ್ಸ್ಟ್ರಾ ಕೊಡಿ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ನಾನು ಮಾಡಿದ ಇಂಪ್ರೆಷನ್ my lordship objection to main petition ಅಂತ ಹೇಳಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬಿಟ್ಟೆ. But in the meantime today I noticed that affidavit has to file. So immediately after vacation I see that the entire issue is resolved.
2 days finally is granted to file the affidavit. Relist on 20th. If affidavit is not filed, the zonal commissioner, the jurisdiction zonal commissioner shall remain personally present before this. R1. You are appearing for R1, yes.
Annexure F is the order.
What's your submission?
I need to file the objection.
Need to file your objection.
It is the panchayat. They have nothing to do with it. The respondent of the executive officer has nothing to do. It's a panchayat resolution. I am seeking implementation. Annexure F8.
You are asking for a circular, I understand.
Yes, my lord. Page 28 is the panchayat, my lord. I am seeking for question. Not.
You are asking for a certiorari to cause the endorsement issued by respondent number 1.
Annexure
You
F.
can't say they have nothing to do with it.
Annexure F, my lord, is the order passed by the panchayat. My lord, the respondent for the executive officer says that it is connected to civil proceeding. It's not so. I am seeking implementation of annexure F, my lord.
What we give them an opportunity to file their option.
They are not at all connected, my lord. For the
Are you
reason,
giving up your prayer?
prayer mail subsequent to point, they said, well, as
Willing to give up? We'll have to give them opportunity. Please don't make these kind of stuff.
because my lord, the obstruction is such a way that I am not in a position to pass on. My lord. That is a great difficulty. That is why my lord, that has to be removed first. My lord. Then let them file any other objection. They cannot simply issue an endorsement. Kindly look at the photograph. My 4 access has been closed. Annexure F ಅಲ್ಲಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ನೀವು ತೆರವು ಮಾಡಬೇಕು ಅನಧಿಕೃತವಾಗಿ ಕಟ್ಟಿದ್ದೀರಿ ಅಂತ 28 ಮೇಲೆ ರೆಸಲ್ಯೂಷನ್ ನಂಬರ್ 1 ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ annexure F page 28 resolution photograph ಮೇಲೆ kindly look at ಮೇಲೆ annexure N page 39 they put a permanent blockade by next to my door only brick ಹಾಕ್ಬಿಟ್ಟಿದೆ. This has been ordered to be removed now by the panchayat.
What has happened?
Now ಮೇಲೆ panchayat ಮೇಲೆ after passing their resolution they said
door is available.
I cannot go that side ಮೇಲೆ because it is this door is mine. After that ಮೇಲೆ after gate ಆಚೆ ಬದಿಯಲ್ಲಿ brick ಮಾಡಿ ಕಟ್ಟಿ ವಾಲ್ ಕಟ್ಟಿ
ಏನಿದೆ ಆ ಬದಿಯಲ್ಲಿ?
ಆ ಬದಿಯಿಂದ ನಂಗೆ ಟೆಂಪಲ್ ನನ್ನ ಇದು ಫಸ್ಟ್ ಫ್ಲೋರ್ ನನ್ನ ಮೆಟ್ಲಿಂದ ಕೆಳಗಿಳಿಲಿಕ್ಕೆ ದಾರಿ ಇದೆ. Their brothers, the panchayat I have said he has no access in my building. It's my building.
You have no access to go up.
No access to go there. This has to be removed because only for the purpose.
What is the resolution? Okay. What is that page 20?
Now, page F 28, they passed the resolution directing the respondent to remove that. Unauthorized blockade has been made. ಇದು ಮಾಡಿದ ನಂತರ ಪಂಚಾಯತ್ನವರು ನಾನು ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಒಪಿನಿಯನ್ ತಗೊಳ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರು. ಒಪಿನಿಯನ್
What is annexure M?
M is the endorsement issued by the respondent in the executive Taluk Panchayat stating that you issue an endorsement that it's a matter of civil in nature. It is completely giving a go by to their own resolution. There was first of all no necessity of asking any recommendation from the Jilla Panchayat.
Who built that wall and the...
Well, that is the contesting respondent who is none other than my brother. He is neither having ownership right or nothing.
Yes, but if he has built it, how can we ask them to remove it? They have to take action against your brother.
Well, that I have taken a complaint because this construction is made without obtaining license or whatever be the.
Who has constructed it, Mr. Acharya?
Well, this is my construct the third respondent.
So how can we direct them to do it?
Well, because
you and your brother are fighting. Don't thank the
because my lord, any kind of construction, if he has to make, he has to go to the authority and take a license, and then he has to do as.
We'll have to hear them. That council for respond number 1 and is granted 2 weeks time to file our objections. You are appearing for R2.
R1 and R2.
Ashok Naik, who is entered offense for respond number 2, undertakes to appear for respond number 1 also. Registry is directed to print his name as that. 6-4 and is granted 2 weeks time to file statement of objection. Objection to penny by 18th May, relist on 22nd May.
139. Nagaraj Arsi.
Filling certain documents as well as the rejoinder, the of objections filed. Matter pertains to the eviction of the petitioners from the Gandhi Bazaar market for its reconstruction.
Yes.
Here in the eviction is with respect to reallotment of shops in the new market. My lord. With regard, petition is filed.
If there is auction which is going to be carried out for you participate, and if you are successful, it will be.
That is all right, my. These people have been there from the times of their forefathers. I am not saying this. On that ground, I am not claiming any right, but equity, my lord, because they have established this since 1950s, and they have been carrying on. If all of a sudden they are made to close their shops,
it's not all of a sudden; it's after decades. You have been able to be there.
Very much depend on the business they are carrying on in the market. If at all they are.
That is being demolished.
Demolished, hardly we have no objections. But as done in the Jayanagar shopping complex, annexure E I have produced, which They have assured the shop owners there that new shops will be granted. We are not objecting for reconstruction at all, my lord. We will vacate the premises provided.
New shops will be granted subject to you participating in the auction.
Auction ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡೋದು ಬೇರೆ ಆಗುತ್ತೆ ಅಲ್ಲ ಆಕ್ಷನ್ ಅಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡೋಣ ಬಟ್ ಈಗ 50 ವರ್ಷದಿಂದ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ ಆಲ್ ಆಫ್ ಅ ಸಡನ್ ದೇ ಆರ್ ಮೇಡ್ ಟು ಶಿಫ್ಟ್ ಸಮ್ವೇರ್ ಎಲ್ಸ್ their clientele will be affected.
It's not somewhere else. Your lordship must find it out from the statement.
ಅಲ್ಲ ಸ್ವಾಮಿ ಈಗ ಟೆಂಪರರಿ ಶೆಡ್ಸ್ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲಿ they have put it on a bridge, my lord. They have constructed it on a road. It's on a bridge.
It's a Tagore circle. Avರೆಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
Which bridge have you constructed?
The bridge. Tagore circle adjacent to the
that is not a suitable place.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ್ರೆ ಕೊಟ್ಟಿದ್ದು ಇಷ್ಟಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿ
ನೋಡಿ ಸ್ವಾಮಿ
ಇನ್ಸ್ಪೆಕ್ಷನ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. I'm sorry.
Where is this constructed?
It is on a bridge. It is constructed on a bridge.
Which bridge?
Taswangudi hatra bridge ಇದೆ ಸ್ವಾಮಿ ಒಂದು ಅಂಡರ್ ಪಾಸ್ ಇದೆ ಅಂಡರ್ ಪಾಸ್ ಮೇಲೆ ಬ್ರಿಡ್ಜ್ ಮೇಲೆ ಕಟ್ಟಿದ್ದಾರೆ. Actually it is on the road. They have built them on the road without any basic amenities. ಆಮೇಲೆ ಅದು ಯಾವ ತರ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ we cannot keep any valuable security ಇಲ್ಲ ಏನು ಇಲ್ಲ. Easy road vehicle traffic ಎಲ್ಲ
there is no obligation on them to give you temporaries.
Obligation
making something available.
ಈಗ all of a sudden if I am made to stop my business, my lord, I will.
ಯಾವಾಗ ಸ್ಟಾಪ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ನಮ್ಗೆ ಆಲ್ಟರ್ನೇಟ್ ಅಕಾಮಿಡೇಷನ್ ಕೊಟ್ಟು
ನೀವು ನೋಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಆಲ್ಟರ್ನೇಟ್ ಅಕಾಮಿಡೇಷನ್.
ಆಗಲ್ಲ ಈಗ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದಾರೆ ಇಷ್ಟೊಂದು ದಿವಸದಿಂದ ಆಲ್ ಆಫ್ ಸಡನ್ ವ್ಯಾಪಾರ
ಆಲ್ ಆಫ್ ಸಡನ್ ಅಂದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ದಿನ ಬೇಕು?
ನಾವು ವೆಕೇಟ್ ಮಾಡ್ತೀವಿ ಈಗ ಬ್ರಿಡ್ಜ್ ಮೇಲೆ ಕಟ್ಟಿದ್ದಾರೆ ಟೆಂಪರರಿ ಶೆಡ್ಸ್.
ನೀವು ಇದು ಹೇಳ್ತೀರಾ ಅದು ಹೇಳ್ತೀರಾ, ಯು ಹ್ಯಾವ್ ಟು ಚೂಸ್ ಒನ್.
ಫಸ್ಟ್ ಮೆನ್ಷನ್ ವಿ ವಿಲ್ ವೆಕೇಟ್ ಶಿಫ್ಟ್ ಟು ದಿ ಟೆಂಪರರಿ ಶೆಡ್ಸ್. ಆಮೇಲೆ ಈಗ ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಆದ್ಮೇಲೆ ಇಫ್ ದೇ ಕ್ಯಾನ್ ರೀಲೊಕೇಟ್ ಅಸ್ ಇನ್ ದಿ ನ್ಯೂ ಬಿಲ್ಡಿಂಗ್.
That is why you are arguing for quantitative standard. First you say I'll shift to temporary, then you say temporary is not good enough. Then you say I'll come back here, but I won't participate in the auction.
Temporary sheds ಕಟ್ಟಿರೋದು ಯಾವ ತರ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Temporary sheds ಕಟ್ಟಿರೋದು they have.
You are ready to shift there.
Oh, we are ready to shift.
Then why argue on that if you are ready to shift?
It is not suitable ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. They have not taken care of.
You want to shift or you don't want to shift?
ಮಾಡ್ತೀವಿ ನಾವು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀವಿ.
Argument ಏನಕ್ಕೆ?
ಅಲ್ಲ it is not suitable for carrying on business somewhere else they can do ಅಂತ ಬ್ರಿಡ್ಜ್ ಮೇಲೆ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಎಲ್ಲಿ somewhere else ಹೇಳಿ, ಎಲ್ಲಿದೆ ಜಾಗ?
Vacant site belonging to BBMP they can.
Where is the vacant site belonging to?
ರೋಡ್ ಮೇಲೆ ಇದೆ ಸ್ವಾಮಿ, ರೋಡ್ ಮೇಲೆ ಇದೆ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ನೀವು ತೋರಿಸಿ ಅವ್ರಿಗೆ ಎಲ್ಲಿದೆ ಅಂತ. Where is the vacant site?
ಅದಕ್ಕೆ ಈಗ ಸಿಚುವೇಶನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
You shift there, you participate in the auction. Otherwise you
auction ಅಲ್ಲ ಈಗ because ಈಗ ಅವ್ರಿಗೆ ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ರೆ ಈಗ ನೋಡಿ next
you can't ask them to violate the provision.
ಈಗ
has to be by way of
shopping complex ಅಲ್ಲಿ ಕೊಟ್ಟಿದಾರಲ್ಲ ಸರ್, ಜಯನಗರ ಶಾಪಿಂಗ್ ಕಾಂಪ್ಲೆಕ್ಸ್ they have done, they have even
provision they gave it and the particular officer is facing the consequences for the Lokayukta court.
Lokayukta only produced the order sheet in my rejoinder. That Lokayukta investigation is only with respect to 11 shops. 11 shops were not given without auction. They have previously who were
there cannot be allotment of shops without auction. Say government property, it's not a private
property there. But in similar situation, Supreme Court has even considered these things. Lord, I will give judgment of.
Supreme Court has said everything has to be by auction.
Transparency Act. We have to make auction.
Last paragraph ಅಲ್ಲಿ clear ಆಗಿದೆ. Last paragraph of judgment. Last paragraph. We've seen that the applicant has been last paragraph 16 on page 16. We've seen that the applicant has been in possession of as tenant for well over half a century and therefore it is injuriously
the 142 order. We don't have that power. We don't have the powers under the as the Supreme Court has to do it. It is in order to do justice in the matter.
In another judgment, my lord, another judgment. in this judgment, High Court itself has granted such a relief. Para 39 is that, wherein the Supreme Court has upheld that. Head note also I am permitted to read. Last
Where
head
has
note-
High Court done that?
Hence, the respondents, particularly last head note, my lord. Hence, the respondents, particularly municipal corporation, directed to implement the High Court directions within parameters of the statutory provisions, considering the interest of general public and the shopkeepers of the existing market. Further directed as soon as construction up to ground floor level is completed, along with required parking facilities at basement level, those shops are to be allotted to all shopkeepers within a period of 6 months. This was the High Court order which has been upheld by the Supreme Court.
In the meanwhile, the municipal corporation shall auction the shops which shall not be finalized. Auction ಆಗಿದೆ ಇದರಲ್ಲಿ.
Auction ಆಗಿದೆ, other shops. ಈಗ ಇಲ್ಲಿ 37, initially there are 37 shops. ಈಗ they are constructing almost double than that. 37 shops may be reserved for the
Participate in the auction.
some auctional ಮಾಡಿದ್ರೆ we will not be able to compete with the others. ಈ judgment ಪ್ರಕಾರ even they have considered the
Again, last time you said you have no place to shift. So we asked them to see if the arrangement could be made. That has been made.
Temporary shed ಹೋಗ್ತೀವಿ. How long can we stay there after construction? At least ಈ judgment ಪ್ರಕಾರ there is a
After construction, you participate in the auction.
auctionally I cannot participate with the others because compete ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. We have been in this place for such a long time.
That we
All of a sudden ಈಗ we'll have to close the business. ನಾವು ಈಗೆಲ್ಲ ಶಿಫ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತಾರೆ ಆಗಲ್ಲ. ಅದಕ್ಕೆ for that ground only, even in this judgment, High Court itself has directed them to reconsider, and they have done it already in the case of Jayanagar shopping complex. That's why I request this honorable court to kindly consider.
Whenever you have done that, Mr. Jagdish.
No. What was transmitted so far as Gandhi, the general shopping is concerned, some official has given letter, re-allotment of the same shop after construction. And the public at large, they filed a complaint before the Lokayukta. Now that particular officer was kept under suspension, he was facing the consequences before the Lokayukta. Under the act, there is no provision to allot the same property after constructing the
So you're
shop.
not even.
We are not allotting any shop to the purpose of an occupation. What we did is, we construct the shops as per the plan, and we will open for tender in under the Transparency Act. If any person, if entitled, if they make action, will be successful, we will allow the particular person to occupy. Not beyond that.
Only thing you could do was temporary, this one which they have done now. That we are directed. They have done.
Even ನಮ್ಮ grievance still have.
Even rents ಕೊಟ್ಟಿಲ್ಲ ಒಬ್ಬೊಬ್ಬರದ್ದು rents ಲಕ್ಷ ಬಾಡಿಗೆಗಳು.
Subject payment of all the areas, your lordship may.
Actually by auction.
Consider, hello sir. Auction ಮಾಡಿದ್ರೆ these people will not be able to. And also that
is before this court.
Article 21, violate Article 21 of the Constitution.
We'll deal with that also. Petitions are before this court seeking for the following reliefs.
I am permitted to read Article 38.
Yes, yearly, Constitution. $38 million.
38, state to secure a social order for the promotion of welfare of the people.
Yes.
The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Clearly says that they have to protect Article 49 also, my lord. They are duty bound to protect social order. If at this stage.
49 is monument.
Protection of monument, no, 48, my lord.
Agriculture and animal husbandry.
Animal husbandry and modern scientific lines shall protect. No, 47, my lord. Sorry, 47. Duty of the state to raise the level of nutrition and the standard of living and to improve public health. If at this stage we are attained certain stage, my lord, after working hard, we are earning, eking out small sums and carrying on our livelihood. If we are displaced from the place there, we have to start from the scratch. Again, we have to go somewhere else and restart the business. We have developed a clientele in this area.
So no tenant can be evicted at all if we accept your suggestion.
Now eviction anta helta illa. Give us preference because we have been there since long.
Participate in the auction. That's it.
Participate.
No way of determining the cost.
Compete with the general public because our economy.
Public money is going to be spent on construction of this, Mr. Nagaraj. The money has to be recovered in some way. It is not practice.
Whatever it is, because even so civil court we had filed appeal, we have succeeded there because the civil court, whatever the penalty they had put on us, it is reduced to 1/3 of what they had, and we have paid all that. Subject to we paying the entire arrears, this court may kindly give a preference. Both the Supreme Court judges.
Which is a provision of law that could be just not there.
Under BBMP 137 also.
Can only empathize with you. You'll have to follow the law.
107 even there is a mention of social justice. Section 107 of the BBMP
It's
Act.
not social justice.
Because these people are going to stop their business all of a sudden. They have to start again.
That doesn't give.
107 will clear again.
Been there for decades now.
Decades ಇದೆ ಅದಕ್ಕೆ our clientele is there in that area.
If your clientele is so good in that area, please participate in the auction. That liberty will reserve. You don't need the liberty.
Liberty, just something above the general public. Whatever ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
Policy decision. We can't decide. It's not within our.
That judgment which I gave to your lordship that clearly mentions that is a high court order wherein it is upheld by the Supreme Court.
That was auction, Mr. Nagaraj.
Some auction Auction is kindly keep para 39 relates to old para 39 of the judgment. Rakesh Sharma and others versus State of Madhya Pradesh. ಇದರಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ. Against that, some of the shopkeepers had gone to Supreme Court.
That was by consent of the corporation.
39 ನೋಡಿ.
It was by consent of the corporation at that time. Now even they cannot consent.
The High Court on the basis of the consensus of the parties, more particularly with consent of the shopkeepers, a committee was appointed and direction was issued providing an alternate place to the shopkeepers till new construction be completed the existing place, and all of them were assured accommodation in the ground floor of the new market complex. This case also they have granted.
That was a committee appointed by the corporation also consented.
They can give, my lord. There is no bar for them to. Under these circumstances,
there is no provision for them to consent now, Mr. Nagaraj. Now they have to follow the Transparency Act. Transparency Act has come into force, and now everything is to Transparency Act. Nobody can do anything contrary to that. That is the check and balance that has been imposed on the state.
That is there, my lord. But still under your lordship's power under 226.
We cannot. At first, we don't have under 226 to say. Violate the Transparency Act and violate who is going to fix what is the cost for you? Cannot be fixed like that. You have had enough of time.
But subsequently.
Each dinner you have enjoyed at a lower rate. Now your clients will have to do.
Market rate we are ready to.
Market rate will be determined by auction.
Also some preference to these people.
The liberty beko bird.
Liberty and the beke.
Petitioner is before this court seeking for the following relief. The petitioners claim to be small-time businessmen, so women running shops at the Gandhi Bazaar market owned by the first respondent, Growth Bangalore Mahanagar Palika bracket BBMP. The petitioner claimed to be running their businesses in the said market for several decades and have been making payment of the due license fees to the BBMP on a regular basis. By way of notice dated 22/2/2023, the BBMP had asked the petitioners to vacate the premises on the ground that the existing market, being in a bad condition, is required to be demolished and rebuilt under the Bangalore Smart City program. And it is in pursuance thereof that the dilapidated building was proposed to be demolished. The petitioners before this court agreed by such demand caused for vacating the premises. Firstly, on the ground that the petitioners who have been occupying the premises for several decades would now be displaced, and as such they'll lose their source of living. Furthermore, it is contended that there is no alternate space which has been made available to the petitioner to carry on their business during the time when the building is proposed to be constructed. Insofar as it is further contended that once the building is constructed, similar or identical premises as that in occupation of the petitioner be allotted to the petitioners on market rate. In this regard, reliance is placed on a letter said to have been addressed by an officer of the corporation as regards the Jayanagar, officer of the BBMP as regards the Jayanagara shopping complex.
Second respondent has.
Wherein the promise made by the second respondent that ordinate space would be, suitable space would be allotted after the building is constructed. On all the opposite grounds, the opposite relief is sought for. The NR Jagdishwara Learned Council appearing for the BBMP would firstly submit that insofar as Jayanagara shopping complex is concerned, there was no letter which had been issued. The letter claimed to have been claimed by the petitioner to have been issued is without authorization. The person who had issued this said letter has been placed under suspension, and there is an inquiry initiated by the Honorable Lokayukta.
And he is facing a case before the local.
He further submits that this said letter is not being acted upon, and all the shop owners, shop licensees in the Jayanagara shopping complex have been.
Sorry, Manoj. Case is a PIL filed by one person that is dealing before the first court. In that case, there was a dispute regarding allotment of 11 shops without auction. And the Honorable High Court was.
On this letter, he is submitting that
No,
letter.
Lord, I have produced the order copy, entire order sheet, rejoinder, that is PIL which was filed.
That's in respect of other parallel proceedings because the irregularities insofar general shopping concerned. PL is concerned in respect of other 11 shops.
What is?
Insofar the letter issued to the
But no,
next
no documents are placed regarding this. Only submission.
even otherwise, my lord, there is no provision under that to allot the shop in the same premises to the tenants.
He was saying something different.
Lokayukta. The said letter not being acted upon, the petitioners also cannot seek for allotment of an alternate shop on construction without going through the process of auction. As regards alternate accommodation, he submits that a temporary alternate accommodation has been made, which the petitioner can make use of till the building is complete. And once the building is complete, the petitioners can participate in the auction, and if successful, the newly constructed shop would be allotted to the petitioner. If not successful, they would also have to vacate the temporary structure which has been built.
And there is no lease and license as on today to the petitioners are concerned.
Till the building is completed, you won't disturb them. Till the new building is
Temporary structure ಏನು ಮಾಡೋದಿಲ್ಲ.
new building is completed and auction is carried out, you won't disturb.
In such thing, you won't touch the temporary structures.
The submission is that until the new building is constructed and the auction completed, the petitioners will not be disturbed. In the will be permitted to carry out their business in the temporary alternate accommodation, and that their possession and or business will not be disturbed.
Subject to payment of arrears, because
subject to payment of necessary. Have you fixed the license fees?
No license as on today.
Temporary license fee fixed.
Continue ಆಗ್ತಾ ಇದಾರಲ್ಲ, ಇದುವರೆಗೂ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ.
ಇದು ಬೇರೆ same rate ಅಲ್ಲಿ continue ಆಗುತ್ತೆ. How can you continue the same thing for temporary? That was a shop.
Arrears ನಾನು ಹೇಳ್ತೇನೆ. I am making some arrears is concerned.
Going forward ಏನು ಕೊಡೋದು ಬೇಕಾಗಿಲ್ವಾ?
ಅದಕ್ಕೂ ಕಟ್ಟಬೇಕು.
ಎಷ್ಟು?
ಅದನ್ನ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ. It's a temporary structure.
ಡಿಸೈಡ್ ಮಾಡಿ ಹೇಳ್ಬೇಕಲ್ಲ ನೀವು ಅವ್ರಿಗೆ. ಎಷ್ಟು ಅಂತ.
ಇಲ್ಲಿ ಈಗ ಏನು ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್, ಡೆವಲಪ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಅದಕ್ಕಿಂತ ದೊಡ್ಡ ಶಾಪ್ಸ್ ಇದೆ. ಶಾಪ್ಸ್ ದೊಡ್ಡದಿದೆ. ಪ್ಲೇಸ್ ಅದೇ ಪ್ಲೇಸ್, ಬೇರೆ ದೂರ ಏನಿಲ್ಲ.
ಬಟ್ ಎಷ್ಟು ದುಡ್ಡು ಕೊಡಬೇಕು ಅಷ್ಟೇ. How much is the payment?
That will be decided by the concerned department.
Then that is another litigation.
In ಜಾಸ್ತಿನೇ ಮಾಡ್ಲಿಕ್ಕಿಲ್ಲ, because it's temporary structure. Almost it may take 1 year or 1.5 years also. Commercial complex.
1.5 year ಕಟ್ಟಿದ್ರೆ 9 months ಅಲ್ಲಿ ಬಿದ್ದೋಗುತ್ತೆ.
ಅಲ್ಲ, ಬಾರಿ ದೊಡ್ಡ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲ ಗಾಂಧಿ ಬಜಾರ್.
What would be the license fee to be paid?
I have to ascertain with the concerned officers.
Subject to the arrears of the license fee being paid and the license fee on a monthly basis being paid as regards the temporary accommodation, which license fee submit would not be more than what is already being paid till date. Submissions are placed. The third question that would arise is whether to consideration is whether the tenant of a municipal corporation can claim equity on the basis of long-standing usage of the premises, so as to be allotted a shop in the newly constructed building without going through the process of auction. Admittedly, the petitioners are businessmen or businesswomen carrying on their business at Gandhi Bazaar market for several decades. The said building being dilapidated and being required to be demolished is also not in dispute. Once the building is dilapidated and required to be demolished, in the interest of the general public as also the shopkeepers, the shop owners or shop licensees cannot have any ground not to vacate the premises. Alternative arrangement has been made by providing temporary shops by the BBMP. The petitioners are willing to make use of it. But however, the only condition put forth by Mr. Nagaraj, the counsel for the petitioner, is that once the building is completed, the same may be allotted to the petitioner without following the auction process. The Transparency Act. In terms of Section 4 of the Transparency So-and-so Act, it is required for any governmental authority to auction any property of the government, as also to invite bids in the, from the general public in case of a tender. Since this is required in order to ascertain the value of the property and or the value of the tender on the basis of public participation. The property belonging to the BBMP, in the event of any fresh allotment to be made after construction of the building by using public funds, it would but be required that the same be auctioned and the highest bidder be allotted the particular shop. The petitioners, merely because they are using the premises of the BBMP for several decades, cannot automatically seek for allotment of the property with allotment of a shop without going through the process of auction. The contention of the counsel for Sri Nagaraj, counsel for the petitioner, that a goodwill being established at the current location, the petitioners, if were to be displaced, will have to start afresh. In my opinion, cannot be a ground, since the auction is always available to the petitioner to participate in the auction. Towards this, the submission of Sri Nagaraj that the petitioners, being small businessmen and women, they may not be able to participate in the auction, cannot be a ground for direct allotment to the petitioner, since the property in question is a public property and the same cannot be dealt with by the corporation at its whims and fancies and or without following the principles of Transparency Act by bringing the same for auction. Needless to say that the petitioners would be at liberty to participate in the said auction. And until the said auction is completed, the petitioner's business being carried on in the temporary accommodation would not be disturbed as per the submission made by Sri N.R. Jagdishwara. In that view of the matter, I pass the following order. The petition stands dismissed. Liberty is reserved to the petitioner to participate in the auction carried out. Until the auction is carried out and or the building is until the building is complete and auction is carried out, the petitioner shall not be disturbed from the temporary accommodation, subject to payment of past dues and future license fees.
Serial number 38.
So please pay.
Respondents have developed a portion of park in the property belonging to the petitioner. Petitioner has bought the property in the year 2010, my lord, from the erstwhile owner, one Sunita Sharma. Without any,
yes,
not following any. No, madam. It was a vacant land, madam, and it is situated next to the park. Might be on our side, they have enclosed all the property belonging to the petitioner. Previously, my lord, in the year 2000,
let them give their finding. And AG accepts notice for respond number 1. Sri Pawan Kumar accepts notice for respond number 2 to 4. He seeks for and is granted 3 weeks time to file his objection.
It was maybe
Is already constructed. How do we get status?
The portion of the property where it has.
There is already a construction. If there is status quo, that will remain like that.
They have put up the fence, my lord. Now they are likely to put up a structure over the portion of the.
They are trying to put up any construction.
Please, my lord. Annexure F2, my
lord. Is granted 3 weeks time to file his statement of objection. Objection is pending by 18th, relist and 23rd. Until then, the respondents are restrained from putting up any construction on the petition scheduled property.
File your question. Day onwards, because already some construction happened.
If not already.
Section G.
Yes.
Please cease before the Karnataka appellate tribunal. Next year G may continue. Page 63, please.
Next year G.
G.
Page
63, please. Order.
demolition order after 321 is complied.
Please. Not this reference. Tatkalik Adesha Sankhya so and so dated 29/6/2019. And the Pirikarana Adesh Sankhya is the final order, the confirmation order. Now, this matter is before the CH-18 order. The stay is in operation.
Stay, then they can't demolish.
Matter is already under High Court, Chief Justice Madam. Not passed by this under High Court. That demolition. I'm the owner of the property.
Can't be demolished. The stay will have to be vacated first.
Way back in the 2020 itself, there is a same law that it has to demolish.
No, don't listen.
Last 5 years.
We direct the second, explain to the court why an action in this is not being initiated.
Till that they have not taken any action, madam. We have
So they will stay there.
ಅಲ್ಲ ಅದರಲ್ಲಿ as regards KT step ಬಿಟ್ಬಿಟ್ಟಿದ್ದೇನೆ ಉಳಿಕೆ ಏನಿದೆ ಅಂದ್ರೆ 4th floor 5th floor ಅಂತ ಏನಿದೆ ಅದನ್ನ ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಅಂತ ಹೊಟ್ಟಿದ್ದಾರೆ ಐ ಮೀನ್ ಕಂಟಿನ್ಯೂಸ್ ಪರ್ಸಿಂಗ್ ವಿತ್ ದಿ ಅಥಾರಿಟಿ ಟು
KT ಅಲ್ಲಿ ಏನಂತ stay ಇದೆ?
ಯಾವುದು ಕಾನೂನಾತ್ಮಕವಾಗಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ಟಚ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ we are not asking for that.
Where is the KT stay? Where is the order of the KT?
Yes, I have produced. Order sheet. You not would find it at page 42, annexure F. Now, page 46, my lord, would find it. 46.
Till ground first and second.
Yes, third floor.
So above third floor is not applicable.
It is not there. My lord, I have not submitted anything before your lordship. And it is, and until further orders, it is extended now. Appeal is still pending.
So now the demolition is for which portion?
No.
4th and 5th floor.
ಎಲ್ಲಿದೆ ಹಂಗಂತ ಮಿಸ್ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಬಾರ್ದು.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಇದರದ್ದು 321 ತೆಗೀರಿ 321 ನೋಟಿಸ್ ತೆಗೀರಿ ಅಲ್ಲ ಐ ಮೀನ್ ಓನರ್ ಐ ಆಮ್ ನಾಟ್ ಬೀನ್ ಅರೆಡ್ as a party.
Clarify it is above the third floor.
ಹೌದು.
One submission. Kindly take the notice which I have challenged before your lordship.
Mr.
My lord, annexure G.
Your order is only up to third floor. Have you put up any construction above third floor?
My lord, I do concede for a moment that my lord, there was a construction.
The moment alla. Construction idre forever.
Lord, I have produced not even the photographs.
Have you constructed above third floor?
Please.
It is not protected by this order.
Lord, may I make one submission? The order which is sought to be executed by the second respondent hearing is challenged before the KAT and it is pending consideration. But it may go either way, on technicalities, on merits. My respectful submission is, had it been the annexure which I have challenged before your lordship at annexure G may kindly be. It does not say anything that the demolition order or an action to be executed above 4th or 5th floor. What it says is, my lord, he refers the very order of the original order as well as the confirmation order. Yes. If I am not wrong, my lord, he refers to the provisional order as well as the confirmation order, which is, my lord, factually said by the gate.
Till the third floor.
Till third floor. And, my lord, the appeal is still pending. It is not, it is, my lord, settled for final.
The plan sanction is till which floor?
Till the third floor. Therefore, my lord, my respect.
So we'll clarify that they can't do anything below third floor. Third floor and below.
To that extent, this order already before KT, madam.
Above third floor,
Ashad.
you are not protected because your plan sanction itself is not for.
The annexure can be.
Yes.
I mean, what he says is, he does not specify anything regarding that.
We will specify it now, Mr. Hegde. ಅಷ್ಟು ಮಾಡಬಹುದಾಯ್ತು.
What
4 years.
subject to my lord's kindly. Now, suppose I'm not intervening anything. This was subject in the evening. On technicalities on this. I have produced all the documents before me. For some reason, the matter before the KAT gets the order of the second respondent and the first respondent gets squashed and matter is remitted back for fresh disposal according to law, irrespective of this order. But in the event, any demolition takes place as of now.
That is why you had the option to ask for stay. Stay is limited. So beyond that, you can't ask for it. Your plan sanction is only up to 3rd floor. There is no way that you can ask for construction beyond that.
But now that, see, my lord, on the guise of my lord doing anything, if the whole building is damaged by the respondent authority, I'll be put to.
So ನೀವೇ demolish ಮಾಡ್ತೀರಾ? Option is yours. ಅವ್ರು demolish ಮಾಡಿದ್ರೆ ಒಂದು ಬಿಲ್ಲು ಕೊಡ್ತಾರೆ ಅದ್ರ ಜೊತೆ ದೊಡ್ಡ ಬಿಲ್.
Appeal before the KAT is at the fag end. It is second form.
That cannot be a ground. There's a direction by the division bench also on that.
And
that has to be complied. You can't.
ಅದರಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದಾರಂತ. I'm not notified, not to be fair. And it is still pending. That's what my learned friend said. And it is for the lookout of the second respondent. There is that what action he has taken. He would have brought it to the notice of this honorable court. That
And sanction is only for 3rd floor, Mr. Hegde. That's it. The Kumar accept notice to respond now. Who are you?
I'm the owner. I have
given a party.
he is not a party at all.
He is deliberately
argument to
he is not deliberately made me party, my lord. If at all, ನನಗೆ 110 application ಆಗ permission ಗೆ ಕೇಳಕ್ಕೆ ಬಂದೆ.
You are the owner of
the property, my lord, which has been developed by the petition number 1.
You are a tenant.
No. Developer. No, there is not only.
This is the petition from there 2012, my lord, and I've
termination case. OS is there, KAT is there. No, everywhere, wherever I go, he follows me.
You can't build like this. You have to build as per the plan sanction. Is that you take?
Great respect, my lord. It is not as if subsequently after obtaining this stay, my lord, I have put up. By that time, it was when the construction was over. But of course, irrespective of the fact that the wrong is a wrong. Not that, my lord, my only submission before your lordship is, my lord, till the time, my lord, the KAT decides, my lord, it is at the fag end. At any time, it won't be disposed of. The reason why my humble request is, my lord, this once he himself is a party to the appeal. The second respondent who issued this annexure fee, my lord, he is a party before the KAT also. Since this is an executable order, the KAT has stayed this order specifically saying that, Lord, having regard to the fact that even the sanction plan was before the appellate tribunal.
If I'm permitted to submit, my lord, two such submissions.
From 1/9/2020, you have been asking for and obtaining adjournment.
Yes, my lord, that is my submission.
ಇಲ್ಲ may I make one submission. ಇಲ್ಲಿ quorum ಇರೋದಿಲ್ಲ. ಇಬ್ರು ಜಡ್ಜಸ್ ಇರಬೇಕು. ಇದು ಹಿಯರಿಂಗ್ ಇದೆ.
ಫೈನಲಿ ಅಂತ ಕೊಡ್ತಿದ್ದಾರೆ.
ಇಲ್ಲ once ನಾನು ಒಂದ್ ಸತಿ ಟೈಮ್ ಕೇಳಿದ್ದೀನಿ. ಅದು ಆದಮೇಲೆ quorum ಇರಲ್ಲ. Not at me. Now also, ಅಲ್ಲಿ ಸಿಟ್ಟಿಂಗ್ ಏನಂತ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ತಗೋತಾರೆ. ದೇ ಇಬ್ರು ಸೈನ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ quorum ಇದೆ. I have produced the typed copy also.
Directly expeditious disposal of the appeal before the case.
Yes, sir.
One day signature.
Please, sir. But ಇದರಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದರದ್ದು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಿರೋದು.
Not a party.
Please, I'll leave it to court.
Petitioner is before this court seeking, Pawan Kumar accept notice for response. Petitioner is before this court seeking for the following. The grievance of the petitioner is that while the proceedings challenging the 321 and 321(2) and 321(3) orders are pending before the Karnataka Appellate Tribunal in appeal number 801 of 2019. And a interim stay has been passed insofar as the construction until the third floor is concerned. The respondent have issued a demolition order on 11/3/2022, followed up with the final notice dated 17/10/2022, informing the petitioner that the construction would be demolished. The submission is that the orders passed under 321(1), 2, and 3 being under challenge before the KAT. In the event of the petitioners were successful in the said matter, the demolition, if effected, will be irreversible and the interest of the petitioner would suffer. Heard so and so. A perusal of the appeal memo in appeal number 801 of 2019, as also the order sheet, indicates that the above proceedings are pending and the matter is now at the stage of arguments. If that be so, the said matter being in the final stage, interest of justice, in my considered opinion, will be sought by directing the Karnataka Appellate Tribunal to dispose of the matter at the earliest. And thereafter, in the event of the petitioner being unsuccessful, the corporation could take necessary action. In that view of the matter, I pass the following matter. Petition is partly allowed. The notice dated 17/10/2022 at Annexure G is suspended till the finalization of, till the final order is passed in appeal number 801 of 2019 by the Karnataka Appellate Tribunal. The Karnataka Appellate Tribunal is directed to dispose of the said matter
As regards that, division bench order is concerned.
as expeditiously as possible, at any rate within a period of 3 months from the date of receipt of a copy of this order.
Number 52. Harish Kumar Endra, sir, corrected.
There are three petitions in respect of the same property. Third round of litigation. Lord, admittedly, the land, the building, which is there on 20 cents. Lord, earlier it was belonging to the Giant family. Yes. In a partition which took place in the year 1964, my lord.
You have filed one matter. Ajay Prabhu has filed.
Yes, my lord.
Yep. Mr. Egde, you have filed one.
Yes, yes.
There is an affidavit to be filed by
Yes, my lord.
Yes,
My matter was posted, my lord. There was a direction to repair the building. Instead of repairing, my lord, he has taken steps to demolish the building. Then, my lord, this court has directed to file a affidavit, my lord.
It is not in.
No, my lord, he has removed entire roof, my lord. Monsoon is entering, my lord, at any time.
My lord,
What will
me make my submission, my lord. The affidavit was filed. Was asked to file, my lord, stating that if at all I am repairing, I should not demolish the building. My lord, I am aggrieved by the order of the corporation, wherein, my lord, earlier I have filed a representation stating that the building is 100 years old, it is in dilapidated condition, it has to be demolished. The problem is that 20 cents is the building. Out of that, the petitioner is owner of 17.5 cents. The respondent number 2 is the owner of 2.5 cents. My lord, in this regard, the corporation directed the expert to give an opinion. The Suratkal, my lord, that college, they have been appointed and they have given the report stating that it is 100-year-old and it is in dangerous condition, it has to be demolished. In the meanwhile, earlier he filed a suit for injunction, seeking not to interfere and not to demolish the building. That was dismissed, against which appeal came to be filed. Appeal was allowed with a direction to get a report from a special expert. And thereafter,
You have to file an affidavit. Are you going to file the affidavit?
My lord,
Without filing the affidavit, if you don't file it, adverse inference on that.
my lord, I will make a submission for what reason it has been said and what I have done afterwards.
You filing or
My
not?
lord, if I'm not going to repair, that is the reason was that if at all I am repairing the building, then, my lord, I have to file an affidavit stating that I will not demolish. Then, my lord, I have filed a writ petition challenging the order of the corporation, stating that I will not repair because if I am going to repair, it is certainly going to fall in. That is the condition. That is the reason I have stated that the order of the corporation directing the parties to repair is not correct. Then, my lord, I made a submission.
Are you filing an affidavit, Mr. Harish, or no?
I will file, my lord, I will file affidavit stating that I will not repair. And there is no question of demolition by myself. The point was that if at all, their allegation is that on the guise of repairing the building, I am demolishing the. That I said, I am not even going to repair it.
File an affidavit.
That I will file it.
That's all.
No, what happened, my lord, that I made a submission before this honorable court, and also I gave an offer to settle it out of the court. On that day, my lord, I have made a statement that, my lord, I will construct the entire building and I will give their share. 2.5.
Your cost.
Yes, my lord, I have made that. That is the reason, my lord, the matter was sent to the arbitration for mediation before the man. We tried to convince them. Despite that, my lord, they did not turn up and once, and thereafter they said that they are not interested. So the matter has come up. And I will file an affidavit stating that I will not repair the building, so that there is no question of demolition by myself. But the condition is in such a fashion, nature.
You file your affidavit.
Yes,
also
my lord.
make your offer.
I have made it.
Put it in the affidavit also.
Yes, my lord, I'll do it.
That you will construct it.
Yes.
Now, my lord, they removed the entire roof, my lord, then it is not going to repair it, fix the roof. Let them, my lord, allow us to put the roof, otherwise, rainy season.
Where has he removed it? When has he removed it?
Annexure L, my lord, in page 18, I lost my
Petition.
on.
In which petition?
Yes, my lord, third one, my lord, petition number 26165.
Annexure?
Annexure L in page 89. 89. Second picture is removed entire roof. Now we are repairing, my lord, is not allowing to repair. The police says, my lord, unless we got a protection order, we can't help it. Then corporation says, we pass the order, my lord, we
Who
can't.
has removed this roof?
He only.
No, man, I have. Kindly see the photographs. It
Who has
was.
removed it? You have not removed it.
No, we have not. Kindly see the two reports, my lord. The photographs taken at that stage. It is in the year.
No.
Mr. Bhandari,
Kindly see.
either you have to remove or Mr. Bhandari has to remove.
My lord, the two reports.
Where's Mr. Bhandari? What is the report?
My lord, two
What is the
reports.
prior to disposal of the
Kindly see the
report,
photographs.
2021. Now, before passing the order,
One is-
fresh opinion was sought by the technical.
My lord, even in
person,
the,
on the basis of the report of the technical person, my lord, this order actually was passed.
in the suit also, at the.
This was on 13/9/21.
Yes, my lord.
Now, if we look at this photograph, the roof was in existence.
My lord, in kindly see the 22 photographs, and thereafter, my lord, there was a heavy rain. That was the reason, my lord, we continuously before the court.
Even in 22, roof was in existence.
Yes, my lord, thereafter there was a rain.
Passing order, any share they removed.
There was
We
an
filed a
order.
complaint.
There was an order to repair it. Then we went there. Immediately on that day only complaint came to be filed. Then we stopped it and we gave a representation to the corporation stating that we are not going to repair.
Sorry, have you removed the roof? Roof ನೀವು remove ಮಾಡಿದ್ದೀರಾ?
ನಾವು ಮಾಡಿದಲ್ಲ.
So only you are left out, Mr.
My lord, kindly see
Nobody else will remove.
kindly see, my lord, my representation dated 5/1/2023. When this order came to be passed, my lord, even they tried to repair it and we tried to repair it. At that stage, my lord, again there was a disturbance. Then we decided not to, because, my lord, if we are going to repair it, it is going to fall down. So the situation is such a bad that even the report says so.
That doesn't mean that you take the law in your hand
My lord,
and remove this.
My lord, I am not removing it. To repair it also, if we.
So who are the people found in these photographs?
Yeah.
Who are the people found in
They are all
L1,
experts.
L4, L5?
Kindly see the
We are
memo
not
along with my recommendation.
Who are you for, Mr.
I'm tenant.
He is also one of the tenant in that building.
You don't want them.
Want demolition.
You want them.
Filed suit against.
That is why you are standing on this side. Mr. Harish.
Tenants are 6 tenants out of 6 and 3 tenants, my lord. Now 3 tenants are there.
You were asked to file an affidavit.
Yes, my lord, certainly.
And you are removing the.
My lord, kindly see the photographs of the present photographs and the condition of the building, even to me, repair it also. If we go there, my lord, there is a chance of.
Asked you to remove it, Mr.
My lord, I'm not, what has to be repaired, my lord, that everything has to be removed and they have to be put.
Remove the roof, please. We are asking you the last time.
My lord, the removal of the roof, my lord, it is not done by us. That is what our contention is, that even to, while removing, when repairing, also there is a chance of falling everything down. That was the condition. Kindly see the report given in the year 2021. The upstairs was in such a.
You are trying to abuse the process of.
Certainly not, my lord. My lord, kindly see.
Remove the thing and now you want to take the advantage that it cannot be repaired.
My lord, it has to be repaired. It has to be.
You repair it without the building falling.
My lord, that I have to verify, my lord, that who has done, because my representation, my kindly within 5 and 2.
You removed it without asking anybody. Now you put it back in directions.
But that I'll verify with my client, my lord.
No verification, Mr.
My lord, kindly my representation.
Verification from your client.
My lord, earlier.
You have the audacity to remove this while the matter is pending in 2 other petitions. And
my lord,
now you want to take advantage of.
No, my lord. The upstairs condition is such a bad, my lord. Kindly see the earlier writ petition order.
That does not authorize you to remove.
My lord, on its own, my lord, it is falling down. That is the condition. My lord, 100-year-old building.
Harish, there must be a limit to your submissions.
My lord,
if you are going to be making false submissions one after the other.
Sorry, my lord, I am not making such.
There are people removing it in the photographs.
My lord, there are employees. I don't know whose employees. Even if it is my employees, my lord, that's something. Then, my lord, only once we went there to repair it. Immediately, complaint came to be filed. Then we filed a representation. We did not repair the building at all. Now, my lord, they have come to repair it. Then we filed a complaint stating that matter is pending before the.
Direct the state to file a complaint and take action against the people found in the photographs. We can do that also.
No, certainly, my lord, the court has got power.
And if you continue to make.
My lord, I will.
False.
My lord, if at all it has to be replaced, that will be done. We are not. My lord, kindly see my representation on 5/1/2000.
We are not concerned with your representative. We are concerned with your action.
My lord,
speak loudly.
My lord, when the commissioner has passed the order that it has to be repaired, my lord, we try to do that. My lord, when we went there and the work has started, complaint came to be filed. My lord, what intention they have done, whether it has been removed or whether it was removed with an intention to replace it with proper manner, that's a different. But we stopped there itself because the complaint came to be filed by the other side.
So you stopped there itself, you removed it.
That will be done.
You removed it.
That will be done. My lord, I'll ask them to put it. But the fact remains that, my lord, it will not.
After that later. First you do that.
Certainly.
The contention of Sri Proceedings Learned Council is that the roof of the building has been removed while the dispute between the petitioner and the respondent was remaining to be adjudicated. His further submission is by way of removal of the roof, the petitioner in WP number 26165 of 2022 was put to a detrimental position. The contention of the petitioner is that the petitioner has not, again, petitioner has removed or not removed?
My lord, they went to repair it. That is there on record. But I'm not sure to.
Please decide. Removed or not removed. On that basis, we will dictate.
My lord, I have to ask my client whether they so, my lord.
Making vociferous submissions from that time, so you could have that basic.
No, with that, my lord, they said that they went to repair it.
So find out from your client and make that submission. We will come to that later. And be very careful what submission you will make.
Certain.
For the petitioner, Your Honor, the matter relating to demand of the BBMP regards to plan, wherein it relates to the
sanction of plan.
How the sanction of plans. Referring to betterment charges and several other matters. There are several other matters have been.
AG access notice for respond number 1 to 3, Pawan Kumar access notice for respond number 4 and 5. Table. All the labor
Next year,
table on them. And issuance of plan section.
plan checks. And commencement certificate.
Connect with so and so and released on 2/6.
Great.
So Puneet Kumar.
Preparing for petition level. C and annexure J. Annexure B, readable.
Annexure C.
Objection may be over. Is at page number 10.
There is no office objection.
And annexure J. While handing over the copy itself, the written portion was highly actually accepted.
Anyway, there is no office objection right now. Why are you challenging this?
Please. Petitioner husband Lakshmikant SP has died on, has expired on 22/11/2020. And a death certificate was issued on 9/12/2022. In that death certificate, there were 3 errors. Column number 5 is at annexure D, page number 11. Column number 5, the deceased mother's name. Correct name is Vijay Lakshmi, Your Lordship, but they have entered as Vijay Lakshmi Kant. And in column number 6, the deceased father's name is late P. Peddanna, but it has been entered as Rettanna. And deceased wife's name is Sai Lakshmi, but it has been entered as Peddanna, Your Lordship. And the petitioner has filed a representation on 9/1/2023, seeking for the petition.
Access notice for respond number 1, Shri Pawan Kumar access notice for respond number 2 to 4. If he copies to be furnished, he seeks for and is done 3 weeks time to make his submission. We list on 29/5. Venkatachalapati. What have you done?
My Lordship, in this matter, there is an appeal pending before the Chief Commissioner. Appeal number is 42/2020.
And counsel for respond number 1 submit that challenging the order under section 48(3) and appeal has been filed under section 253, which is pending before Chief Commissioner.
Before the Chief Commissioner, BBMP, under section.
Submission is placed on record. We list on 19/6.
Man notice, page number 53.
Plan sanction, huh?
Plan sanction.
Accepting the reasons stated in section 501 of 2020, dispensed with. AGA access notice for respond number 1 and 2, Pawan Kumar for 3 and 4, cable. Connect with so and so, relist on 2/6.
Appear for it. Within the nature of mandamus malady sought. The grievance of the petitioner malady is a society. Has formed a layout of sites. There is an encroachment that takes place, my lord, on the Raj Kalve, which, my lord, is forthcoming in annexure A, page number 12. These encroachments are not removed. Result of which, my lord, during the last monsoon, the entire layout, my lord, was inundated.
So late. We can't pass an extra. And AG accept notice to respond number 1 to 4. Valley Town Municipal.
Yes, Mahesh. Yes, Mahesh.
Yes, Mahesh for 5. Anekal Town.
Yogesh Naik.
Yogesh Naik for respond number 6. Council for the petition serve copies. Released on 22nd May.
Yes, we Prakash.
SP Prakash. Rajendra. Hairstyle. Shimoga Bhadravati,
AV Gangadharappa. AV Gangadharappa.
Devi Gangadharappa for respond number 2, AGF for respond number 1. Connect the above matter with so and so, relist on so and so. The order communication dated 2/11/2021, hearing number so and so at Annexure H, he states as the next date of hearing.
My lord, this matter may be called along with WP number 1362, but 2022.
Yes.
My lord, all the
Stay ಮಾಡಿದೀವಿ Mr. Rajan.
much obligation.
The allotment ತಾನೆ ಶಿವಮೊಗ್ಗ.
Allotment. My lord, ಉಳಿದ matter ಎಲ್ಲ 29 on 29/5, my lord. This
20.
matter may also be posted on 29/5, my
Yes.
lord.
29/5.
59.
Much obligation.
For the petition can be taken up on Thursday, my lord's faith. Filing an impleading application, we are challenging the sanction plan given to a party. That party is not being arrayed as a respondent.
How can you sanction the, how can you challenge this? For you to challenge?
To say dispute.
Not here.
And
we'll have to dismiss it on that ground. And AG accept notice for respond number 1, Shri Yogesh Naik. Notice for respond number 2 and 3. Kerera Gyara. Gautam Mullal accept notice for respond number 4. The petitioner is before this court seeking for the following release. Petitioners have challenged the final plan sanction issued by respond number 2 and 3 in favor of the promoter who is not in the party. Be that as it may, the challenge to a plan sanction cannot be made by way of a writ. There are other statutory remedies which are available to the petitioner. Reserving such liberty, the petition stands dismissed.
Similar to 56.
A1 so dispensed with same. Plan sanction na idu? Plan sanction.
For the petitioner, allowed the matter of ownership of a property which was purchased by an erstwhile partnership entity. Now, if I may bring your attention to page 11, there was a pursuant to a declaration of Hiba which was executed. The owner, the respondent number 3, relinquished their share, relinquished their undivided share of the property in favor of 4 persons, one of whom is the petitioner in this case. Pursuant thereto, the BBMP acknowledged the same and issued a Kata certificate in favor of 4 such persons. My lord, now in 2022, respondent number 3, having no ownership in the said property, requested for an endorsement of the same by respondent number 2, that's the assistant revenue officer, and the same was issued by the respondent number 2 by adding in the ownership column the name of respondent number 3 and unilaterally.
No notice, no nothing, software problem, we are correcting it by hand.
Yes, my lord, and this was provided as well. So
Pawan Kumar accepts notice to respond number 1 and 2, issue notice to respond number 3 to 9, returnable by 19/6, the operation of the endorsement dated 23/12/2022 of Annexure K, issued by respond number 2, is taken to the next date of hearing. Process fee and tax to be furnished by end of day tomorrow, hearing which will be model.
This matter, further interim relief is sought. I'm sorry, my apologies for intervening. A further interim relief is sought in terms of not changing the pursuant to this Kata. Whatever the ownership Kata as a result of the software problem which is highlighted, further transfer transactions are likely to take place in third party. Based on that,
If this is state, then there is no question.
but the state, this endorse only stayed in so far as the Kata which has been made in favor of Rafiq Ahmad. Now Rafiq Ahmad has sold the property to Rahmatullah Khan.
He has sold it already.
Yes, he has already sold, we have placed it on record.
I'm my sincere apology. I want to encourage my young.
Yes. It's not been entered in the name of respondent.
It is not entered, but now respondent
If
number
respondent
9,
number 2 is state, how will it be entered in the name of respondent?
but the obtaining of ours is that as we have.
Intention of the counsel for the petitioner is that since respondent number 2 has sold the property in favor of respondent number 9, maybe a further entry of Tata made in favor of respondent number 9. When annexure K has been stayed, question of making any further entries would not arise. We'll just so.
I appear for the petitioner, but seeking for a mandamus, my lord, to consider my representation at annexure K at page 41.
Also,
Whereunder, my lord,
you're asking for a certiorari also.
yes, certiorari, my lord, to quash annexure L. Lord, if mandamus is issued, my lord, to consider annexure K, and till then, my lord, annexure L implementation is, my lord, deferred.
Without quashing E, it cannot happen, Mr. Vexatious.
Annexure L is the demolition notice, second notice.
Sharanjit Shetty accepts notice for respondent number 1. PDO accept Matira, Mr. Shetty. 1 and 2. What is the order passed in WP?
My lord, that video that there's a panchayat was directed to take appropriate action to demolish the excess building if it is found to be so during the course of inspection. My lord, they find, my lord, pursuant to inspection that I had put up around 8 meters in excess. Then, my lord, I filed a writ petition. I took an undertaking to demolish and I sought for extended time. My lord will find that, my lord, order at page number 37.
And you still
subsequent to that, my lord, annexure H, I started demolishing. At that juncture, my lord, the entire building was under the threat of being collapsed. That is what the report says, engineer's report, my lord. Then I sought for compounding of the deviation by filing the representation. Without considering that representation at annexure K, my lord, annexure L is issued.
How much is the deviation?
My lord, it is within the permissible limit of the plan.
Where is the report?
My lord, if my lord looks into page number 21, my lord, I am permitted to put up construction to the extent of 298.4 square meters.
Yes. How much have you put up?
I have put up, my lord, 291.6 square meters. Only length exceeds.
Where is the report on the, is there an inspection report produced?
A notice is produced, my lord, at annexure E. There they say, ಕಟ್ಟಡದ ಉದ್ದ ನೀಲನಕಾಶೆಯಲ್ಲಿ ನೀಡಿದ ಉದ್ದಕ್ಕಿಂತ 8.2 ಮೀಟರ್ ಹೆಚ್ಚುವರಿಯಾಗಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. Then, my lord, I filed a representation as per annexure F. Sought for some time to remove the excess construction.
Are there setbacks left now, or have you used the entire property?
No, setback ella ide. It's only, both are my properties only, my lord. It's adjacent property belonging to me only.
The operation of the notice dated 22/11/2022 at annexure E 16/3/2023 at annexure L, insofar as demolition is concerned, is stated till the next date of hearing.
Grateful.
19/6.
Grateful, my lord.
Madam. Prevent illegal use of the residential site for the religious purpose, my lord. On the earlier occasion, my lord, the business for the residents of HPR layout has approached the Honorable Court
on the reason that the said construction made by the respondent number 5.
The public interest litigation is.
Hello?
Public interest litigation. You're not the neighbor.
I am the neighbor. I was the resident, my lord.
Yeah.
Earlier we
Been
filed
dinner
a
around.
public interest
So
litigation.
it's a public interest litigation.
Earlier we filed a PL model. It has been directed. It doesn't come under public
Really?
interest litigation. It is a private.
Where is that order?
869. Judge,
69.
69.
We are only seeking that order which has passed by the Honorable High Court has not been followed by the BBMP. Kindly to non-compliant order and not taking any steps with regard to illegal use of the structure.
You filed a contempt also.
Yes, my lord. In that context, my lord, there is the order directing the BBMP to monitor the construction. That is on page number 84, my lord, Annex M. The order portion.
In the writ petition, they did not say it's a private interest litigation come before.
Earlier, there is of the view that construction was only done with a non-sanction of plan. But in their affidavit, the respondent 5 came before the court and stated
There's
that.
a PIL was treated, orders were passed,
Yes, my lord.
a contempt was filed. You can't come before us now.
At that stage, we are of the view that it is a construction without a sanction plan. But afterwards, in the contempt petition, the respondent files a affidavit stating that the said sanction plan has been
The
made. for-
PIL. The PIL.
Yes,
So PIL like ಇನ್ನೊಂದ್ ಸತಿ ಯಾವಾಗ ಆಗ್ತೀರಾ ಹೇಳಿ?
as early as possible. My lord, previously PL file ಮಾಡಿದೀವಿ, but ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಇದಕ್ಕೆ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು.
Until earlier PIL has been introduced.
Not PL. At the time of filing, I'll approach ಮಾಡಿದಾಗ it doesn't come some PL, so private should be filed.
ಹೇಳಿದ್ದ
I'll connect it to PL.
After asking for some time, then it passes for the petitioner. Submits that the above matter may be treated as a PI as done in WP number 8753 of 2020. Held earlier. He seeks one is granted 3 weeks time to file second circuit. Anyway, after vacation, registry is direct.
There is conducting prayers in
Necessary.
so it's afraid of the situation, my lord.
From the Honorable Chief Justice and do it.
Is covered at page 60. The order and the challenge, my lords, directed the developer
Land bank.
at page 60. Because under one relinquishment deed, my lords,
Before a bench of it is GRJ. Adu first year with
same.
same party. Same one.
Transfer of Khata. Vendors enable Khata was there and also tax update tax are paid.
Pawan Kumar accepts notice for respondents. Sarvagidiya.
Copy.
The representation Tata.
Due to a long, so reasonable time will be given because after 13/4, the officers will be.
That will time. Petitioner is before this court seeking for the foreign release. So the petitioner is that though the petitioner purchased the property in survey number 33 measuring 30 guntas situated at Medrandi village, Yeshwanthpur, Bangalore, North Carolina. The data in respect thereof has not been made out in favor of the petitioner as such a representation is submitted on 27/2023 at Annexure G and H. 22/7/2000 16 and 27/3/2023 of Annexure D and H, which have not been considered. In view thereof, I pass the following. The petition is allowed and mandamus is issued directing the respondent to consider the requested representation within a period of 12 weeks from the 8 weeks from the date of receipt of copy.
Final hearing, serial number 67. K. Raghavendra Rao.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ Mr. Rao?
They have given the papers to not directed them to file
Location,
other documents.
Last location, this got directed to file an affidavit to show that whether the sites are in existence or not. I'm filing an affidavit, madam. Copies are also sent to the petitioner.
So this is the two layouts in between.
Yes, your lordship.
Your file matter.
Your file, madam. Because election detail issue ಅದಕ್ಕೋಸ್ಕರ Saturday secure ಮಾಡಿ ಅಲ್ಲ.
For respondent number 1 to 5 is filed.
ಅಲ್ಲ, I have for respondent number 6 ಬಿಡಿ.
I'm also filing.
It's filed. What are you filing?
Affidavit of the consent is as per the layout plan.
It's filed an affidavit of the assistant executive engineer. Enclosing there with the gazette notification, the layout plan. The form is taken on record. Counsel for the BDA, new respondent.
Phone number.
Fund number 6 was also filed. An affidavit of the assistant executive engineer. Enclosing there with
Resolution and original layout plan, approved layout plan.
the preliminary notification.
Final notification.
Final notification
Final notification. Only 4 acres, 23 guntas are required.
for acquisition of land.
And resolution reconvert the land to the society.
The resolution dated 23/7 before reconveying the land to an extent of 4 acres, 23 guntas. And approval. The agreement reconveyed as also the layout plan approval dated 18/1/85. And the handing over of the layout to the BBMP. The same is taken to record. Counsel for the petitioner seeks for and is granted 2 weeks' time to go through the same and make a submission. Released on 25/5.
I request that treated as part of.
And be prepared. You are chartered ಮೇಲೆ part of treatment.
The government advocate was directed to find out about the inquiry report.
The inquiry is complete and report.
Inquiry has been completed, my lords. Yet to receive the report, my lords. It's been communicated to the societies on 17/1, my lords. 17/1/23. It's been communicated, my lords, to the petitioners. Petitioner will also respond. My lords.
Report ready ಆಗಿದೆಯಾ?
Report ready is.
ಕೊಡಕ್ಕೆ ಏನಂತ
Receive the communication.
the election.
Adena registrar of societies in a cooperative registrar has been made the designated officer anta that is my instruction. So I don't know, I think he should be in a better.
Society is DR.
This is about registration of 2 societies in the same name. So this court directed an inquiry to be held and to give a report. So ಅದನ್ನ ರಿಟ್ petition ಅಲ್ಲೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ದವ್ರನ್ನ registrar of tax and registration ಅಂತ.
This is under the society's registration, not under cooperative.
Correct. ಅಲ್ಲ, ನಾವು registrar of cooperative societies is designated as a registrar of societies also on that is the
Institution of society.
That is the instructions that I have got.
Current CGP submit that the report is yet to be received. Since the officers were busy.
Report has furnished or sent to the petitioner as well as the rival society on January 2023 itself. About the communications.
And SCGP submits that a report has been sent to the petitioner and respond number.
The warring factions was 4 and 5. 4 and 5.
Petitioner and respond number. Petitioner respond number 4 and 5.
4 and 5. Yes.
Be that as it may, the same is not in compliance with the order dated 33/2023. The SCGP is directed to file the report before this court. Relist on 5/6.
71.
I request honorable court attention to order sheet dated 2/1/2023.
2/1/23.
2/1, January 2nd.
You are appearing in which matter, Mr. Shankar?
The direction to the BBMP.
You are appearing in which matter?
I'm appealing for petitioner's advocate.
In both the matters.
Yes, please.
71.1, I am appearing for petitioners.
You are appearing for blood.
Before that, to senior counsel. Kindly see, my lord, order sheet dated 16/1/2017. This honorable court was pleased to directed to inquire about whether relinquished deed has been executed or not. Kindly see for a moment, my lord, 16/1/2017 order of this court.
He has to go back 6 years. He wants to go back
No.
to 3 months.
By virtue of direction issued by this honorable court, BBMP has filed affidavit, appointed, my lord, the particular, my lord.
My friend has got the voice, but I have the right. My friend has merely the voice.
Great
I have the right.
to senior counsel, my lord.
Let me come in.
No, 16/1 salan notebody, sir. Then, my lord, with, I'll not go back for, my lord, subsequent orders, my lord, that we will.
This is the two senior advocates had to retire from the case.
10 senior, he is the 10th senior. With great respect to this honorable court, he is the 10th senior before this court.
Yes, I'm corrected.
Yes.
Only two.
No.
He has overtaken 10 senior advocates.
No, I have not overtaken, but time and then whenever
time is less than
they have changed senior counsel. Learned senior counsel Rajgopal has appeared. Learned senior counsel. No.
Is it necessary for disposal of the case?
No, I am not saying.
I think there should be a limit to misbehave also. Please do not disturb me. I am on my legs. Please sit down. Take your seat. The honorable court will give you a chance to answer. Please sit down.
Those are not the submissions to be made.
16/1.
No, there is no need to go to 16/1 in your 2/1.
There is senior counsel on his feet. There is senior counsel who is on his feet and who is making a submission.
Please.
I'm
sorry.
You cannot try to hijack the proceeding.
No, I'm bringing to the.
Why did they tell you?
You are not asked to bring anything to the notice of this. Once you are asked, you can.
Please.
Yes, Mr.
I apply my lord's consideration to order sheet dated 2/1/2023. Cabinet Council Sri Jagadishwara is directed to file an affidavit with regard to availability or otherwise of the record relating to the formation of road in the lands in question. The affidavit shall also indicate whether the owners of survey number 30/1, 30/2, 24/26 of Pogil village have relinquished their rights in favor of BBMP or not for the purpose of formation of road. I now request my lord's kind attention to the Google map. The map is very simple and this will be clear from this now. Reading out. This is
Google map we can refer to for.
While along with the affidavit described.
Shankar, we can't refer to Google map for these kind of matters.
This is the land in question.
Whether the road is being formed or not, cannot be referred to Google map.
I am explaining to your lordship what he has done. Will kindly level. He'll put your I filed along with 8/3/2017. The affidavit filed along. By number of times it has been considered.
You did not settle the matter amongst yourself, so we'll have to consider it.
ಇಲ್ಲಿ ತಮ್ಮ ಗಮನ ಇಲ್ಲಿ ತರ್ತೇನೆ. ಇಲ್ಲಿ ಸ್ವಲ್ಪ ಕಣ್ಣು ನೋಡ್ತಿರ್ತಾ ಇದ್ರೆ
Yes, what do you want us?
I mean, please, this, this is survey number 29 where my property is situated. It is landlocked. There is left side is the stormwater drain, right side the land. Well, this is the Illinois. This patch is the road to be found according to the direction of this honorable court. And respondent number 10 who has come voluntarily and record owns the rest of the land. He has been directed to surrender this land. That order become final. I'm only requesting you not to.
Number 3 owns the land.
Yeah, they survey number 30, 32. These are the survey numbers owned by applicant respondent number 7. The court order is it has already relinquished the land in favor of BBMP. What they are producing is in the revised plan. ನನ್ನ ಭೂಮಿಗೆ ಜಾಗ ಬಿಟ್ಟು ಅವ್ರು ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. My land remains to be landlocked. Whole thing as simple as this. I am requesting the honorable court to allow the road to be formed from out of the land relinquished by these neighboring owners. And they have relinquished, they have lost the right over it, and still they are obstructing in the formation of road. This is all my case.
Where is the relinquishment deed?
ಅದಕ್ಕೆ ಆ ವಿಷಯ ತಮಗೆ ಇನ್ನೊಂದು ಕೊಡ್ತೇನೆ. BBMP advocate has been directed to what steps they have taken to farm the road and whether this.
Where is the relinquishment deed?
Relinquishment deed ಇಲ್ಲ ಕಾರ್ಪೊರೇಷನ್ ರೆಕಾರ್ಡ್ ಇದೆ. ಅವ್ರು ಕಾರ್ಪೊರೇಷನ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಇದೆ.
Have you produced the relinquishment?
ಅವ್ರು ಕೊಡ್ಬೇಕು. BBMP direction ಕೊಟ್ಟರು.
Your relinquishment deed is not part of the record.
It's not filed by me. It's not filed by me. It's filed by him.
So relinquishment deed is not part of the records.
It is really. ಅದು registered instrument. That's also filed.
Who is relinquished what?
The survey number 34 to survey number more number. BBMP advocate must.
First, you know,
ಒಂದು ನಿಮಿಷ ಇದನ್ನ BBMP objections ತೋರಿಸ್ತೇನೆ. ಅದ್ರೊಳಗೆ ಅವ್ರೆಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಎಲ್ಲ ಹೀಗೆ BBMP objections ಕೊಡ್ತೀರಾ ಮೇಡಮ್? BBMP objections. Dated 11/1/2017. ನಮಗೆ ಅಲ್ಲ ಇದೆಯಾ ಅಥವಾ ಇಲ್ಲಿ statement of objection filed by BBMP on 11/1/2017 in paragraph 12, 13, 14 and 16. The matter is made clear. At the top, my lord asked relinquishment deed. They are available in the records, court records.
Said everything but not produced.
These are the release dates. They are available in the record. The connected.
By whom?
Yes, all.
Connected matter. Connected matter.
Page 60. Page 60. The release date is.
Then finally it boils down to 2/1/2023 order. If that is the case.
In our position is Annexure Z1.
Have you complied with this order, Mr. Nitish? 2/1/23? 2/1/2023 order here.
For us, your lordship may kindly turn to the order sheet dated 25/1/23. I filed an affidavit, my lordship, as per direction of some court.
25/1.
Yes, my lordship. Along with my affidavit, I also produced a sketch prepared by the concerned engineer along with ADLR.
This you filed on 25/1.
Yes, my lordship.
We have it here.
ಕೊಟ್ಟಿದೆ ಸರ್ ಕೊಟ್ಟಿದೆ ಒಂದು ಕೊಡ್ತೀನಿ ರಿಲ್ಯಾಕ್ಸ್ ಮಾಡ್ಕೊಡಿ ಇಟ್ಸ್ ಇವನ್ ಇಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಇಟ್ಸ್ ಕೊಡ್ತೀನಿ ಸರ್ ಕೊಡ್ತೀನಿ ಇಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಆನ್ 25/1/23 my lordship.
So you have the original file with you.
Yes, my lordship.
Have you given inspection to everybody? They had filed an affidavit, Mr.
I think copy somehow is not available.
It's been received by Mr. Harikrishna Alva's colleague.
But now, the advocate for respondent number 7 has filed a compromise petition asking us to sign, saying that he has released the land and it stopped.
That compromise petition has been filed to indicate the best efforts made by them to settle, which did not settle.
No, the reason is this. Survey number 29 ನಮಗೆ ಲ್ಯಾಂಡ್ ಕನೆಕ್ಷನ್ ಕೊಡು ಅಂತ ಅರ್ಜಿಯಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ, ಅದು ಕೊಡೋದಿಲ್ಲ. ಆ ಭೂಮಿ ನಾವೇ ಇಟ್ಕೊತೀವಿ, ನೀವು ಸಾಯಿರಿ. You suffer for the rest of your life as a landless, landlocked land.
We are saying that 23/1/23 has not been complied, it's been complied.
Yes.
And they have the original records available with them. Take an inspection of all of it so that you are clear as to what is available. And insofar as
So for us, relinquished deed in the concerned my lordship up to survey number 30/2, there is no relinquished deed executed by 7th respondent. There is amicable settlement proposed amicable settlement between the petitioner as well 7th respondent, 7th respondent, insofar as relinquished deed to be executed in favor of the corporation in respect of the report which was filed by me. Unless they.
What you do, Mr. Subhitra, is you produce the relinquishment deed.
No relinquished deed execute insofar that particular property is concerned.
ಬೇರೆ ಎಲ್ಲ ಯಾವ ಪ್ರಾಪರ್ಟಿ ಇದೆಯೋ
ಅದೆಲ್ಲ ಕೊಡ್ತೇನೆ.
Produce ಮಾಡಿ, because you are not produced it along with the objection. Also, you mark out the area relinquished in the revenue map to show where the lands have been relinquished and where the property of the petitioner and property of 7th respondent.
There is connection to my place.
Along with my affidavit, I filed the sketch also.
Sketch ಇಲ್ಲ ಅಲ್ಲಿ.
Sketch ಅಲ್ಲಿ close ಮಾಡಿದ್ದೇನೆ affidavit ಜೊತೆಲಿ. Affidavit ಜೊತೆಲಿ I filed a sketch along with the detailed sketch, my lordship. What is the relinquished deed and up to which extent the relinquished deed has been executed. There is a sketch, my lordship.
After appointment, only. Writ prayer is to direct me to execute relinquishment.
The yellow pursuit marked in the sketch, my lordship, is the disputed property. So that particular property has to be relinquished by 7th respondent, the respondent 1 to 3. That was the direction sought by this court before it's got by the petitioner.
No, the blue and green has been relinquished.
Relinquished.
Yellow has not been relinquished.
Yellow is not relinquished.
Yellow is linking my land.
The other blue and purple has been relinquished.
Relinquished.
Where is the land of the petitioner in this?
30/2 beyond that yellow line, yellow space.
So is it adjacent to the blue portion?
Settled and is mud road.
Is the petitioner's property adjacent to the blue portion?
Yes, my lords, up to 30/2. Up to 30/2. Yellow link ಮಾಡೋ ತನಕ ಇದೆ ರಿಲಿಕ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ.
Blue link ಆಗತ್ತಾ?
ಇದೆಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ಇದ್ರಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಇದ್ರಲ್ಲಿ ರಿಲಿಕ್ವಿಸ್ ಮಾಡಿದ್ದಾರೆ. So for yellow color is concerned,
private land.
ಯಾವ್ದೋ ಬೇರೆ ಸ್ಕೆಚ್ ಇದೆ ಇಲ್ಲ
ಎಲ್ಲ ಒಂದೇ ಸಬ್ ಸ್ಕೆಚ್ ಎಲ್ಲ ಒಂದೇ ಇದೆ.
ಇನ್ನೊಂದಿದೆ. ಅದು ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ ಆದ್ಮೇಲೆ.
So for the direction issued by this court to appoint the court commissioner with the physical measurement. ಆ measurement ಹೇಳಿದ್ರೆ this will tallies.
Where is the property of the petitioner here? So
yellow line ನಮಗೆ ಲಿಂಕ್ ಅದು.
It is 29 ಸರ್ವೆ ನಂಬರ್. ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅನ್ನು ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಮಾಡ್ಕೊಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇರೋದು.
Connecting to survey number 29.
where the respondent number 7 required to execute relinquishment deed as regard the yellow portion.
Yes, that is the crux of the case right now, my lordship. Seventh respondent has to execute the link within the yellow color is concerned.
As per your conditions.
Yes. Now,
No,
now
not
the
as
writ is
per
filed
that.
for mandatory writ of mandamus as against the
ಅದು ಇವ್ರು ಕೇಳ್ತಾ ಇರೋದು.
ಅವ್ರು ಕೇಳ್ತಾರೆ ಹೌದು ಹೌದು.
ನಿಮ್ ಪ್ರಕಾರ is there any condition imposed while sanctioning the plan to relinquish this portion of the land? Yellow
This particular property not been relinquished by the seventh respondent.
where they are required to relinquish.
ಅವ್ರು ಕೊಟ್ರೆ ನಾವು ಮಾಡ್ಬೋದು ಅಷ್ಟೇ.
Required,
ನನಗೆ
not required,
so far
not
as
required.
corporation is concerned, my lordship, if this particular property is not required for us because it is approved, there is no approved layout plan also. It's between the private party, they are claiming a right over the property in respect of the road is concerned. Unless, my lordship, they approach the BDA or any planning authority to get the approved layout plan and they execute relinquish in super CH-18 park and road. We are supposed to give up the amenities, my lordship. It's purely between the private parties.
So that we have no access.
You can't force somebody to give
Yes.
you.
I don't know, we have.
Unless the only right that you can have is the right of prescription, which you can do only in easement issue.
BBMP has directed them to relinquish this. That's an order.
Where is that direction?
That direction.
They're required to, that's what we are asking.
There is no direction. If there's no direction, I have no flex with that.
Where is that document? Relinquishment deed use ಮಾಡಿಲ್ಲ.
Day after tomorrow in the order scale. So for the production of the customer. I have understood, my lord. The my lord is pleased to narrow down the dispute and if there is a direction to form this road in this yellow portion, I have make a survey not. That's how.
First, you will have to establish whether they were required to relinquish it by an order of valid order passed by the corporation or any state government. Then we will come to Mr. Bhatt. Until then, we don't need to go to it.
They have their own documents to spell out my right, doesn't matter. I'll have to do it. Can I make one submission with great respect? Insofar as, my lord, direction sought. In the prayer itself, my lord, that they have sought the direction to relinquish. Insofar as, my lord, property which they are claiming from survey number 30/2 to 29. No relinquished deed has been executed and we have not, even layout has not been approved. Earlier, my lord, that insofar as our land is concerned, some portion relinquishment deed has been executed. Prior to that also, my lord, that we have entered into agreement with some private landowner by getting the property to formation of law. Subsequent to that, when this we have a please.
Petitioner. Sixth point is granted 2 days time to produce the direction issued by the BBMP. And the point number 7 was required to relinquish a portion of the land abutting the land of the petitioner for formation of the road. 20th in orders category. 20th at 2:30 p.m.
Yes.
Keshav Reddy, I'm appears for the petitioner released on 20th January, 20th June.
Short accommodation.
73 at the request of counsel for the petitioner released on 26th June. 26.
Yes, my lord, sir. On the last date of hearing, my lord, sir, the directed respondent number 1 and 2, my lords. Order of the Taluk Panchayat is under challenge, my lords, at Annexure C, my lords.
No notice was issued.
No notice issued. We have filed the appeal, my lords. And in that appeal, my lords, what is our prayer is not dealt with. And some other relief is given in favor of the respondent, my lords. I am having a business in the adjacent.
Annexure C is what you are challenging. Annexure C.
Annexure C, in that, my lords, I am challenging as per the license, my lords, at ink page 15, my lords, he is not leaving, fulfilling the conditions at ink page 15, my lords. Point number 5. ಕಟ್ಟಡ ರಚನೆಯ ಸಾರ್ವಜನಿಕ ಕಾಮಗಾರಿ ಇಲಾಖೆ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿದ್ದಲ್ಲಿ ರಸ್ತೆಯ ಮಧ್ಯಭಾಗದಿಂದ 25 ಮೀಟರ್ ಅಂತರವಿಟ್ಟು ಕಟ್ಟಡ ರಚಿಸುವುದು. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ 15 ಮೀಟರ್. At ink page 15, my lord. Annexure B.
Yes.
Point number 5, my lord.
Yes, point number 5.
ಕಟ್ಟಡ ರಚನೆಯ ಸಾರ್ವಜನಿಕ ಕಾಮಗಾರಿ ಇಲಾಖೆ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿದ್ದಲ್ಲಿ ರಸ್ತೆಯ ಮಧ್ಯಭಾಗದಿಂದ 25 ಮೀಟರ್ ಅಂತರವಿಟ್ಟು ಕಟ್ಟಡ ರಚಿಸುವುದು. ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಇತರ ರಸ್ತೆ ಮಧ್ಯಭಾಗದಿಂದ 15 ಮೀಟರ್ ಅಂತರ ಬಿಡುವುದು. Next page, my lords, 16. As per their own plan, my lords, they are not leaving 25 meters, my lords. From the national highway, they are leaving 14 meters, my lords. And they are digging the foundation adjacent to my land, my lords, where I am carrying out my business, my lords. For that, my lords, I have filed appeal before the Taluk Panchayat, and Taluk Panchayat passes an order stating that, my lords, OS number so and so is pending before the court, civil court, and construct the building by leaving 3 feet setback. Ink page 20. Take instruction. Third may copy today only.
Third, ಮುಂಚೆ ಹೇಳೋದು. That council for respondent number 1 and 2 seeks for and is granted 3 weeks time to make a submission as regards the distance of the subject property from the center of the national highway as also from the center of the state highway, which the property abuts. Released on 1st June.
75. The Manisha.
Lordship, I made an application for recall the order dated 5/7/22. It is not put up, my lord.
In 5/7 ಏನಾಯ್ತು? There's no representation, so can dismissed.
Against 3 and 5, it has been dismissed.
Against only R3 and 5.
R3 and 4 ನೀವು ಇದು ತಗೊಂಡಿಲ್ವಾ?
Steps has not been taken because my name has been shown differently, my lordship. Mahesh Appi and list of that is
Counsel for the petitioner submits that since his name was not properly shown in the clause list, he could not appear on the date on 5/7/2022 when this court dismissed the proceedings against respondent number 3 and 4. He submitted given he submitted it is on that background that IA 1 of 2023 has been filed for continuation delay of 252 days, and IA 2 of 2023 has been filed for recalling the order dated 5/7/2022. He submits that given a period of 2 days time,
I will take
necessary process fee and copies would be furnished in respect of respondent number 3 and 4. Subject to the condition that process fee and copies are furnished by end of day 20th April, the order dated 5/7/2022 is recalled. IA1 and IA2 of 2023 are allowed. Sorry, IA1 and IA2 of 2023 are allowed. The delay is condoned. The order dated 5/7/2022 is recalled. Registry is directed to issue notice to return number 3 and 4, returnable by 26/6.
Copy may be given to us.
Council.
Waiting for the petition to respond. Order in annexure A. Past
No objections filed.
Panchayat has filed the government will have to take action and other respondents have not filed.
Elections. And AGS submits that due to the impending elections, he could not get instructions to file his statement of objections. He submits that immediately after elections, the objections would be filed. Objections, if any, by 29, released on 1st June.
Serial number 80.
Matter, it is trade license. They are not running school there. The last time also I made the submission, serial number 80. They have given notice that we are not obtaining trade license.
None appears for the petition to, despite the order dated 33/2023, none appears for the petition today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed from the matter.
81.
81.
This matter, they have challenged the impleading application. They have filed an impleading application for CH-18. That was impleading.
Nobody has been appearing. Pending in the proceeding,
I could not get the status on it. Online is not coming.
None has been appearing for the petitioner on the last 5 occasions. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed and non-prosecuted. 83. Yes. Yes, Mr.
Petitioners, the owner of Schedule A property, which is
Good.
the owners of Schedule A property, which is about 62,000 square feet of vacant land, which was leased by the fourth respondent for a period of 60 years. By annexure A.
For a period of 60 years. For a period of 60 years.
Yes, this is for 30 years plus another 30 years.
That's 30 years.
Once the annexure A is for 30 years. The 30 years, during the 30 years period itself, the lease got forfeited, my lord, because of non-payment of rent. The fourth respondent put up a commercial complex and subleased it to various persons. In terms of section 112, subsection 2 of the Karnataka Municipal Corporations Act, an assessment was made on the fourth respondent for payment of property tax. And subsequently, my lord, another assessment was made in favor of the subtenants. My lord, in view of the non-payment of rent, the lease was terminated and the arbitral tribunal has given an award in favor of the petitioners, directing the fourth respondent to quit and deliver possession of the property together with the building.
Yes.
That thereafter, my lord, the eviction was taken out. Eviction by the execution proceedings. The subtenants appeared before the commercial court and they filed objections, saying that the termination of the lease by the petitioners are not binding on them. That their objections were overruled and they approved the honorable court in a commercial appeal unsuccessfully. And the matter took, my lord, reached the Supreme Court. Supreme Court has affirmed the judgment of this honorable court. Normally, it has been noticed, my lord, there is a huge arrears of tax, property tax, both from fourth respondent and his subtenancies.
Holders Kata was made out in the name of respondent number 4.
My lord, respondent number 4, yes, assessment has been made in the name of respondent number 4 and the subtenants, both. My lord, kindly see my rejoinder. My lord, before that, no, your lordship may turn to annexure G, my lord. At page 146. In response to my representation to the first respondent to collect the tax, so that tomorrow there will be no problem with my lord, for me to seek the change of khata or for redevelopment of the property. The response given by the fourth respondent is that he has given a list of subtenants, which your lordships will see at page number 147, 148. It runs up to 150, 151.
Yes.
The arrears are in the region of 4 crore 57 lakhs. And my lord, subsequent representations did not yield any response. Although, my lord, kindly see annexure J, my lord. The first respondent says that these khata holders have promised to pay and they have sought some time to make the payment. But nothing was forthcoming, my lord. Therefore, I was constrained to approach your lordship by this writ petition for a direction to recover the arrears of property tax from a fourth respondent and his subtenants. So the assessment has not been made on me.
This petition premature, Mr.
My lord, yes, I understand that because I know what your lordships, what is passing through your lordship's mind. I am not the assessee. In fact, no assessment has been made. There is an assessment made in respect of the land, I have paid the tax. In respect of the building, there is no assessment made on me. There is no doubt about it. And I think your lordships are suggesting that premature in the sense you are not in any way affected by this arrears.
Them first what they do and then they may come to you.
Yes, that is true.
That time you can challenge your liability. But
yeah,
as for a mandamus to collect it from them may not be.
From them, there is
the right till you.
It is their obligation to cover it from the assessees, from the khatidar. The 5th May, my lord, all the subtenants will have to vacate. The khata will have to be retransferred to my name of the entire property. And then, my lord, I may go for redevelopment of that. At that point of time, my lord, they should not be saying that, look here, you pay this arrears of 5 or 6 crores. That is my apprehension.
You will get a cause at that time. Apprehension cannot give you that cause now. We can direct this. You could have at the most challenged.
That is right. I appreciate that.
Which you are not.
What is the cause of action? And my lord, your lordship may also be think that I don't have the locus at the moment. Because the assessment has not been made on me.
There is no cause or locus.
Your lordship may observe that the assessment has been made on this, the fourth respondents and his subtenants, and not on the petitioners. And he has no cause of action. Your lordship may say that and.
The petitioner is before this court seeking for the following. Petitioners are the owners of
Schedule B property. Schedule A.
property bears municipal corporation number 15, 16, and 17 Cunningham Road, now known as Company House of Temple Road, Bangalore. Petitioner had leased out the property for a period of 30 years with a renewal clause of 30 years. They were respond number 4, who had put up construction thereon and subleased it to various other persons.
In pursuance of that, Schedule B property has been put up, my lord.
Various other persons. The construction put up is described in Schedule B to the petition. On certain violations of the terms of the lease, proceedings have been initiated. The lease, on violation of certain terms of the lease was terminated. Proceedings have been initiated by way of arbitration. The arbitral award has been passed in favor of the petitioner. Now the petitioner apprehending that on account of the petition, on account of respond number 4, and its subtenant not having paid the municipal taxes, the petitioner may be mulcted with the said liability before this court seeking the opposite relief. As on today, there is no assessment made in favor of against the petitioner, nor a direction or demand, nor a demand made against the petitioner for payment of any amounts. It would always be open to the respondent to initiate such proceedings against the assessee.
Not only assessment, because he being the owner, it is duty to pay the tax in respect of the property is concerned.
Unless the contract otherwise prescribes. Adu nodbekalla.
Section 112, madam, I got 2 statements of this.
Because we are not a party to the agreement between the petitioner as well as fourth respondent, we are not given any.
So you want to be party to all the leases?
Not that, my lordship, because your lordship can appreciate.
If you make that submission, we'll have to say that.
They have recognized the lease. They have recognized the lease.
You have issued the plan sanction.
Assessment is made. Assessment is made in respect of the shops is concerned. But no kata has been affected either in the name of the IDBA project.
Insofar as the construction is put up, in terms of section 112, it is the landowner who is responsible.
Yes.
Unless otherwise contracted. That contract you have recognized.
They have recognized.
So you have to go against them. Not against.
Ultimately, my lordship, in case, if the fourth respondent is not available, from whom you have to collect the tax?
You have to bring his property for auction and everything.
Okay, if you don't have a property, according to the petition council submission, you don't have a property, from whom you have to collect the tax money?
Proceed against the directors. Why are you sitting quiet till now?
Because virtually, my lordship, the property belongs to the petitioner.
You can't be sitting quiet, Mr. Jagdish. ಯಾವಾಗಲಿಂದ ಸುಮ್ಮನೆ ಕೂತಿವಿ 2 ವರ್ಷದಿಂದ 3 ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಕೂತಿವಿ.
ಇಲ್ಲ ನೋಟಿಸ್ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಮೇಲೆ
ಕೆಲವರು ರೆಂಟ್ ಕೊಡ ಟ್ಯಾಕ್ಸ್ ಕಟ್ತಾರೆ, ಕೆಲವರು ಕಟ್ಟೋದಿಲ್ಲ. Ultimately is getting rents out of the income. The petitioner is getting rent out of him.
Only in the event of any demand being made against the petitioner would have a right to seek for any release before this court. In that view of the matter, there are no grounds made out in the above petition reserving liberty as a process. Petition stands before.
Two thirty matters. 5 matters. The common order tax.
Adjourn all the matters. We have some mood matters.
The one matter which has been passed over to get an instruction.
Right.
My lord, he said he has removed his portion of the floor with an intention to put a pillar and to slab, cement slab. He did not touch the side where the roof is. My lord,
we'll have it tomorrow.
Yes, please.
Tomorrow.
Lord, serial number 91-2 in order needs to be extended.
We'll adjourn all the matters and give dates. 334 to 87. 89 to 94. 19th June. 95, 96, 98, 99 to 104. 23rd June. 104 to 111. 27 June.
109.
and 12 to 120, 28 June, and 21 to 23, 25, 27, 29, 27 June, 130 to 136, 28 June.
Serial number 132, my lord.
He told you it won't reach.
But I wouldn't have trouble, my lord, but for the time and covering of my head.
134.
32.
134 relist on 20th at 2:30 p.m. Wait. Just will in the birthday one ನಿಮಿಷ ಇದ್ರಿ ನೀವು ಮದುವೆಯಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಇಲ್ಲಿ ಬಂದು ಏನ್ ಹೇಳಿ ಮಾಡ್ಕೊಳ್ಳಿ 84, 85, 90 same day.
And 2.1 model.
All entry models will be extended. Any mentioning? You extend all entry models will be extended. Kalbaga Kali Agakadri.
132.
What's the movement? Zero 4. 5th June.
2.1, then the remote status.
Extend again.
122 mile. And I would before because extreme emergency. We are filed impeding application. So I may be cut.
Impeding application.
Permit to take and summons for the impeding application.
My lord, 90. I am responding. My name is shown as Akash Kumar Gowda, but it is Akash Kumar Gowda.
That's good. So on.
132, my lord. 132, my lord. Your worship may kindly have it.
Yeah, your last name. Because last you are entering too much.
132. Worship may have it on May 26th.
132. 132, 25th May. ನಿಮ್ದಿಲ್ಲ.
Serial number 136. ಇದು ಮೊನ್ನೆ ಬಂದಿತ್ತು ಆ ಲಾರ್ಡ್ಶಿಪ್ ಐ ಅಂಡರ್ಟೇಕನ್ ಟು ವಿಡ್ರಾ ದಿಸ್ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ.
ಸೊ ಇದು ಹೋಗ
ಅಲ್ಲ ವಿಡ್ರಾ ಮಾಡಿದ್ದೀನಿ ರಿಟ್ ಪಿಟಿಷನ್ ಉಳಿಯುತ್ತೆ.
Lord, serial number 125. It is with regard to the issuance of my lord trade license to run petrol bunk.
ಯಾವುದು serial number?
Serial number 125, my lord. It will be taken up on 20th, my lord, at 2:30. My lord, the entire infrastructure is provided, my lord, trade license.
125, 20th at 2:30.
Not 108 minutes. There is some urgency minutes. 108. There is a illegal 108 minutes.
108. Yes.
There is a milk parlor minutes that is constructed illegally. Because it is right in front of my property. Even on the last date, it had come up. There is some urgency in this.
Again, it will come up. Again, the same thing will happen.
I request for tomorrow or day after.
You have no access to the property. You have no access to your property.
I have no access. The whole easement rights have been locked. Can't get in.
So where are you staying?
Because I am taking a different route.
108, 20th at 2:30 p.m.
121. 121. Construction is stopped on the ground that there is no sanction plan. We have produced a sanction plan. And I have not been heard.
Pawan Kumar.
Pawan Kumar.
121 plan sanction is there.
There is a sanction plan. If there is a deviation, let them hear me and then pass an order, provisional order.
Order of this honorable court only the construction was stayed. Petitioner has alleged that they are given representation to BBMP. Then action was taken under section 248.
Let them take action.
But plan sanction is there.
Yes, transaction is there.
121 released on 20th at 2:30 p.m. Yes.
The 230, there may be a doubt. 19.
Is the only option that you have.
19. This is the only argument. I don't have any argument except your lordship.
20th afternoon ಇರಲ್ಲ ಹಾಗಾದ್ರೆ.
ಅದೇ ಇರಲ್ಲ ಅಂತ ನಮಗೆ ಮೆಸೇಜ್. 19th 230.
19th 20th ಅಲ್ಲ 19th.
136 ಏನ್ ಆರ್ಡರ್
136 ಏನೋ ಮಾಡಿ 36.
28.
Some urgency because the ban has been withdrawn, my lord. So suit has been
36 2nd June.
Serial number 129, my lord. That site ಮುಂದೆ ಫುಟ್ಪಾತ್ ಇದೆ my lord. ಮುಂದೆ ನಂದಿನಿ ಬೂತ್ ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾನು ಜಮೀನ್ಗೆ ಹೋಗೋದು, ನನ್ನ ಸೈಟ್ಗೆ ಹೋಗೋದಕ್ಕೆ ಆಕ್ಸಿಸ್ ರೋಡ್ ಆಕ್ಸಿಸ್ ಇಲ್ಲ. ಅರ್ಜೆನ್ಸಿ
ಸೈಟ್ಗ ಜಮೀನ್ಗ
ಸೈಟ್ ಸ್ವಾಮಿ.
ಜಮೀನ್ ಅಂದ್ರೆ ಜಾಗ ಇರೋದು ಪಾರ್ಲರ್
ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾನು ಜಮೀನ್ಗೆ ಹೋಗೋದಕ್ಕೆ
ಜಮೀನ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಬೇಡ.
ಸೈಟ್ ಸ್ವಾಮಿ. ನಂದಿನಿ ಬೂತು ಇದೆಲ್ಲ ಮರಗಳೆಲ್ಲ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ ನಾನು ಲೇಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಮೇಲ್ ರೇಪ್ ಕೇಸ್ ಕೊಡ್ತೀನಿ ಮತ್ತೆ ರಿಟರ್ನ್ ಮಾಡ್ತೀನಿ ಅಂತ ನಾವು ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ. 2017 ಇಂದ
482 ಹಾಕೊಂಡ್ ಬನ್ನಿ.
ಪ್ಲೀಸ್ ಮೈ
129 19/230 ತಗೊಳ್ಳಿ. End of
120.
ಅದೇನ ಆಯ್ತು.
My lord, 2:11 morning, my lord, this honorable court passed an order allowing the petitions of the, 5 more petitions, the number quoted in, my lord.
Come whenever.
My lord, the petitioner is the same, my lord.
Yes, no, it can't come.
My lord, serial number
permission, serial number 91.
ಎಲ್ಲ ಡೇಟ್ ಕೊಟ್ಟಾಗಿದೆ.
Serial number 120, petition is unable to send the states. Really, but 500 plots has been held up.
There's no time, Mr. Counsel, and now Mr. Lakshman gave us one more half day. He took away from us.
Petitioner has been unable to sell the sites.
Half day nu hoytu ಇನ್ನೇನಿಲ್ಲ.
Really, but 500 plots has been struck, my lord, because of the endorsement given by the town planning authority. My lord, at 2:7, my lord. The honorable court had passed an order combining all the 5 matters, my lord. Morning, the one matter was allowed, allowing annexure rate to be quashed.
Those are not listed today. We can't pass order. When they are listed, make a submission.
Oh, bless.
Yes, Mr. Girisha.
My lord, that's the.
ನೀವು ಮೂವ್ ಮಾಡಿರೋದ?
ಹೌದು, my lord.
How did you move this?
My lord, morning, this.
You can't move these kind of matters at the end of the list. I think 1, 2 and 2.1 are the same.
2.11, my lord. 2.1, 6113 of 2000.
6087.
6087, my lord.
6087 same as 2. 6260.
Yes, my lord. 6260.
Same as 2. And 6360.
6360, my lord. 6369, my lord.
6360 delink and relist on 12th. 6369 is not here.
087.
6167.
Yes, my lord. 616.
Same as 2. 6369 same as 2.
6353.
That's 3.
53, my lord.
It is not here.
Oh, bless. Serial number 100. We'll take one chance.
ಗುರುವಾರ ಇಲ್ಲ ಇವಾಗ. ನಾವು ಕೇಳಿ ಲಕ್ಷ್ಮಣ ಅವ್ರಿಗೆ ಬ್ಲೇಮ್ ಮಾಡಿದ್ವಿ.
ಡೇಟ್ ಕೊಟ್ರೆ ಏನ್ ಮಾಡೋದು? ಟ್ಯಾಕ್ಸ್ ಮಾಡ್ತಾ ಮೇಡಮ್ ಅವ್ ನಾನು ಚೇಂಜ್ ಮಾಡೋಣ. ನಾನು ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದೆ ಬೇರೆ ಅಂತ ಹೇಳಿ ನಾವು
ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಮೇಡಮ್? 19th.
121 to 30. ಅದೇ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಮೇಡಮ್?
22 and 23.
130 ಮಾಡ್ತಾ ಇದ್ದೀನಿ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87
Yes, sorry.
No, 1 or 2. 120. 122.
Madam, 91 ಯಾವ ಡೇಟ್ ನೋಡಿ?
123 ನೋಡಿ.
Madam, 91.
123.
Madam, 110, 116. Madam, 110, 116.
ಸ್ವಲ್ಪ ಇಲ್ಲಿ ಹಾಕ್ತೀರಾ?
160.
ಏನಾಗಿದೆ? 330 ಗೆ ಅನ್ಸುತ್ತೆ.
116.
ಮೇಡಮ್ ಮೇಡಮ್
Sorry, sorry. You all
ಒಂದ್ ಮಿನಿಟ್ ಕೂತ್ಕೊಳ್ಳ ಬನ್ನಿ. ಕೋರ್ಟ್ ಇದ್ರಲ್ಲಿ ಇದ್ದೇವೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಸರ್ವರೇ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ ಮೇಡಮ್? ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಯಾವ ಡೇಟ್ ಹೋಗಿದೆ?
ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗುತ್ತದೆ ಅಂತ ಈ ಎಂತದ್ದು ಯೂಟ್ಯೂಬ್ನು ಇದ್ರದ್ದು ಏನು ಹ್ಯಾಂಗ್ ಆಗಿ. ಹೌದು
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 87 ಯಾವ ಡೇಟ್?
ಕೋರ್ಟ್ ಆಫೀಸರ್, ಏನೋ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗುತ್ತೆ.